If I could have everybody's attention, please. If I could have everybody's attention, please. I've been asked to read the following before we begin. It's the County Non-Discrimination and Accessibility Notice. Tippecanoe County does not discriminate on the basis of race, color, national origin, religion, sex, age, marital status, disability, or veteran status. If you need a reasonable accommodation, including auxiliary aids or language assistance to participate in this public meeting, please contact the County ADA Title VI Coordinator, Paula Bennett. I believe she is here. But you can inquire at the staff desk, and hopefully that'll take care of anybody with any hearing or other needs of other accommodations.
Yeah, you might try eating the mic a little bit more.
Okay. If anybody needs any auxiliary aids or language assistance to participate, please see the staff desk. Or if you need any other accommodations for the meeting. Thank you. Everybody ready? I will call to order the August 27th, 2025 Area Board of Zoning Appeals of Tippecanoe County meeting. First item on the agenda is the roll call.
Steve Clevenger.
Present.
Gary Schroeder.
Present.
Tim Vanderplaats.
Present.
Robert Novak.
Present.
Brad Halberg.
Present.
Ed Butz.
Present.
Rabita Rajkanikar. Present. Quorum present.
Thank you. We have everybody on the board here today. Thank you all for coming. Next item is the approval of the minutes.
I move to approve the minutes from the July 23rd, 2025 ABZA public hearing as submitted.
A second.
Have a motion and a second. Any comments or corrections? Hearing none, all in favor? Aye. Opposed? Motion carries. New business.
I believe the petitioner for BZA 2199 is requested to be moved to the end of the agenda. So I believe this board would have to make that happen. The other cases are ready to go with the exception of, we are good. The other cases are ready to go in advance of that.
With the exception of the two that are marked so on the agenda.
Yes, we have one continuance, number 3, that's BZA 2204, being continued to the September meeting. And then BZA 2209 has been withdrawn by the petitioner.
Okay. Thank you. Continuance is actually after the... I would first like to discuss the determination for hearing for the Rainbow Trout Solar Farm case, the BZA 2199. And yeah, we can do that.
Let's just wait until we
Let's
get
wait.
to that one.
Okay. We will wait on the procedure till we get to that case. I'd like to go ahead and, for the other cases, which will be very similar to what the Rainbow Trout will be as well, we'll go ahead and read those procedures. So I'll go ahead and first take the continuance. $22, write down. Go ahead, write down here. Oh, go ahead and do the public hearing motion. I'm sorry.
All right. I move that there be incorporated into the public hearing portion of each application to be heard this evening and to become part of evidence at such hearing, the Unified Zoning Ordinance, the Unified Subdivision Ordinance, the Comprehensive Plan, the bylaws of the Area Board of Zoning Appeals, the application and all documents filed therewith, the staff report and recommendation on the applications to be heard this evening, and responses from the checkpoint agencies.
Second.
Have a motion and a second. All in favor, say aye.
Aye.
Aye. Opposed? That motion carries.
I move to continue BZA 2204 Select Towers 2 LLC to the September 24th ABZA public hearing.
I second.
Have a motion and a second. All in favor?
Aye.
See if that will, okay. All in favor, say aye. Aye. I missed
Gotcha.
that. And try and speak up in your microphone, because I guess it's very hard to hear with all the people in the room. So I will try and speak as loud as I can into the microphone. So if you're here for BZA 2204 Select Towers 2 LLC, that will be heard next month on September 24th at that Area Board of Zoning Appeals meeting. There's also one case, BZA 2209 Jason T. Myers, that has been withdrawn and will not be heard. I would now like a motion to move BZA 2199 Rainbow Trout Solar to the last case on the agenda.
I move to move BZA 2199 Rainbow Trout Solar to the end of the agenda.
For the last item.
To the
or the
last item on the
case
agenda.
Yeah.
I second.
Any discussion? All in favor?
Aye.
So the Rainbow Trout Solar will be held as the last item on, or the last case of the evening on the agenda. I will now go through the procedures for the meeting tonight. Each case will be heard following a motion and a second from the board. We will ask the staff to report on its findings. Following the staff report, we will ask the petitioner to present his or her case, after which anyone wishing to support the petitioner's request for a variance or special exception will be asked to come forward. After hearing from the petitioner and those speaking on his or her behalf, we will ask those speaking against the petition to present their arguments. The petitioner will then be allowed to rebut arguments raised by those in opposition to his or her petition. Following the rebuttal, the board may wish to ask questions of the petitioner, supporters, and opponents of the petition, or of the staff. The staff will have the opportunity at this time to make any necessary clarifying comments. We will then vote by use of a prescribed ballot. 4 votes are necessary to make any decision. In the absence of 4 votes, either for or against, the petition is automatically continued to the next meeting. Please observe the following guidelines for the sake of time and fairness to all. State your name and address for the record before you speak. Limit your remarks to 5 minutes or less. Do not repeat arguments that have been brought up by others. Remember that all visual aids used to support your arguments will remain the property of the board. Cell phones must be turned off while the meeting is in session. Please step out of the room before using your cell phone. And with that in mind, we'll have the first case.
I move to hear and vote on BZA 2203 Paul Luttrell. Petitioner and owner requests a variance to reduce the front south setback from the required 25 feet to 10 feet for a new shed. The R1 zone property is Lot 13 of the Cedar Hollow subdivision, commonly known as 200 Cedar Hollow Court, West Lafayette, Wabash 8, Northwest 23-4, and 6, Northwest 23-4. UZO 2-1-7, continued from the July 23rd, 2025 ABZA hearing due to inclusive vote.
Second.
I have a motion and a second, and we'll hear from staff, please. Nathan?
Thank you. Nathan McBurnett, APC staff. We're out here at the corner of Soldiers Home Road and Cedar Hollow Court. As Robert said, this case was continued from last month because of a tied vote, essentially. So there is nothing that has changed substantially about the petition. I think that there's been some new materials that were submitted and are being distributed by the petitioner. I'll have him speak more to that. Just as a refresher, it's for a shed in the front yard, reducing that front setback from 25 to 10 feet. I guess it's relevant to note that that front setback area is coterminous with the utility easement, which staff would advise, to stay clear of utility easements, but that is not really a zoning issue. Again, here's the property, some pictures of the property. The sort of platform for the foundation that you can see here has already been put in place. This is not something that requires a permit, so it's not the foundation itself, it's just the platform for that foundation. And some pictures of the backyard. This property is surrounded by a pretty steep ravine that is slowly eating away at the backyard. And so while there is a pretty wide backyard to put a shed, there's evidence that suggests that the ground is not stable, and that shed, would probably eventually have to be moved at some point or it'd fall into the ravine. So with that said, staff is recommending denial in this case simply because it doesn't pass the hardship test. A tool shed is not something that's required in order for this to be used residentially by the zoning district. So that is staff's reasoning. Happy to answer any questions. Thanks.
Thank you. Petitioner, his or her representative.
Paul Luttrell, 200 Cedar Hollow Court. I'm the owner and resident of the house. We kind of talked about how the proposed site is probably the best place to put a shed on the property. And there was some opposition in the last meeting that was generally concerned with aesthetics, the aesthetics of the front yard after the building is put in. So I distributed the request for the building permit so that you can see the intent. The request was actually put in long before I even realized that I needed a variance. The value of the building includes materials only because all of the assembly is going to be done by myself. And there are pictures of what it should look like in there as well. I think that's really all I have.
Hey, thank you. Anyone wishing to speak in favor of the petition? And if you are not the petitioner, if you speak in favor or in opposition, we do ask that you sign in after you speak at the staff table, please.
Fair enough. I'm Dave Glossbach. I live at 100 Reba Drive, across the road from Paul's property. As a neighbor, I've been there for over 30 years. Quick story, I promise. When my wife and I moved in there way back then with our 3 little girls, it was an aging neighborhood. Reba, who the name she was named for, was still with us. Dr. Britt was there, the POS. But when we came in, the neighborhood was welcome and friendly, and they let the little girls probably get away with far too much, but they were glad to see little kids. But the long and the short of it is, those folks have all passed away. The neighborhood is aging, it's turning, and that happens. But that also means that tastes will change, and applications will be different from person to person. Now, I do know in conversation from the previous meeting, the original real rub on this was the fact that Paul and his wife put a garden in front of their house. And that, set some people wrong, and that's okay. I know I have gardens all around my property. My house is completely surrounded. It is beautiful 6 months out of the year. When you get through the gray cloudy days of November and December and January and February, and the crocuses start to come and the new life comes to pass, it is gorgeous, and it's gorgeous right now. I'll brag about it. My wife works very hard. But I also know in a few months, it will all be dying, and it won't be pretty. You just have to remember what it's like. Paul's garden is much the same. They've planted a vegetable garden, and they've planted flowers to beautify it, as well as to draw the insects that love to feed on them, and that's cool. Now, in the 30 years I've been there, I've never seen anybody make as much improvements to a property as Paul and his family has done to that house. It was fallen into a great deal of neglected maintenance. They spent a great deal of time and money totally modernizing the exterior of the house, fixing the deck so it's livable, and all they've done to the property. And I'm absolutely sure that they will continue with that same high standard of construction that they do with the rest of their property. I see that degree of pride, that degree of stewardship that you want your neighbors to have. And looking at it, it's a difficult property to work with, no doubt about it, with the whole ravine and all that. But as far as safety goes, it's not an issue from the curb and pulling out onto the road. As a matter of fact, Paul takes a great deal of time to cut the trees and branches back and all that, so you have visibility, so people aren't dying trying to pull onto Soldier Stone Road. And and it's their property. And for that, basically, I'm pro allowing this construction to continue.
Thank you. Anyone else wishing to speak in favor of the petition? Hearing none. Anyone in opposition to the petition? Hearing none. Questions from the board? Go ahead, Robert.
I have a question for staff. If this is approved, while the current owner seems, the neighbors are happy with him and how he cares for his house, when the day comes that he sells that home, the shed remains, the shed will go ahead and be able to still be there, and the next owner, depending upon what they want to do out of a shed in the front yard, if they want to fix lawnmowers or motorbikes or anything, that shed will still stay even after the property is transferred. Is that correct?
Yeah, the variance runs with the property, so it would stay. As for how that shed is used, whether it's used for a business, that's a different matter. The variance wouldn't permit any sort of business use out of that shed.
Thank you.
Any other questions or comments from the board? Gary?
We have heard this twice. It does seem like a unique site with a ravine behind it, and seems like this shed would not be too intrusive to the neighborhood and would serve the homeowner. So I'm in favor of it.
Thank you. Any other comments? Hearing none, we've got a ballot.
Seven ballots cast, 6 in favor, 1 against.
That variance has been granted, and we'll hear our next case, please.
I move to hear and vote on BZA 2205, a company LLC. Petitioner, with consent of owner Stewart Cooperative Association and represented by Kevin J. Riley of RTS Law, requests the following variances for the expansion of a cooperative student housing facility in an R3U zone. 1, to increase the maximum building height from 35 feet, 37 feet per UZO 4-5-1C to 42 feet, UZO 2-9-11. Number 2, to reduce the minimum required parking from 57 spaces to 22 spaces, UZO 2-9-12. Number 3, to eliminate the required 5-foot no parking setback along the north and south side lot lines, UZO 4-4-6E. The property is Calkins First Edition, lots 21, 22, and 23, commonly known as 800 Northwestern Avenue, West Lafayette, Wabash 18, Southeast 23-4.
I second.
We have a motion and a second, and we'll hear from staff, please. Nathan?
All right, we're right here at the corner of Dodge Street and Northwestern Avenue across from Mackey Arena. This property is zoned R3U as of the past month, so you heard APC rather heard the rezone request. It used to be R2U, so it was legally non-conforming, and they just became conforming so that they can make these requests for an addition. So we've got 3 variances. Here's a close-up of the property. Just for some reference, since it's referenced a lot in the staff report, the rear lot line is to the east. So there's a tree line there to the east bordering that other residential property. That's the rear lot line making Northwestern the front. And then the north and south, obviously the sides. Some snapshots of the property currently. This is from that south lot line, so a side lot line, but the house currently kind of fronts on it, or it appears to front on it anyway. That's the existing parking lot where the proposed addition is going to sort of be. And then some rear shots of the property. This is the public alleyway that runs along the north side of the property, currently being used for parking. It's pretty parked out right now. Just a view of the elevation shot. This shows the addition there on the right-hand side, added onto the house. It'll be taller, shorter than the chimney, but taller than the actual structure. And then the site plan. So just running through each of these variances one by one. The first one, we have a height request. So the note in the staff report about the 37 feet per UZO 451C, that provision is basically the minimum exceeding setback provision. So for every 1 foot of setback that the addition or proposed conditions exceed, they get 2 additional feet in height. So they're 1 foot and 6 inches over the minimum setback, meaning they get 2 additional feet of height. So the standard would be 37 feet rather than the 35 feet per the zone. They're requesting 42 feet in height. For the height variance, the staff reviewing all of the petitioner's materials, it appears that the building is kind of being built up so high because of the common space and the study spaces that are being incorporated on the first 2 floors. So it'll be 3 total floors. The petitioner can speak more to the interior arrangement, but there's a copious amount of study space and common space that appears to be kind of making this need to be higher than the standard. Moving into the tests, specifically focusing on test 4 and 5, staff is not recommending approval on this variance request because the conditions of the property are common among R3U zone properties. It's a square lot. It's generally the same size as other R3U zoned lots with similar uses. So there's really nothing sticking out about the property that makes it an uncommon circumstance. And then the hardship test, test 5, staff was not able to identify a hardship. Again, it seems that the height request is being made because of the amount of common space and study space that's being incorporated into the first 2 floors. And while the residents would probably appreciate that, is not something that's required per the zone for it to be used residentially. So for those reasons, staff is recommending denial. One way that the petitioner could meet the height standard is by increasing the setback on the south or rear, rather the rear property line to 4 feet from the 1 foot, which would give them that additional height allowance per 451C, UZO per 451C. Moving on to the second variance request. This is the parking reduction, the total parking reduction. So the petitioner's going to be increasing the total bed count on the property from 33 to 76 spaces, which would require a total of 57 automobile parking spaces and then 57 bicycle parking spaces as well. The proposed automobile parking area, which you can see on the site plan, is along the south property line and along the north property line as well. Includes a total of 22 automobile spaces. So it's a pretty significant reduction. 20 of them are standard spaces. We have 2 tandem spaces on the northeast side and then 1 accessible parking space. The parking standard would require a total of 3 accessible parking spaces. So this is reducing the total parking spaces and those required accessible spaces as well. Moving into the tests again, staff again there's no feature of the property that is uncommon for R3U zoned properties. And again, it doesn't pass the hardship test. The R3U zoning standards do not accommodate an expansion of this scale with this site plan, indicating the property is too small for the intensity of the desired use. It is a lot of parking spaces required, and it is close to campus, which is worth noting. But there are similar examples in other parts of the city for similar uses. I think the one I found is Alpha Omicron Pi is a fraternity on the other side of town that has actually integrated parking into the structure. So that is an option that's available here as well that's not being used. Moving into variance 3, this is the no parking setback variance. So along the entire perimeter of the property, there is a 5-foot no parking setback. And basically 14 total spaces are going to encroach on that no parking setback. All the spaces on the north side, forgot I have my clicker here, this is new. So all of these spaces on the north side and including one here on the south side are all encroaching in that 5-foot no parking setback. Per the new Chauncey neighborhood plan, which this property is in, it's on the very edge, the southern edge of the new Chauncey neighborhood. The plan calls for properties that are on a public alley to use that portion of the property that abuts the alley for parking. So part of this site plan actually is in conformance with the new Chauncey neighborhood plan. Unfortunately, the reason why it calls for that is so that that decreases the property's vehicular disposition along the frontage or the part that fronts on a street. And so along the southern portion of the property, we obviously have parking right there along the street, which is not in conformance with the new Chauncey neighborhood plan. And moving into the tests, again, this is a situation that is not uncommon for properties in the R3U zone, and staff does not believe that it passes the hardship test. Again, the scale of the addition here is probably a little bit too large for this property, and there are ways to accommodate the needed parking. So staff is recommending denial on all 3 variances.
Thank you. Petitioner, his or her representative.
All right, good evening, Kevin Riley, representative for the petitioner, Company LLC. I'm with RTS Law. A company is the owner's representative for this project. Property sits at 800 Northwestern, just across from Mackey Arena, and it currently contains an approximately 100-year-old building that is currently home to the Stewart Cooperative. Property, as Nathan mentioned, was rezoned recently. Project has also been in front of the Joint Board, which is a group of West Lafayette and Purdue representatives who evaluate the project. The variances are needed so that Stewart can build an expansion that is ADA compliant and that addresses some current emergency exit and fire prevention concerns. Our only option, or the petitioner's only option for making the premises ADA compliant, is to rely on these variances or tear down the building and build a new ADA compliant building. I think you have received, or hopefully been passed around, we've got some letters from the city of West Lafayette, Purdue University, and the Historic Preservation Commission, who are all in favor of these variances, and none of them want to see this building torn down, and frankly, we don't want to see it torn down either. It's, I think, important to note that it would actually be cheaper to tear down the building than try to retrofit the existing one. So these requests certainly aren't based on a desire to increase or decrease the cost of the project, I should say. Before I turn it over to Anna Goodman with KJG to address some of the more technical reasons that support the variance, I wanted to address a couple of comments in the staff report. First comment being that the additional height is to accommodate petitioner's desire to include a liberal amount of study and common space for the residents. That's not an accurate statement. That's not at all why it was designed that way. The height is to accommodate the ADA improvements or features in the fire suppression features. As a result, we had some extra space on the ground floor, and rather than just let it sit empty, we designed it to have study space and common area. So that is the reason it's there. The residents aren't demanding more study space or common area. It's strictly a result of how the building has to be designed in order to accommodate ADA needs. With respect to parking, we have attempted to find some off-site parking, have not been able to do that yet. We will continue to make efforts in that regard. The petitioners worked through nearly 24 site designs, to maximize parking, one of which included parking below ground. That option, due to the depth, doesn't result in any measurable increase in the amount of parking. So making parking apart, incorporating it into the structure is not feasible for this site. I would note that Stewart has a parking policy in place that we think helps alleviate and avoid these issues. The policy prohibits the residents of the co-op from having a car on campus unless they have a designated parking spot on this site, or they can prove through documentation that they have secured off-site parking. So, and there are any violation of that rule exposes those residents to certain increased chores and ultimately eviction if they refuse to comply. So, to our knowledge, there haven't been any issues with that parking policy, which has been in place. So, for the reasons that I mentioned and some of the facts that Anna is going to go over, we believe that each of the requests meets each of the elements for a variance, and we request your approval. But I'll turn it over to Anna.
Good evening. As mentioned, a large part of our issues on retrofitting and adding on to this house is that it's not ADA accessible. All entrances to the house are via stairs. This is because the first floor, if you can see on that elevation that was just up, is actually almost 5 feet out of the ground. And internally in the house, there are level changes within the floors, preventing someone with mobility issues from moving freely. Additionally, there are no ADA compliant bathrooms, and many of the common spaces currently in the house are in the basement, which is also inaccessible. The building's narrow, steep rear exit stair and exterior fire escape, when that is highlighted on the first page of the packet, serve as the primary exits in the emergency from the upper floors, and these do not comply with modern codes and are both a fall risk to residents. The current building codes also require us to have a 1-hour fire-rated separation between sleeping areas and adjacent spaces, and upgrading their existing dormitory space to meet this requirement would be complex and difficult, and this dorm is also not accessible. So our project seeks to address these safety and accessibility issues with a new addition while maintaining the existing architectural features of the historic house. So on the second page that Kevin provided, you can see that we have several exterior ramps to allow for ADA access. This is eating up a significant portion of the site. At minimum, we need 50% of the entrances to be accessible, and these ramps allow for this. It is part of the reason we couldn't slide the parking out of the parking setback. Particularly the south ramp is providing an accessible path from the sidewalk to the house. Additionally, to address egress issues from the upper floors, we show 2 stairs, which are shown in green on that second page, to provide the required code-compliant exits. On the next page, that would be page 3, we show 2 new ADA adaptable suites along with accessible restrooms and a laundry room to serve residents and visitors. On the following page, in green, all of the remaining common spaces that were currently in the basement are shown up on the first floor. This includes the kitchen and the dining room. Their current kitchen is undersized for their current number of residents and cannot be expanded in its current location, even if it were made accessible. On the 5th page, you can see how the addition was set back from the existing structure to minimize any demolition that would alter the character of the historic facade or roofline. It's important to note that this house is considered notable in terms of its historic architecture. Eliminating this gap would allow us to get the necessary setback that staff mentioned to get the height increase that we need. However, we'd have to significantly alter the look and facade of the historic house. So if you look on that elevation on the page 6, as I've kind of mentioned, it's our accessibility is kind of our driving goal in this project. And we are trying to match the existing first floor height with the new addition, which is approximately 4 feet 9 inches above the existing grade at street level. So that elevation you're seeing there, it's actually that second level line, that's our first level. We did look at dropping the first floor of the new addition to grade, which would put the building as designed in compliance with the height variance or height requirements per zoning. However, splitting the main floor in this manner would require us to allocate even more space towards circulation and creating an accessible path between the main common areas on this level more cumbersome and inequitable for a student in need of those accommodations. Currently, most of the new addition is designed with ceiling heights at 8 feet, which is 6 inches above a code minimum for this type of building, and some ceilings are even set to 7.6, which is our code minimum to limit the height and accommodate necessary building systems. The existing house does not currently have AC nor fire suppression, and so we'll be using the new addition.
You have 1 minute, please.
Okay, sorry. Finally, it's many of the concerns noted in the staff recommendation state that the R3U zoning are not designed to support an expansion of this scale, and the scale would be better suited on a larger property. The size of this addition, as noted, is due to the accessibility and saving the existing house. On that last page, we actually diagrammed a 3-story new building of similar building area to what we were proposing with a much larger parking lot would fit on this site, but we'd have to tear down the existing house to do so, which is not what we are interested in doing. Thank you.
Thank you. Anyone wishing to speak in favor of the petition? Anyone wishing to speak in opposition to the petition? Hearing none. Questions, comments from the board?
I have a quick comment, not necessarily a question, but I do know for communities like ours where we have historic homes, the best way to keep them intact is looking through adaptive reuse, and this would be a good reuse of the historic home to retain the character, and I'm in favor of it.
Thank you. Robert?
Have you looked at elevators? I noticed that there's a lot of ramps there, but I didn't see an elevator. Would an elevator go ahead and alleviate a lot of the need for the ramps and hence save space for you guys?
Yeah, so we did look at doing an elevator. The problem is there is a lot of internal level changes in the house, as well as many of the existing spaces in the house don't have wide enough doors for someone in a wheelchair or enough clearance for turning. So a lot of the spaces that do exist in the house that we're trying to save, we can't retrofit them easily. So even if we got a lift to bring students to the level, we're still needing to move some of those spaces to the addition. If that
It would be different than what they would need from getting off of a ramp?
Sorry, the ramps are just on the first floor because the first floor has internal level changes. So half the house is 13 inches lower than the other half. So the ramps on the first floor are to alleviate that sort of level change. And then up on the upper floors is where we have this space that we are fitting in the new larger study rooms that fit the needs of students. An elevator, you could put it in between these levels on the first floor, but it would require every time someone wanted to go from the living room to the dining room to have to use a lift. And that, it just doesn't seem very equitable to those students and kind of cumbersome as a movement path in the space. That makes sense? That, I think it's the second page, shows where the steps are in the house. So the ramps kind of help.
If you could speak into the mic so we can get it on the recording, please.
I would like to, as the petitioner, to take a shot at this too. There's a
Your name and address for the record.
Greg Napier, 1228 West, 400 South, Lafayette. And there is actually 6 different elevations inside that house. And the ability to put a elevator inside of the house would, first of all, it would be a structural issue. We might be able to put it outside the house, but like you said, every time you would leave a room to go to the restroom, you have to go into an elevator and move up 13 inches and then go to the other side. And there is no accessible restrooms on the main floor, and there's no accessible restrooms on the ground floor. There's no accessible restrooms anywhere in this building. So this is a hardship that I'm not quite understanding why we're taking it. We're not looking at this from an ADA perspective. And we have a 5-foot berm that this house sits on. And we're doing everything in our power to save what I would call a historic structure for our community. And to do something, to butcher it into lots of pieces and scabbing on things, that's not right for our community. There is the option of knocking it down. We don't like that option. No one likes that option. And we think that this is the best option after 20 versions plus. Yeah, this is our best option.
Okay, thank you.
Yeah.
And I do have a question. How many parking spots are currently on site? I know with the new proposal, there's supposed to be 57, and you're asking for a reduction to 22.
Yeah, so if I was to say how many are on site versus how many are parked on site, they're parking 30-some cars on site right now. Are those, per the ordinance, as far as the width and the depths and all those sort of things, they're piling in their 30-some cars for everyone that's in there on a gravel lot. And what's interesting to note is the gravel lot is in the same context. When we go back and look at all the aerial photography as far as we can go, it looks exactly like it does today. So nothing has changed in at least 40 years from what I can gather. It's been this way. When you look at the construction of the football stadium back in the 20s, this building is sitting in the background. It's been here way longer than even the ordinance has been in place. So this is great for our community to try to save.
Thank you.
Yeah.
Any other questions or comments? If not, we've got 3 ballots.
All right, we have 7 ballots cast for all of the 3 variances. On variance number 1, the count is 7 yes, 0 no's. On variance number 2, the count is 6 yes, 1 no. And on variance number 3, the count is 7 yes, 0 no.
All 3 variances have been approved. And we'll hear our next case, please.
I move to hear and vote on BZA 2206, Michael and Sally Sandry. Petitioners and owners represented by Cedric DeHue of Happy Stay WL LLC request a special exception to allow a transient guest house, SIC 702, for a maximum of 6 adult guests in a single-family dwelling operating 24 hours per day, 7 days per week. The AW zoned property is located a half a mile due west of North County Line Road East, commonly known as 10400 East, 250 North, Perry 12, Northeast 23-3, UZO 3-2-10.
Second.
Have a motion and a second. We'll hear from staff, please. Ryan?
Yes, very good. We have agricultural wooded site. Most of the vicinity is the same. It's a 2.2 acre location. The site has been used as a short-term rental by the petitioner's admission for about past 2.5 years. However, this is not, they're not here as a result of a zoning violation. They're here because they found out that this is actually regulated now, and so they came in on their own. They turned themselves in, so good for them. Anyway, the site itself is, the house anyway that's there is a kind of a log cabin style. It has 2 bedrooms, 2 full baths, and is planned to and is going to be restricted to accommodating up to 6 guests maximum. Access to the home is from a private driveway. Let's see, there's a shot of the house there. That also leads to the petitioner's house. Not making use of the garage, that would be exterior parking. I think that's all we got on that. Well, we got some more images there. Feels like you're going back in time, doesn't it? I believe that's it. There's a site plan. You can see it's kind of connected there. The private drive. It's obviously on well and septic out in this vicinity. So they're essentially trying to legitimize this use in this zone, which is permitted with a special exception. So, and to essentially continue it, but this time to fully legitimize it. So on August 6th, Executive Committee did vote that the comprehensive plan would not be substantially adversely affected. And in terms of the tests, in staff's opinion that the development standards will be met. Parking for 3 vehicles exists in front of the garage, which exceeds the 2 minimum required. Granting a special exception will not subvert the general purposes served by the ordinance. Limited to 6 will be permitted to stay here, consistent with short-term rentals that has been heard in the past. In terms of injury, granting the special exception will not materially and permanently injure other property or uses in the same district due to traffic generation, placement of outdoor lighting, noise production. The use has obviously been in place for 2.5 years without incident, and so they've sort of demonstrated their good faith, and so they just continue to plan to continue to do the same. And so limitations have been found to be satisfactory to the building commission in the past in terms of the occupancy level. So conditions, of course, are fairly standard. Permit to operate a guest house, From the Building Commission, must be obtained, and then 2 commitments, which are also fairly standard. House may be rented for only a single booking at any given time, and the house may be, again, only rented up to 6 individuals. Staff is recommending approval with the 1 condition and 2 commitments. Be happy to answer any questions.
Thank you. Petitioner, his or her representative.
Mike Sandry, 10440 East 250 North. As was stated, we've actually owned the cabin for almost 25 years, along with the house just to the north of it where we raised our family. And then, which is the previous slide, the picture in the lower left, that is the house. That picture is taken from the front door of the cabin, so it's very close in proximity. We raised our family there. Like I said, we've owned that been there for almost 25 years. My wife and I then built a home just further down the road from that house and sold that house that you see there to our 2 children who live there and now our 2 grandchildren. So it's this area has been in the family for quite some time. We had rented out the cabin for about 20 years and then made the transition to a short-term rental, like it was said, about 2.5 years ago. And then when we discovered that it needed this variance, we went to start to take the necessary steps and also contacted our neighbors immediately just to let them know what was going on, to find out if there was any issues whatsoever. And all the feedback we got was positive, and I believe you've also received those approvals, statements from them as well. So, doing the right, hopefully, get this done correctly. Thank you.
Thank you. Anyone else wishing to speak in favor of the petition?
Hello, Cedric D. Hugh, 3395 Putnam Street, West Lafayette, Indiana. Thank you for taking the time to hear my perspective. I'm the representative as well as the proposed property manager, co-host for the petition property. We agree with the staff recommendations and conditions for the permit. And I just wanted to reiterate that the home is actually 2 separate historic structures that have been combined together. And it's there's a lot of character to it, which makes it very appealing to guests. And we're in agreement with the 2 neighbors' letters of support, as well as the committee's agreement that the petition would not, adversely affect the comprehensive plan. Thank you.
Thank you. Anyone else wishing to speak in favor of the petition? Anyone in opposition to the petition? Questions, comments from the board? Hearing none, we've got a ballot.
Seven ballots cast, 7 yes, 0 no.
Special exception has been approved, and we'll hear the next 2 cases, please.
I move to hear together and vote on separately BZA 2207 Co-Knox. Petitioner and owner requests a special exception to allow a transient guest house, SIC 702, for an unspecified number of guests in a single-family dwelling operating 24 hours per day, 7 days per week. The AW-zoned property is located a half a mile northwest of the intersection at North 475 West and Jackson Highway, commonly known as 5100 Jackson Highway, Shelby 5 Southeast 23-5, UZO 3-2-10, and BZA 2208, Conox. Petitioner and owner requests a special exception to allow a transient guest house, SIC 702, for an unspecified number of guests in a single-family dwelling operating 24 hours per day, 7 days per week. The AW zone property is located a half-mile northwest of the intersection at North 475 West and Jackson Highway, commonly known as 5124 Jackson Highway, Shelby 5 Southeast 23-5, UZO 3-2-10.
Second.
Have a motion and a second, and we'll hear from staff, please.
Good evening, Christine Royal, Area Plan Commission staff. We are going to talk about 2207 first, briefly. Of course, we're out at Jackson Highway. Both of these are in AW, agricultural wooded. They are both shared with about a 750-foot driveway. And so then 2207 is a single-family home that was constructed in 2017 and is about 170 feet from the other house. I actually had that it was going to have a maximum of 5 guests on the staff report, and the site plan indicates that there are 6 parking spaces. And then BZA 2208, it has a single-family home that was constructed in the early 1900s, and it would like to have a maximum of 12 guests, and this home has room for 5 parking spaces. This is this home. Both houses are surrounded by medium-sized rural lots, and they have trees to the north and east. You see the trees on the bottom. And both homes are about at least over 450 feet from other residences. And both properties are served by well and septic. The county still has the policy that no more than 3 unrelated guests may occupy the residence at one time. And the building commissioner has concerns of guests sleeping in areas of the house without egress for the home that is requesting 12 guest maximum. These transient guest houses would not substantially affect the comprehensive plan, and the UZO does allow them in agricultural wooded zoning district. If the requests are granted, the petitioner is required to apply for the permit from the building commission, and they will also need to close out some open building permits for both sites. And then, of course, meet the commitments. They did pass all the tests that we ran, and then we recommend approval for both sites. And we're happy to answer any questions.
Thank you. Thank you. Petitioner or his or her representative.
Good evening, and thank you for having us. We agreed to any of the compliance requirements set forth by the municipalities in terms of permitting and closing some open permits. Our family actually had planned on raising our children here, but we had gotten pulled away to another state for work. So both of these residences are pretty well completely remodeled as of new. And we thought it would be a nice usage for West Lafayette and Purdue so that it wasn't just sitting vacant. So appreciate your consideration and happy to answer any questions.
Just thank you, your name and address for the record.
Thank you.
Co Knox at 6731 Bottlebrush Lane, Naples, Florida, 34109.
Thank you. Anyone wishing to speak in favor of the petition? Anyone in opposition to the petition?
Hello, good evening. My name's Shirley Zell. I live at 2800 Foxlair Drive, pretty close to adjacent to this property. You've also received letters previously from Natalie Baker and Pete Lagwish with many concerns similar to mine. I am writing as a concerned resident of Tippecanoe County regarding this petition to convert 2 houses and a barn. The barn isn't included this, but we were here previously with the party barn. I don't know if you probably remember that hearing. Located on a single lot near my residence into transient housing. This is not the first time this property has come under scrutiny. On March 23rd, 2022, the same out-of-state owners who reside in Florida and have no local presence sought approval to operate an agricultural rental hall, or party barn. That request was denied, and for good reason. The current proposal appears to be another attempt to commercialize this property under a different label with the same underlying intent to generate income without regard for the safety, character, or well-being of our community. Safety hazards. The property sits on a dangerous curve where 2 fatalities have occurred in recent years, increasing transient traffic, often unfamiliar with this area, would heighten the risk of further accidents. I'm including copies of both those accidents. The last accident that happened was during the night. We were awakened by it as the car rolled. Lack of operational restrictions. The proposal includes no limits on hours of use and concerns over the use of the barn, which previously was proposed as a party barn. Without these restrictions, the property could easily become a de facto event venue, echoing the previously denied consent concept. There are no limitations on amplified outdoor noise, lighting, fireworks, or other disruptive activities. Neighborhood impact. This area is a growing residential community. More homes are being built all the time. With many families and long-term homeowners, transient housing introduces instability, noise, and potential safety concerns that are incomparable with the character of our neighborhood. The owner's absence from the community raises serious questions about accountability and enforcement of any conditions placed on the property. Precedent and zoning integrity. Granting this exception would set a troubling precedent, encouraging other absentee owners to seek similar loopholes for commercial gain. The loaning laws exist to protect residents and ensure thoughtful, safe development. The proposal undermines that purpose. I respectfully urge the board to deny this request and hope that the integrity of our zoning regulations, our neighborhood deserves thoughtful planning, not opportunist exploitation. I'm also including the Journal and Courier.
You have 1 minute, ma'am.
Okay. Dated June 18, 24, the unified zoning ordinance would ban the use of single-family homes as short-term rentals commonly placed on rental platforms such as Airbnb and VRBO. I'm sure you're all aware of that. It's a Journal and Courier article. It's being concluded too. Thank you for your time.
Thank you. Anyone wishing to speak in opposition? Anyone else in opposition? Petitioner has a chance to rebut.
Wait, I think we have a
Do we have somebody that wants to speak? Sorry.
That's okay. My name is Michelle Coors. I live at 5127 Jackson Highway in West Lafayette, directly across the road from this property. As a neighbor across the road from the property in question, I, along with my husband, have no issue with the use of the home in this manner that's being proposed. The regular use of these homes is actually, I feel, a great fit for the property. Having been in both homes, there's plenty of space for the number of guests that are being requested in this area. In a comment, in comments that were made in previous hearings, I feel to hold property owners responsible for the accidents that occurred on Jackson Highway is inappropriate and unfair. Our property has been affected by those accidents as well, and I would not want to be held accountable for somebody driving irrationally, high rates of speed on roads that they may or may not know in the middle of the night. I wouldn't want that on my shoulders. Those accidents and any changes to the road are completely different issues and should be taken up with the county in the appropriate manner. So I am in favor of this special exemption for this property.
Thank you. Could you sign in? Anyone else wishing to speak either in favor or in opposition to this? Yeah. Yeah.
My name is Victor Gervais. I live at 3286 Apple Lane, about 2 miles from that location. And I know Cole, and I know his family. We live 2 doors down from his parents where he kind of grew up. And I've known him since he got his construction engineering degree at Purdue. And he took over his father's business, worked with him together, a construction business, and I just want to speak to he's a absolutely responsible person, responsible businessman, and my only comment would be if I don't know about the barn thing, but if you want to put any restrictions on him, I'm absolutely certain that he would comply with those, and other than that, I wouldn't have an issue. I would have an issue too if there's a noise and a problem possibly in the past. I don't know if that is addressed or if that can be addressed at this time, but I just want to speak to him and his family that I've known for years, and they operate co-roofing, which everyone has seen their construction equipment and projects all over this, all over our area. So I just wanted to speak to that.
Thank you, and if you could sign in, please. Anyone else in opposition to the petition? Now you have a chance to rebut.
I just wanted to say thank you again for having us, and I wanted to kind of touch on a couple things in terms of what were brought up for the opposition and the quote-unquote party barn. I'm not sure how the party barn ever really came of a concept. It was, we actually were looking at trying to convert this property into an event use space, and it was denied for the special exception, but that is not what we're trying to do here today. We have no intentions on utilizing this property outside of what our request is, which is for the transient housing. And again, we'll be in compliance with any request. I was born and raised here in West Lafayette, went to West Lafayette High School, went to Purdue University, graduated there, planned on raising my family here until work pulled us out of state. But rather than selling this property to a developer or changing it from its beautiful rural setting, we figured this might be a good application to maintain its historical integrity. I think they noted the house is from early 1900s. So appreciate your consideration with the vote. Thank you.
Thank you. Comments, questions from the board? I've got a couple I'll start out with. First of all, the barn, the previous petition, I don't know if you noticed, actually had a provision on the site plan that said that the garage was off limits to guests. Would you be amenable to a condition that would state that the barn is not part of the rental and would be off?
Yes, absolutely. We actually utilize the barn for some storage, and a hay farmer that cuts the hay fields for some of the local farmers sometimes uses it to store hay. So we would actually prefer that these transient guests do not utilize these structures at all.
And a second, most short-term rentals have hours, quiet hours, where people are supposed to be inside or, at least be quiet if they're outside. Would you be willing to suggest hours that we could make a commitment for that?
I think if hours are recommended, that we would be able to be in compliance with that. I think also to note that the structures themselves do sit at minimum, I think, 450 feet from the nearest neighbor, and at other times further in excess of 1,000 feet. So happy to comply with any covenants, restrictions, or requirements set forth by the committee or whoever. Again, we're just really trying to keep the property functional and maintain its kind of what I see as a historic nature as an old farmhouse as part of our community.
Yes, my third question is, how many bedrooms are in the second property that you're proposing 12 guests?
Is the one on the picture,
It's the
is
second
that
one.
the second? So there are 4 bedrooms and a den, and then the regular living spaces.
Gary?
You kind of went where I was going to go. Just for clarification on guest, on the first one, 2207, I see in the staff recommendations, it said occupancy limited to 5 guests, obviously with no more than 3 unrelated guests. Is that part of the request? And if approved, that would be a condition? Or is that a suggestion, or is that part of the request?
That was part of the request. Yeah, I think there was an old version of the agenda that was used on the screen.
Okay, so the first one is 5 guests, 3 unrelated. Okay, for the next one, with the 3 unrelated rule, I'm, in 12 guests with 4 bedrooms, I'm not sure what group you'd have that would have no more than 3 unrelated people, unless you had a family reunion.
Well, sir, I have 4 children myself, 15, 13, 8, and 2.5. So we're a family of 6 in ourselves. If we have one of our cousins over that also is a family of 6, we've hit 12.
I got you. So,
sorry, we have a kind of big family.
Do a
Go ahead.
follow-up with
Yeah,
that?
I'm not
You
done,
said
but-
that there's a den. Is that essentially, is that a bedroom? Does it have
The den
exit
does
of
have I think they're called futon couches. So in theory, there's a den with a desk and a futon couch that could be converted into a physical bed if the need required.
but could it, does it legally comply with a bedroom? Does it have an emergency, a secondary exit?
So there is egress throughout this house. There's a outdoor balcony on the second floor that will have a fire escape device by it, but there is egress. This den actually is adjacent to the garage door entry, and there's a window that meets the requirements for egress attached to the bedroom on the first floor as well.
The den?
The den, yes. There's not a physical closet space, so my understanding from being a contractor for 20 years now is a bedroom is a bedroom if it has a closet.
Go ahead.
Just to follow up on 12 with 3, I can, support the first one with 5 guests with 3 unrelated, and the barn's not part of it. But the second one, I think that the building commission had an issue with 12 people. I just think that's too many.
Yeah.
Whatever the recommendation is, again, we're not trying to pass anything that was set forth by the authorities here.
I guess, do we want to start making some motions for commitments or?
Might entertain a motion on the barn first.
Yep, I'll take a motion on not having the barn accessible to guests. Someone would like to make that?
I move that we have a requirement that the barn is not part of the rental
A commitment.
commitment.
I'll second it.
We have a motion and a second. Is there any further discussion on that?
Just for clarification, I think that'd be for BZA 2207. Is that the first one?
The barn is on the first.
Yeah, so that's
Property.
2207. And that's with 5 guests, 3 unrelated.
Correct. That is agreeable to you.
Yes, sir.
All in favor?
Aye.
Opposed? That motion carries. And we had outdoor quiet hours is the next. What? We would need times for that. We might look at the previous.
We'd be happy to comply with whatever standard regulation or recommendation from you guys.
Okay. So, suggestion of 10 p.m. to 8 a.m. as quiet hours.
I think that's more than fair, and again, we're willing to cooperate with whatever your guys' recommendation is.
And I'll entertain a motion for that.
I move that we have a condition that quiet hours exist from 10 p.m. to 8 a.m. For both BZA 2207 and 2208.
A second, but it's 2007.
I'm sorry, 2207.
No, no, it's not 22. It's
There may be an error in that
2007.
number. BZA
There-
2008.
Yeah, on the staff report,
The staff report
that
has
is an error. It's
in it.
2207 and
Or the-
2208.
Just read it.
Good catch, though, Ed.
Yeah.
Down there it is.
We have a motion and a second. Any further discussion? Hearing none, and you said you were amenable to that.
I'm good with that.
Okay. All in favor, say aye.
Aye.
Opposed? That goes with both cases. And then we have one for 2208. Gary, did you have a suggestion on that one?
I don't have a recommendation per se, but, the only commission had an issue. I just think that it's a rare occasion that you'd have 12 with only 3 unrelated. 4-bedroom, 8 people. I'm just pulling that out. I'm looking for thoughts from the board or the petitioner. Otherwise, it just gets too dense.
Could we make it to where it's the Tippecanoe County Building Commission's call on?
I think we need a number.
Okay.
Did they have a recommendation on file
They-
yet? Working with the Building Commission, did they have a recommendation on the
I have
documents?
not had a recommendation from the building commission, but again, I'm happy to seek that. So the thought process behind the number of it being 12 was that 2 of these bedrooms would have bunk beds in them, because sometimes our younger kids like to share the spaces. And then we were compensating again for like the cousins when they come over and if they have to flip the futon out. But really, we're open to whatever recommendation or suggestion from the committee or county.
Anyone?
I have
Go ahead,
something
Rubita.
that I want to clarify with the staff. So once the transient rental use is approved for something like this, the family or the owner can use the property as their primary house without the restriction of number of people on the property. Is that correct?
Yes.
Okay, thank you.
And to clarify, thank you for asking that question, because my mother does live 1.5 miles, 2 miles down the road. My wife's family, we're both born and raised here, so we have quite a bit of family here. We try to make it back a couple times a year, and we do stay at this house while we're here, yes.
Staff is happy to offer a recommendation if you all are fishing for suggestions.
Sure.
Yes, please.
2 per bedroom is
Two.
the standard we've used in the past.
Just two per bedroom, or since it's 4 bedrooms, maximum of 8?
Yeah.
You know, I think everybody,
And, I mean, will someone like to entertain a motion, or entertain a motion?
I'll motion to add the condition to limit the number of guests to 8.
3
For
unrelated.
yes, for BZA 2208.
Have a motion and a second. Any further discussion? And you're good with that?
Yeah, I'm good with
All in favor, say aye. Aye. Opposed? Any other comments or questions or concerns from the board? Hearing none, we've got 2 ballots.
Can I make one last statement?
I think we...
Or you just vote?
Yeah, we're just going to vote.
First one is
2207 is the first one.
all right. Both of these matters, 2207 and 2208, have 7 ballots cast, and 2207 is 7 yes, 0 no. 2208 is 7 yes, 0 no.
Both special exceptions have been approved. And before we hear our next case, I would entertain a motion to recess for 10 minutes.
I would move that we take a 10-minute recess.
We have a motion and a second, and we'll be back at
7:36.
7:36. If we could please take our seats so we can continue.
Okay, you've got that, all right?
Yeah. If we could please take our seats so we can get started.
Maybe Mr. Bumbleberg needs to sit down.
We reconvene the Area Board of Zoning Appeals of Tippecanoe County meeting of August 27th, 2025. We have a procedure that has been agreed to by the attorneys on both sides. And the attorneys are Jason M. Chuchme and Ryan Munden. And these are the procedures. First, Rainbow Trout's attorney and other representatives will get 30 minutes to present their presentation. After Rainbow Trout's presentation, individuals who wish to speak in favor of the application will each be given 5 minutes to talk. After those in favor speak, the attorney representing the opposition will speak for 30 minutes, and he will also be speaking on behalf of a number of people. After he speaks, individuals who oppose the application will be given 5 minutes to speak. When the opposition speeches are done, Rainbow Trout will be provided 20 minutes for rebuttal. After the rebuttal, the BZA may ask questions and have deliberations and vote. I remind everyone to please not bring up arguments raised by others, per the previous procedures. I mean, if you do need to get up and talk, you can give your name and opposition and the reasons for, but don't elaborate on the reasons that have already been brought up, if possible. And I would like a motion to adopt these procedures.
I so move.
I'll second.
We have a motion and a second. Any discussion? All in favor, say aye. Aye. Opposed? That motion carries. I'll take the motion to put Rainbow Trout on the floor.
I move to hear and vote on BZA 2199 Rainbow Trout Solar and the attached decommissioning plan and the estimate of the surety. Petitioner, on behalf of 7 property owners and represented by Ryan C. Munden of RTS Law, requests a special exception to allow for a large-scale solar energy system, SIC 49, operating 24 hours per day, 7 days per week in the AW and AA zones, spanning a total of 1,700.1 acres. The proposed installation is located in Shelby Township, sections 5, 6, 7, 8, 23 North, 5 West, and also sections 12, 13, 14, 23, 24, 23 North, 6 West, UZO 3-2-6, continued by petitioner from the June 25th, 2025 ABZA hearing, first continuance.
Second.
Have a motion and a second. We'll hear from staff, please. Amanda?
Thank you. Amanda Esposito, APC staff. We know there's a lot of people here for this case, so if all of the copies were taken and you still want to see the packet, I just wanted to let you know that you can access it online from our website, which is tippecanoe.in.gov. Navigate to the Area Plan Commission page, then click on the Board of Zoning Appeals below the heading for meetings/agendas. This case, BZA 2199, starts on page 11 of that PDF. Also, several letters were received after the packet was published. Those are being passed around to the board members as we speak. This special exception request is likely the largest project that has come before the BZA, certainly the largest in recent memory, not to mention incredibly detailed and complicated. The current proposal stands at 1,700.1 acres, which is exclusive of floodplain FP zoned land, which will house solar modules, inverters, an operations and maintenance structure, a new substation, and a meteorological MET station to collect data, as well as internal access roads. The property included in this request is zoned AA, Select Agricultural, and AW, Agricultural and Wooded. Any FP zoning that had been included originally is now excluded from the request. Furthermore, all FP setbacks, floodplain setbacks, have been met according to the binding site plan. The rural zoning districts in this area of the county date back to the 1980s when they were first introduced. Surrounding properties include a mix of RE, rural estate, A, agricultural, and R1, single-family residential. The project area is either unimproved and farmed for row crops, or it is wooded. Many single-family homes lie adjacent to the project scope along various roads, including, but not limited to, Kerber Road, State Road 26, County Road 650 West, Apple Lane, and Southworth Branch Road. You can see a close-up of the northern section here and a close-up of the southern section. We have a couple of pictures that were taken of the farthest west, north, and south boundaries of the northern portion, and a quick note about the site plan that is referencing where the pictures were taken. This site plan is not the binding one. We had used an earlier version of the site plan just for referencing where those pictures were taken. They do have an updated site plan, which is in your packet and which will be shown on a subsequent slide here. We just chose to keep it here since the slides were already created. And here are some pictures taken from on the southern section of the farthest east, north, and south boundaries of the southern portion. Site 1 here is the location of the proposed Met Tower off of County Road 200 North. Oh, this is the, Site 1 on this picture is the Met Tower location. This Site 1 picture is the location of the easement for the proposed transmission lines from the southern solar array as it turns east off of North 750 West toward the northern section. This is their overall site plan, obviously very detailed. Subsequent slides here have a little bit more of a closer up image for you if we needed to refer to them. Public utilities for sewer and water are not required for this use, nor would they be available in this area of the county. An existing substation on the north side of County Road 350 North, operated by American Electric Power Company, is proposed to be used by the solar array as part of its operations. The buffer yard requirement is somewhat complicated, particularly because the UZO refers to Chapter 4-9 for large-scale SES, solar energy systems, buffer yard requirements. Chapter 4-9 does not include solar in any capacity. So in the absence of any guidance from the UZO, Petitioner has opted to provide a 15-foot width buffer yard of mature evergreen trees adjacent to properties with residences on them, in addition to a 6-foot tall agricultural-style fence encircling the entire project. The petitioner may choose to describe the buffering in a little bit more detail. Pollinator-friendly native plants must be maintained below and around the solar panels for the entire lifespan of the project, which the petitioner has included in their application. The UZO has other requirements per Chapter 41114, which the petitioner has either met or addressed to the best of their ability at this time in the process. These are outlined in the staff report, so I won't repeat all of those now. However, the board is responsible for approving the decommissioning plan and the estimated amount for the surety to be posted. Both of these items may be found in your packet materials. Staff has found the plan to conform to the requirements of the UZO in terms of items needed. A certified professional engineer has signed off on the plan as well. We have no further guidance for us or to recommend to you as the board as to the estimate being an acceptable amount. The vote you are casting for this special exception on one ballot will also accept the decommissioning plan and the proposed estimate. Following this meeting, should petitioner be granted approval, staff is recommending a list of conditions and commitments. The conditions must be met before improvement location permits are granted. Please note this was misstated in the staff report as occupancy permits. It needs to be improvement location permits. Commitments are written on a document that is recorded in the county recorder's office and must be adhered to for the lifespan of the project. Staff will coordinate with the petitioner and the respective offices to ensure the conditions and commitments are fulfilled. Again, this is a large project. 1,700 acres of land will be used exclusively for one use for the next 35 to 40 years. Tippecanoe County has 222,136 acres of land in total, making this project 0.77% of the county. Relative to other large-scale SES, this is fairly small. In our research, staff has seen projects encompassing 2,000 or more acres of land. While staff does not believe this project would tip the scales of having an untenable level of non-tillable land, what is that level? The members of our BZA should consider what impact this project will have on our county now, as well as the impact of potential future projects. Special exceptions, when granted approval, cease to be valid if the use is not established within 1 year of the date of approval. In this particular case, the administrative officer has determined that the use will be considered established when the operations and maintenance building has been granted an occupancy permit. When considering a special exception, APC staff looks to the findings of fact from the UZO. Based on the proposed use and using both materials provided by the petitioner in their application, as well as conducting our own research on the use, staff has found that upon receiving the necessary approvals from the county, state, and/or federal agencies, as well as the executed power purchase agreement, the requirements and development standards for the requested use as prescribed by the UZO will be met. Granting the special exception will not subvert the general purposes served by the ordinance. A large-scale SES provides locally generated renewable energy to the power grid, helping us reduce our dependency on non-renewable fossil fuels that produce greenhouse gases and contribute to human-induced climate change. Granting the special exception will not materially and permanently injure other property or uses in the same district and vicinity because of traffic. Once constructed, there will be minimal daily traffic in the form of regular maintenance, an expected 1 to 2 vehicles per day. Outdoor lighting is only proposed on the operations and maintenance building near the entrances, as well as the new substation. The substation will be lit in compliance with federal and state requirements. All lighting is proposed to be downward focused. As for noise, the solar panels themselves do not produce a high enough decibel to be detected by humans, so the inverters and the substation are the two components that would produce any noticeable noise. The estimated level at its highest, and measured at the nearest occupied residences, would be 49 dBA. In comparison, a standard household refrigerator runs at about 32 to 40 dBA. Most of this noise would be occurring during daylight hours. And as per hours of operation, the SES will run 24 hours per day, 7 days per week. However, due to the nature of the use, most of the operations will be conducted during daylight hours when the sun's rays are being captured to transform into electricity for consumption. Because this request passes all of the tests, Staff is recommending approval with the conditions and commitments listed on the staff report, along with an additional condition not listed on the report to record the decommissioning plan that is requested by the UZO. Thank you.
Thank you. Petitioner's attorney.
Good evening, I'm Ryan Munden with RTS Law, here on behalf of Rainbow Trout Solar. As always, thank you, Amanda, for a thorough overview and introduction. We are also appreciative of the hard work put into the staff report by APC. They have clearly put an incredible amount of thought into this project. Our team started meeting with staff in February of this year, and we have been engaged in regular communication with them, answering questions and making requested adjustments along the way. This culminated in a submission that was over 700 pages and included a preliminary drainage, grading and erosion control study, visual impact analysis, noise study, glint and glare analysis, traffic impact study, economic impact analysis, and property valuation study. Obviously, we have a limited amount of time this evening to introduce you to our project, and we'll do the best we can to share with you what we've spent the last 6 months sharing with APC. The staff report is indicative of the time that we've spent with APC and the time that they have spent vetting this project. Our team shares APC staff's desire to get this right. Shortly, I will invite several members of our team to introduce various aspects of who Rainbow Trout Solar is, as well as details about our project. As Amanda said, this is the first time our solar ordinance has been put to the test, and rightfully so, every aspect of our submission has gone through extreme scrutiny. The UZO provides for a pre-submission meeting with APC staff, which we completed on April 24th and May 7th earlier this year. The ordinance also lists certain items that must be complied with or which are to be submitted with a special exception request or an improvement location permit application. A site plan that meets the standards set forth in the ordinance is one, and as staff explained and our next speakers will further explain, we have met or exceeded each of those standards. A buffer yard. Our project provides for a 15-foot wide buffer yard of mature evergreen trees along with 6-foot tall agricultural style fences. A decommissioning plan was submitted with our application as compliant with all the requirements of the ordinance. Obtaining stormwater management plan and driveway permit approval are conditions to our special exception approval, and we will comply with all staff's conditions. However, while we were not required to, we did submit preliminary drainage study as well as proposed driveway entrances as part of our special exception application. I have spoken with Stu Klein, our highway department director. He advised that a driveway permit would not be approved for a use until a rezone or special exception was approved. Likewise, I've spoken with Zach Beasley, our county surveyor, who also confirmed that a drainage plan would not be approved until a rezone or special exception was approved. Finally, the UZO lists a redacted version of the executed power purchase agreement. This is also a condition to approval that we will satisfy. We had extensive discussion with APC staff about why, like an approved drainage plan and driveway permit, an executed power purchase agreement was not possible prior to special exception submission. On April 8th, we emailed a template power purchase agreement to APC staff, which we also included in a draft submission binder that was delivered to staff on April 21st. During our pre-submission meeting on April 24th, staff requested an alternative to an executed power purchase agreement for purposes of our submission. On April 28th, we replaced the template power purchase agreement with the executed interconnection agreement in our binder. This discussion with APC staff was to assist in helping us to go above and beyond the submission requirements, not to ask APC to exercise discretion on what was and was not required as part of our submission. The UZO says certain enumerated items are to be submitted with the special exception request or the improvement location permit application. We have strictly adhered to the UZO with respect to the requirements of our submission, as confirmed by Ryan O'Gara, APC staff, and the APC Executive Committee. I'd now like to introduce you to Wayne DeLong, who will next present who Rainbow Trout Solar is, followed by others who will dive into the project.
Thank you.
Thank you, Ryan. Good evening, members of the Board of Zoning Appeals. My name is Wayne DeLong, address of 525 South Meridian Street, Indianapolis, Indiana, 46225, and I serve as Senior Director of Development with GeneX. This evening, I'll briefly review Rainbow Trout's multi-year timeline. Beginning years of time, that time reflects GeneX's expertise and focus on the project, being an early stage developer. The GNEX team recognizes, of course, both you and the attendees in the room and in the hallway, as well as viewing at home. As a part of that, they all want to be dialed into the facts and the data. But first, we feel we need to give you a little bit of the backstory on how we got here today. Jumping forward, introductions. As an early stage developer, GNEX does not own or operate the installations we develop. The installation is sold to a well-qualified and experienced operator, in this case of Rainbow Trout. That operator is RWE. RWE, whose representatives are here this evening, will speak as a part of this overall presentation. Is a 125-year-old company experienced in developing, owning, and operating utility assets, including and specifically solar generating assets. It is our pleasure to introduce RWE to you here this evening. One of the first level-setting questions we'd like to cover: why here, why now? Interested families in hosting solar panels, existing power transmission infrastructure, mature stands of trees are all characteristics a developer like GNEX is looking for when contemplating installation. These inputs are some of what is considered, but what as well informs Rainbow Trout's potential is the opportunity to support the community in a variety of unique ways. This uniqueness is compounded by the fact that Rainbow Trout is a tax-paying entity, and such a relationship would eliminate the expansion in Shelby Township on ground that is leveraged for researching solar, pollinators, or native vegetation, all while at the same time facilitating the growth of the county's tax base while installation of this facility. Further, the uniqueness of this relationship tamps down the rising electrical rates documented in today's media. Jumping to things we know, facts we know, and then why this matters. Reshoring of manufacturing and electrification of industry places Indiana at the center of a rapidly growing demand for electricity. This surge in demand further strains an electrical grid not built for sudden growth. Indiana is well suited for significant support of this economic growth in key areas based on these factors. We concur with the staff's report and the comments made that the preparations for this transition is an important topic. Utilities are scrambling to find new energy generation sources and make grid upgrades, and solar offers the lowest cost and for production, all while being the fastest produced solar action that can bring and build that level of energy online. Local national media illustrate this point as well, as captured in the quotes and data on the slide in front of you. Matching this information with our conclusions, we provide and offer to you this evening the proposed 120 megawatt Rainbow Trout solar project directly addresses the challenges to the grid, which includes adding new generation capacity, strengthening grid resilience, providing long-term price stability, and supporting sustainable growth. Rainbow Trout Solar helps ensure that Hoosier communities remain powered, prosperous, and prepared for the future. Specific to the timeline that we mentioned earlier, we've been in the county working on this project for 6 years. Personally, I've been a Hoosier since 1983. But 6 years of forward-facing efforts here in Indiana by Rainbow Trout is illustrated on the screen in front of you. I'll briefly review this. In 2020, the project moves forward by finding and talking with interested families willing to lease ground to the project. That's an important component, leasing the ground to the project, as well as the project signs an operational agreement with the grid operator PJM. PJM is probably a term that you may have heard. We can get in more details on that here in later slides. And years 21 through 24, we complete field studies, which will be informing the site plan that you will see this evening, that you've seen already. And additional leases are executed with willing families. And currently, of course, here in 2025, we now have our interconnection agreement, as discussed. We introducing RWE tonight. They are now the project owner. And we submit for your consideration the special exception filing for discussion this evening. And of course, we cannot admit discussing our timeline without a focus on how Rainbow Trout's team's commitment to building meaningful relationships in Tippecanoe County has occurred and continues to occur through accessibility, transparency, and collaboration. Here in 2025 alone, we have opened a local office in West Lafayette, hosted 3 open houses there, and maintained weekly office hours, allowing the community and creating an opportunity to further interface with the Rainbow Trout project and facilitate additional fire training, safety efforts, and have led educational events. And detailing even further here, we are especially proud to invest in the next generation through programming like Junior Achievement and the Purdue Solar Racing Team. Students and active members are here this evening. Our collaboration with university students embraces sustainability efforts by facilitating a real-world case pitch competition focused on renewable energy. Beyond education, we've focused and contributed to environmental efforts such as Nietzsche's Land Trust, Howell Woods Property, D-Trash the Wabash, Riverfest, and the county's 4-H for 3 years running now, and newly this year, Food Finders Hunger Hike. We are proud to have launched the Rainbow Trout Solar Endowment through the Community Foundation here in 2024, and we recognize and feel that that's a lasting investment in the county's future. As we look forward ahead, we remain grateful to the relationships we have built and remain committed to being a trusted, long-term community partner. And wrapping things up for my part of the presentation, on the slide now is an illustration of the Shelby Township parcels that are signed with the project, illustrating 28 parcels, just under 1,800 acres at gross size, as indicated on the site plan as part of the filing and being discussed this evening. This particular site plan was designed in conformance, of course, with the county's UZO, and benefits from information garnered from design professionals on the topics of drainage and wetlands, noise and glare, traffic, impact, and the review of environmental characteristics, as well as landscaping screening. The site's location is representative of the points covered earlier in this site selection: overhead power lines, open available ground, interested landowners, and a strong presence of mature natural buffering. Now I'm happy to introduce Mark Schuler with RWE.
We would also like to remind all speakers to make sure that you are as close to the microphone as possible. There are still some people who are not able to hear everybody. Thank you.
Thank you. My name is Mark Schuler, 353 North Clark Street, Chicago, Illinois, 60654. I'm a senior development manager for RWE, and I am representing RWE today. We've been around for 125 years. As I said, we came to North America in 1998, and we've been in Indiana for approximately 20 years. We are, as he said, a developer. We construct, own, and operate facilities all over the country, and we currently have over 50 active solar projects already operating in the country. In Indiana, we have 13 developments ongoing with the Wildcat Wind Farm, which went COD in 2012, so it's been around for a while, and several others that are ready to break ground in the very near future. I was asked to give a little overview of what utility scale solar is. So sun shines on panels, and the panels have electrons that get excited. They move through the wires to the inverter box. The inverter converts the electricity from DC to AC. The AC moves to our substation, which will up-convert it to the voltage required by the utility. And from there, it goes to the grid. This is Rainbow Trout. It's 120 megawatts AC. It's in two large sections, a north and a south section with approximately a 2-mile collector lines. It has a targeted operational life of around 40 years. This project will power over 20,000 homes. It also reduces 200,000 pounds of CO2 emissions, which is like taking 43,000 gas-powered cars off the road. So it's a very positive thing. This is a close-up since it's been shown a couple times, but we're going to use approximately 272,000 modules, 33 inverters. We will also have a collector substation up on the north side adjacent to the AEP substation. We'll also set up our permanent parking there, and our operations building will be in that location as well. We will have limited lighting like was specified, primarily around the buildings and the substation, potentially at some access gates, but all of that will be pointing down to the ground. We've worked really hard to create setbacks that are large enough to not impose on our neighborhoods and the residences around the property. And we've also taken into consideration the drainage system that runs through our property, so it won't be impacted. Like he said, we're going to have inverters on the site. They do make some noise, but we have positioned all of them at least 250 feet away from our property lines, not the neighbors, our property lines. We have increased setbacks. I've said that already. We originally had about 1,025 acres in the fences. Now we're around 900 acres in fences. We've reduced our panel coverage by 22% from what was submitted in the application. And there's going to be a minimum setback of 250 feet from any non-participating residences. The ordinance requires about 200 feet. Most of it's a lot more than that. With Stantec, we've completed the environmental due diligence studies. Wayne mentioned some of that, or yeah, it's been mentioned, but we did noise and lighting, glint and glare, all the normal wetland studies, stormwater prevention planning, cultural impact and wildlife impact. And it was determined that there's going to be no adverse impact to the county or to the area because of our solar project. Kleinfelder continued our studies with a geotech report, hydrology studies, and also a topo survey. This information has been passed on to TRC, who is advancing our designs and to the next level, and that should be coming out in the next few weeks. Tonight we have Stantec representatives in-house as well as TRC representatives in-house for questions. Our landscaping plan will comply with the Tippecanoe County ordinance. We try to minimize our impact on the vegetation as much as possible and try to minimize our dirt moving as much as possible. We are working with some of the local experts on the tree species and native seed mixes. We've talked to Purdue Agriculture, the Soil and Water Conservation District, and niches about this, as well as working with Stantec. We will comply with the solar pollinator scorecard to make this a good site. This is an example of what it's going to look like after we plant right at planting. So at 5 years, you'll see the trees starting to fill in and mature. And at 10 years, we should have pretty good screening from the roads. So my last slide is about economic benefit. This project is a really good project for the community. We're going to spend at least $140 million of taxable investment in the county. This will come along with 240 plus construction jobs. We have a member from the Carpenters Union here tonight. We'll have 3 to 5 full-time operators working on site, RWE employees. During construction, we expect they'll spend over $30 million in just living here and buying food and buying gas, just all those construction workers. The new tax revenue generated will strengthen the local schools, the roads, and municipalities, as well as potentially lightening the burden on the taxpayers in the community. Paul Wyman of the Wyman Group is here to talk about property values and how we expect there to be no adverse impact on the neighboring property values due to the solar project, since we are going to be doing proper setbacks and vegetative screening. The next presenter is Monica Wilson.
Hi, I'm Monica Wilson, also with RWE. I'm a pre-construction project manager, headquartered 353 North Clark Street in Chicago, Illinois. I'm also a 2015 Purdue Environmental Engineering graduate. I'm going to talk to you about the construction and operations of our solar project. RWE has successfully constructed over 50 solar projects. We prioritize land stewardship and community relations in all of our projects. This project is expected to take about 1.5 years of construction with a 2 to 3 month winter shutdown in the middle. Piles are driven in sequence across the land. It's a moving operation that we do with construction, so not all the work will be in one area all the time. RWE will also comply with all noise and hours of operation regulations during construction. We put road protections and traffic as a big consideration. We direct contractors into laydown yards to reduce road congestion, and we're also responsible for maintaining roads we use during construction operations and decommissioning. Anything we damage, we will fix. As stated in the APC staff report, during operations, traffic is expected to be similar to now or less during operations. And some other ways we prioritize land stewardship and community relations. We know there's drain tile on site, and we will work with landowners to actively avoid and repair drain tile as required and use local contractors for these repairs. We have Tier 1 relationships with our engineering, procurement, and construction EPC firms. They prioritize safety, communication, and quality. And some of our partners, such as Blattner, are in support here today. Stormwater management will plant pollinator seed mix under the panels, which will mitigate stormwater runoff, and we also have a stormwater pollution prevention plan in place prior to construction starting. For the APC staff report, this will help soil stabilization, will include native species, and reduce runoff. We take several steps to maintain and improve the topsoil. We will use approved seed mix pollinator species to maintain the quality of the current topsoil. The site is also relatively flat, which reduces the need for grading and removing of topsoil. If we need to remove any, we will stockpile it temporarily and then respread over the same land so none is lost. During operations and maintenance, there'll be about 3 to 5 full-time permanent employees on site to manage the maintenance, vegetation, and safety of the project. Our project will operate 24/7, but only produce power during the daylight hours, but we will monitor the site 24/7 through local staff and remote control centers for safety and performance. We construct with operations in mind. We have the O&M staff on site while we're in construction so that there's a seamless transition to operations. We also aim to hire local vendors and contractors to support our operations and through construction through trade unions. At decommissioning, we are legally bound to remove equipment and restore the land for agricultural use or other uses as the landowner sees fit. So at the end of our 35 to 40 years, the land can go back to agricultural purposes. A decommissioning bond is posted to assure that no financial burden will ever fall on the community. We're also actively committed to a 90% recycling rate of all solar and wind materials by 2030. And I will pass it on to Ryan for our final conclusion.
Thanks, Monica. As we've mentioned several times, our team has spent 4 years talking to various stakeholders in our community and 6 months working directly with Area Plan Commission to ultimately bring you this project. 700 pages of materials is impossible to do any justice to in 30 minutes, but what I'd like you to take away is that we've been dealing in extensive and actual facts and data, not unfounded fears. For example, over the last several months, we've repeatedly heard concerns about the risks of battery storage. However, this project does not have any battery storage. Another example is that we've heard this project is a permanent alteration of the landscape, when in reality, the project is leasing the ground for 40 years or less, at which point the property will be put back into crop production or available for development for some other use. If you focus on the facts, I'm confident you'll reach the same conclusion that APC staff did, which is that this is a safe project and that this is a project that should be approved. The first level of vetting the project received was by the Executive Committee and whether we substantially adversely affect the comprehensive plan. We concur with staff and the APC Executive Committee that we do not. The goals of the comprehensive plan include properly timing and adequacy of design and administration of utilities and infrastructure. This project has no such need for utilities or public infrastructure, as the project itself will be providing public energy to the grid for use by the public. Next is promotion of environmental protection, including compatibility with soil type and drainage patterns. While rainbow trout is in use and actively producing energy, runoff will not be exposed to any toxic materials that would compromise the groundwater. The stormwater protection plan, thoroughly reviewed and approved by the county surveyor, is part of the approval process for this project. Topsoil will be maintained throughout the project with minimal grading in the initial development. Any and all topsoil removed will be kept for later restoration. Next is preservation of prime ag land. Unlike other types of development, including residential projects, rainbow trout again only has a lifespan of less than 40 years. Upon its completion, it will be decommissioned. Erosion control measures will be taken to protect resources during decommissioning activities. The soils will not be disturbed for 40 years once the project has been installed. Not only will soils not be tilled, creating a continuous cycle of erosion, but they will also be left untreated by harmful agricultural chemicals that have a detrimental effect on the ecosystem. Again, focusing on facts and not unfounded fears supports the conclusion that we do not substantially adversely affect the comprehensive plan. We likewise concur with staff's report and recommendation regarding all ballot items this evening. Upon receiving the necessary approvals from county, state, and/or federal agencies, as well as the executed power purchase agreement, the requirements and development standards for the requested use as prescribed by the Unified Zoning Ordinance will be met. Granting the special exception will not subvert the general purposes served by the ordinance. Rainbow trout will promote the health and general welfare of this community by providing local renewable energy instead of energy generated by fossil fuels. As mentioned, a glare analysis was completed and determined that the arrays will not impact road segments or nearby structures. Granting the special exception will not materially and permanently injure other property or uses in the same district and vicinity because of traffic generation, placement of outdoor lighting, noise production, or hours of operation. With respect to traffic generation, once constructed, the project will have minimum daily traffic in the form of regular maintenance, which may necessitate potentially 1 or 2 vehicles per day on site. With respect to outdoor lighting, as Amanda mentioned, permanent lighting will be installed on the operations and maintenance building, and substation will be lit in compliance with federal and state requirements. With respect to noise production, as Amanda mentioned, the noise produced by the inverters and substation are comparable to what a residential refrigerator would produce. And for hours of operation, the project will run 24 hours per day, 7 days a week. However, due to the nature of the use, most of the operations will be conducted during daylight hours when the sun's rays are captured and transformed into energy. The current use of much of this land is crop production. I live 4 miles west of the project outside of Otterburn, and my house is surrounded by nothing but corn and bean fields. I can see windmills in Benton County from miles away, but they blend into the surroundings and you forget they're even there, much like the hundreds of wooden power poles and miles of overhead lines that trace the public roads between my house and West Lafayette. They may have been visually impactful when they were installed, but they've become a natural part of the surroundings that we come to eventually forget exist. Unlike the power poles and windmills that have become common, the solar arrays top out at 12 feet and then are dwarfed by the miles of evergreens that will be planted, making visual impact minimal. I also grew up on a 100-acre farm that my family still farms to this day. A typical year living surrounded by fields includes cultivating in the spring. This brings heavy traffic of tractors and implements on roads, hours of loud tractors planting, sometimes in the dead of night and at times right on your property line. Once that's done, it's followed by multiple rounds of spraying chemicals to fertilize crop, kill weeds and pests. Once that's done, it's followed by more rounds of spraying, sometimes by crop dusters that fly maybe a few dozen feet over my house. And unfortunately, as our area experienced last summer, sometimes those crop dusters experience fatal accidents. After that, it's harvest, which brings another round of heavy traffic of tractors and implements, and this time semis to transport the grain. After that, there can be further rounds of yet more tractors to till the ground and prep it for next spring. This all occurs all hours of the day and night. Harvest creates an incredible amount of dust and debris. It also displaces large amounts of wildlife, including deer that become a significant traffic hazard. Following harvest, especially after a year of corn, you get to spend the winter and much of the following spring cleaning up the thousands upon thousands of corn stalks that clutter your yard and make a mess of it. Once that's done, you get to do it all over again, year after year. I'm not sharing this to knock on farming. Again, I come from a farming family. They still farm our farm back home to this day. But I share this all in keeping with our theme tonight and dealing with facts, not unfounded fears. It's disingenuous to argue that 12-foot solar panels that after installation do nothing but bathe in the sun for the next 40 years or less are a detriment to the community or to the neighbors compared to crop production. You're going to hear from a lot of members of our community this evening from both sides of the project, and I'm confident that the decision to be made this evening will be based on extensive facts that we've provided you with, not hyperbole or unfounded fears of the unknown at best, or blatant misrepresentations of reality at worst. Thank you again to APC staff, and thank you, BZA members, for giving this project a fair and thorough evaluation. We are confident that after reviewing what's before you, that you'll recognize that this is a good project for Tippecanoe County. With me tonight are representatives of GeneX and RWE, as well as the following subject matter experts on the screen that will be available to help answer any questions you have. Thank you.
Thank you. I'll now ask for anyone that wishes to speak in favor of the petition, and if you could line up so that we can go from one to the next without a whole lot of delay, that would be appreciated. And please remember to sign in at the staff desk after you finish speaking. Please come forward.
Thank you. My name is Lisa Dan, and I am a Midwest Director with the Center for Energy Education, and just wanted to share a couple of key points. Currently, approximately 11 to 13% of Indiana's electricity supply is imported from other states With the number of data centers and other large power users throughout the state continuing to come online, that number will increase exponentially over the next several years if we don't invest in ourselves through additional renewable energy opportunities in our communities, which includes diversifying our utility mix. We know that utilities are becoming less reliant on fossil fuels, and as they continue to diversify their utility mix and reduce the carbon footprint, it is imperative that we become more self-reliant through these renewable opportunities. Second point, solar is now currently the least expensive energy source to produce. 10 years ago, it was a lot more expensive. Today, it's the cheapest form of power that we can produce. In addition to that, economic benefits stand out as additional revenue that these renewable energy projects provide to our Indiana communities. Our rural communities will certainly benefit from additional revenue. Another point regarding economic benefits is the increased assessed valuation that these projects create, which equals decreased property tax rates for residents. And with Senate Bill 1 coming online, this point is even more important than ever. Location of projects. Many of these developers look at rural communities with vast open areas of land close to the MISO or PJM power grids, which both happen to run through Indiana, making Indiana a desirable location for renewable energy projects. As a former economic development director in Stark County, I worked closely with developers interested in locating in Stark County due to its rural nature, flat topography, and proximity to the MISO and PJM power grids. A recent land use study was done that was led by State Representative Kendall Culp, and it was determined that the majority of farmland taken out of production in Indiana is due to new housing developments and not renewable energy projects. A utility-scale solar project will return the land to better than before at the end of its life, unlike a housing development or any other development that will be there forever. At the end of a renewable energy project, the land will be returned to farming as it was originally intended. Property rights is something else that must be considered. As a property owner, they have a right to decide what to do with their land. And then as far as the environment goes, there's nothing that leaches into the ground, as many are led to believe. Solar produces zero greenhouse gas emissions and is good for the environment as opposed to fossil fuels. So I just encourage the BZA to consider approving the special use permit to move forward with the Rainbow Trout Project here in Tippecanoe County. Your approval will promote self-reliance of our energy resources by offering a diverse mix of those resources. Thank you so much.
Thank you.
Sure. My address is 1359 Short Drive, Knox, Indiana.
Please come forward.
Good evening. My name is Alan Collicott. I live at 5219 Grapevine Drive, West Lafayette, and I've been here since 1979. So I've been a Tippecanoe resident for many, many years. And first thing I can say is, man, you guys did a fantastic job of educating me. I wasn't as convinced as I am now. And Mitch Daniels, very smart man, president of Purdue University for many years, said a wise man, when he gets enough facts, if he has an opinion, but it's different, changes his mind. So if any of your red shirts want to trade for green, they got plenty of shirts back here. It's always impossible to get 100% approval on anything. My son, when he's about 3 or 4, when we'd get a new car, new piece of furniture, especially if we changed houses, said, don't like it, don't want it, get rid of it, don't want to see it. But the adults in the room said, we need a new car, we got it. We needed to move, we moved. So we didn't listen to the naysayer, our son, But he benefited from all those things, eventually enjoying the same things that he admitted that he didn't like or didn't want. America is built on dragging the naysayers to eventually enjoy the same things. Electricity itself was not accepted 100%. It's going to kill us. It's dangerous, which it can be, but we have it. We don't like the telephone poles and the lines and the things that we see in our way, but we benefit from what happens. I don't particularly like farmers growing corn for fuel. It messed up my mower, messed up my boat. If you let it set over the year, if you've had it, it can happen. But here we are watching the Indianapolis 500 winners driving an ethanol at the Indianapolis 500, and I enjoy it. And I put 10% ethanol in my car today, and I use it. So we have it. But right now, those same farmers that benefited from growing corn for fuel now have to make decisions. Do I grow soybeans? Do I grow corn? I think I'm going to grow solar panels. Solar panels. Solar panels is going to be beautiful, setting in a field drawn from the sun that God gave us, and it hits the solar panels. It's collected, it's transported, and illuminates our homes, our businesses, our churches, our communities, and we benefit from it. Now, we are hitting a crossroads of needing electricity. I've been hearing that with data centers and electric cars, that we're going to need more and more and more electricity. Where's it going to come from? It's got to come someplace. How about a coal factory that burns coal or gas? How about a nuclear facility to generate electricity? I imagine we'd have some pushback on that as well. But we have solar panels that these farmers have decided to allow to be used to benefit all of us. Solar is clean, it's renewable, it's cost effective. Solar panels seen in a field with native grasses growing underneath it for 40 years is somehow going to destroy farmland. Does anybody really believe that? I don't. But history of the United States has always been dragging the naysayers along into the future. Not currently, they'll eventually benefit from the same thing that they're fussing about. Board members, don't listen to the naysayers like my son saying, don't like it, don't want it, but make the hard decision. You don't want to go down in history as saying this is bad. I think it's good. Vote yes, and that's my opinion. Thank you.
Thank you. Next, please.
How we doing? I'm Josh Rutherford. My address is 2949 North Honore in Chicago. I don't do a lot of big public speaking stuff, so please forgive me if I'm go through this and read a little bit as I'm talking. My dad Carl was on Area Plan Commission. You know, he loved that spot. He loved being in that position. And today I'm like, I wonder if he would love this. I stand before you though today as someone who was raised on the land where the panels will go. And I still consider it my home. My family has lived on, farmed, and improved this ground for nearly 70 years. It's more than soil and fences. It's our memories, our work, and more importantly, our hope to provide for our future generations. Now, I'll be the first to admit, I've never been much of an expert on renewable energy. I was raised with the belief to work hard, be frugal, and take care of what you own. But I've also learned that sometimes caring for something means being willing to look at new opportunities, especially when the old ways can't compete with the new ones. That's why I support the solar farm project proposed for this land. With panels powered by the sun, this project will generate enough energy to power 20,000 homes. Think about that, 20,000 families flipping on the lights, cooking dinner, running their business, all because of what's going to happen on our land. Something I never would have conceived to be possible. It will also bring new tax revenue into our community, revenue that helps keep our schools strong, supports our roads and services, and lightens the burden on every taxpayer in the county. And as a current resident of the tax-heavy city of Chicago, that sounds pretty nice to me. I think RWE and GNEX teams have presented a very solid plan to ensure the peaceful tranquility of living in a farming community remains. I also know they are open to suggestions to facilitate that idea. With that, let's harness the power of the sun and reap the benefits together. Thank you all for your time.
Thank you. Next, please.
Good evening. My name is Kyle Morales, 2500 North, 600 West, West Lafayette, 47906. I live on the farm where these solar panels are being proposed. I live there. My children live there. My husband lives there. My parents live there. We are local there. We have grown up there. And my cousin Josh, who many of you remember his father, Carl Rutherford, he may not live there right now, but he grew up there. The trees that were planted that the rainbow trout people have spoken about, he planted when he was a child with his dad on that land. Today, I live in the house where I grew up that is in the middle of that farm. Every time my children and I go out for a walk, every time we walk the dog, we go for bicycle rides, my husband goes for a run, we will be in the midst of where the solar panels will be located. And yet we are pro-solar. We are excited for this project. Today I work as a teacher at Benton Central High School. My children attend Otterben and BC. I'm sure that the increased tax revenue in the Benton Community School Corporation because of the proposed solar farms would be very welcomed. My mother has written about our 60-year history of owning ground in Shelby Township and how years were spent working to purchase property as it came available, with years farming and improving our wooded areas. I'm the third generation to live on the farm. My children are the fourth. Our farm is currently about half tillable acres and half forested, and it's owned by the descendants of my grandparents. Some of you may remember my Uncle Carl, who I mentioned, who served on the Area Plan Commission for years, and my mother, Katie Benson, served on the APC as a county commissioner for 2 terms. We are now 9 families, 24 people who have ownership interest in Rutherford Farms. We believe the best decision for our family's future is to lease our tillable ground for solar panels, preserving our farm ground for the next 20 to 40 years. This will allow us to keep the grounds in the family, allow us to continue to improve our woods, and we can postpone decisions about a return to agriculture or a shift to some other development. Many of the people who may voice concerns over this project are not just our neighbors, but they're also coworkers, they're also friends, they're people that I grew up with. But we have been glad that Rainbow Trout was able to increase setbacks and screening plans to help with the aesthetic concerns. We believe that the solar panels will be a quiet and clean neighbor that will not destroy the ground, but preserve it. And we think solar panels will be a better environmental neighbor than large battery storage facilities or data centers, and we have been approached by those companies as well. Solar energy is part of a solution to global warming, and we are glad that we are in a position to do what we can to help contribute to the solution. We hope other property owners will do the same, and we ask for your support of this project. Thank you.
Thank you. Next, please.
Members of the board, my name is Jamil Mansouri. I live at 4505 Hayloft Drive in West Lafayette, and I've been a member of this community since the day I was born. I'm the local project representative for Rainbow Trout Solar, and while this is my day job, I chose this work because I truly believe the argument I am making before you today. I grew up next to this project area, in a neighborhood just off of 26, biking on the county roads, and exploring the wooded area surrounding this project site. Those experiences shaped my passion for the environment, my education, and my future career. I stand here in support for this solar project because it offers us something rare: a path to conserve farmland while meeting the needs of our growing community. The choice before us isn't between solar or farmland. is between solar or permanent development. This project represents the best case scenario for farmland conservation. Unlike subdivisions, industrial parks, or commercial developments, a solar installation does not pave over soil, install septic systems, or permanently remove land from production. Instead, it keeps this land intact, preserves its agricultural potential, and through intentional land management and native plantings, actually improves soil health and biodiversity. As we all know, our county is growing rapidly. Just around this site alone, in a 10-mile radius, you have farmland being converted into subdivisions for hundreds of $400,000 or $500,000 homes, large industrial projects like the SK Hynix microchip processing plant, and once that land is gone, it is gone forever. It will never again be fertile farmland that we rely on. It will be concrete, asphalt, and rooftops. This project is different. It allows landowners to keep their land in their hands rather than selling it off to a permanent development. It gives them the choice to return the property to farming in the future, something no subdivision or industrial park can ever promise. At the same time, it delivers clear environmental benefits, reduces pressure for urban sprawl, and positions our community as a leader in responsible growth. Opponents and supporters alike share the same values: to conserve our farmland, protect our community's identity, and leave a stronger foundation for the next generation. Where we differ is not in the goal, but in the path. Solar is the only option on the table today that both addresses energy and growth needs and conserves the land for future farmers. This project embodies what responsible land use looks like in a rapidly changing county. It is conservation, it is economic growth, and it is environmental stewardship all rolled into one. I urge you to approve this project not only for what it provides today, but for what it protects tomorrow. Thank you.
Thank you. Next, please.
Thank you. My name is Cliff Sadoff. I live on 54 Knoll Crest in West Lafayette. I'm a retired entomology professor from Purdue University, and I've been living here since 1990. And I ride my bicycle through these pathways on quite a regular basis, so I'm quite familiar with the land. About 6 years ago, while I was riding my bicycle, not on this particular part, but just near County Road, the County Line Road near 800, it was an early morning. They were spraying their soybeans for soybean rust, and I got sprayed. I don't think that would happen once this development would occur. So I think that's one of the reasons why I'm supporting it. The other reason is that in my laboratory for 34 years, my students and I looked at the impacts of native plants and flowering plants on the communities of insects that they attract. And we published several papers on the impacts of these sorts of plants and how they increase the abundance of insects that feed on native plants that can attract birds and feed birds and improve wildlife. We also found that they increase many beneficial insects, including the pollinators, like the pollinator scorecard that my colleagues at Purdue put together that's being used by niches and such. So I can independently confirm that when you plant flowers, you can increase the abundance of these beneficial insects by up to 17 to 15 feet in the general vicinity. And this was measured over a 3-year period, and I can certainly be very confident in knowing that what they're going to be planting under these panels will in fact improve biodiversity and the ecosystem health. Thank you for your time.
Thank you. And please, if you can, make sure your cell phones are on silent or off. And next, please.
Good evening. My name is Sam Langley Hawthorne. I live at 2101 Cumberland Avenue, West Lafayette, Indiana. I'm a junior at Purdue University studying mechanical engineering, and I'm the current president of Purdue's solar racing team. I previously worked at the Department of Energy's National Renewable Energy Lab, which is one of the nation's leading research facilities for solar energy. Purdue Solar Racing is a team of 50 passionate undergraduate students. Many of you will hear from them today. And we work to design, build, and race solar-powered cars. GeneX has been an amazing sponsor of our team for the past since 2022, and has worked with us and allowed us to successfully complete the American Solar Challenge, which is a 1,000-mile race across the United States, which we completed purely on solar power. For our club, we have a 2-part mission statement. 1, as engineers, we pioneer innovations for solar electric vehicles. including advanced solar panels, aerodynamics, and battery technology. And 2, as a club, we promote sustainable energy, including solar power, to the Purdue campus, the greater Lafayette area, and the state of Indiana. When a freshman at Purdue comes up to me and wants to join the solar racing team, they mainly want to drive a sleek, cool-looking race car just because they think it's cool. But these students also want to live in a community that supports solar energy and inspires them to look to the future. As clubs, universities, and local governments, we have a responsibility to show young people coming to Purdue that there is a path forward for solar energy in Indiana. As students, we want to look to this community and be excited for the future. We see the value of solar energy, whether it powers our solar cars or our homes. Supporting solar projects like this one will inspire students like ourselves to pursue renewable energy careers and improve our world. So I urge you to move forward and approve this project. Thank you.
Thank you. Next, please.
Hi, my name is Tim Hines. I'm a business representative for the United Brotherhood of Carpenters of Central Indiana. My address is 709 East County Road, 1300 West. That's in Galveston, Indiana. Though I'm not a resident of this county, I represent several members in this county. I want to talk a little bit about local labor. Solar energy projects bring substantial benefits to our local workforce, especially for skilled trade workers. These are not just short-term roles, as workers gain valuable experience in fast-growing industry with skills that transfer to future renewable projects along with infrastructure projects. I represent about 200 plus members that reside here in Tippecanoe County alone, and another 300 in the surrounding counties. Not to mention over 4,000 just in central Indiana. So members that live in the surrounding counties, most of which have received solar panel training, solar panel installation training at our training facility here locally in Lafayette. So this project would put food on the table for a lot of families. It gives our local workforce an opportunity to work close to home. I know I've spent in the field days that I've driven an hour, hour and a half, 2 hours, three and a half hours one-way trip for work. So that's big to all of us trade workers. You know, we'd like to spend more time with our families and also spending our money right here, our tax dollars right here at home. So I've seen communities do very well economically with these types of projects. Some of the advantages that they receive, tax incentives that come from these solar projects, tax incentives that benefit your service members, like the guys who are keeping us safe here tonight and are out in the streets, keeping the road safe, our medical professions, our firefighters. Also, I can tell you that RWE shares the same values as the United Brotherhood of Carpenters do. They believe in paying livable wages, benefits for the workers on those projects. They believe in using local labor first. They also want to provide opportunities for the youth on these projects in these areas. And they want to partner with the communities that they build these projects in. Solar development supports good paying jobs, builds workforce capacity, and strengthens the economic foundation of your county. Thank you.
Thank you. Next, please.
My name is Michael Hoover. I live at 2906 Greenbush Street, Lafayette, Indiana. I am a union carpenter and executive board member here for Local 215 Carpenters Union. And I want to share my experience with the solar farms. I worked at the Calvary Solar Farm up north in Monon, Indiana. And to me, it is one of the best jobs I ever worked as a union carpenter. Outside of the loud working conditions, I've worked on Purdue's campus inside the halls out there, doing demo, remodel, interior system works, to even doing concrete work of how loud it is with the concrete trucks going in, coming in and out, shouting, yelling. My experience with that is as soon as I got out there, I was brought onto the quality control team and power remediation. So, and the very first thing that, when I was out there, I noticed the very first thing was they didn't start driving piles in. They didn't start doing this, doing that, loud noises. The very first thing they did was they spread grass seed out there, and hay was the very first thing. And then they started out going to the pile driving. And the pile driving, it's loud, it is, but once you get about 50 yards back, it's hardly noticeable. It just sounds like if you were driving by a car, that's it. So, and I watched it from that point all the way up to where the solar panels were put on. And I can tell you, I watched a lot of workers out there support their families and support themselves. I've watched a lot of apprentices that come in looking for work, and they also are able to support themselves just at that job because of all the money they were making and all the hard work they were putting in. Sorry, mine's drawing blank. Just got off work not too long ago, so I do apologize. I was out there for about a year and a half, give or take, and I seen all the economic revenue that it brought to Monticello and Monon with all the people coming out there. And it's, like I said, it's very, very beneficial for us because, especially coming here, I live right in town, north side of Lafayette. You know, this be 15 minutes away from the house. And when I worked there, it helped me buy my first house. It helped me support my wife, and I got a son now. I'm first-time dad, and so I earned a lot out there, and that's what helped me who I am today. So it's very beneficial for us to keep going with the work, and that's pretty much what I have. So, thank you.
Thank you. Next, please.
Hi, my name's Lucia, and I live at 346 Sylvia Street, West Lafayette. And I am currently a freshman attending West Lafayette Junior-Senior High School. And I'd like to share a short message with you today. So, a 2024 Forbes magazine headline warns that global economy will be it'll cost global economy $38 trillion every year within 25 years. And my generation will have to bear that burden. I will have to live with your decision, and the children of my generation will have to grow up with it. It's your decision to approve renewable energy matters for us and future generations. Thank you for your time.
Thank you. Next, please.
Good evening. My name is Susan Schechter. I live at 1001 Ferry Street in Lafayette. I'm on the Fairfield Township Board, and we, this summer, have had a 14-fold increase in applications for utility assistance. The rate hike from Duke and the heat this summer drove electric bills through the roof. And so we need inexpensive electricity, and we also need renewable electricity because the heat that we've had this summer, we're going to have it again. The temperature didn't go down at night. That's what's being predicted, that we'll see more and more of this. We've also had changes to our tax laws coming down the pike that will have impacts. So it may be harder to help people with their electricity. In the county, our tax revenue will be, by 2027, will be in the hole relative to currently $24 million annual revenue loss. What services will we lose in our schools, libraries, courts, jails, cities, and towns? This development will bring us not only clean, affordable, renewable energy, but will help fill that hole. Lafayette started out, you know, we're going to be celebrating the 200 and, well, an anniversary. It's long standing. We started out as a river city. People paddling on the Tippecanoe River. And then we became a canal city. And then, relatively quickly, we became a rail city. And we're still a rail city, but the highway goes through here. And so change is kind of inevitable. And we need this change of producing renewable electricity in our county. We shouldn't be beholden to Duke Electric, who takes our money and sends it out of the county, out of this huge sucking noise out of the county. And their major stockholder is Singapore Sovereign Wealth. Not only do they suck it out of the county, they send it overseas. And this project will bring money into the county, as well as providing us with clean, affordable electricity. Thank you.
Thank you. Next, please.
Hello, I'm Barbara Brown. I live at 515 North 5th Street in Lafayette. I've been a Tippecanoe County resident for about 50 years. And for 30 of those years, I lived on Division Road in West Lafayette, not far from the proposed solar project. So I'm very familiar with the area, did a lot of biking and running and hiking out there. And I have to say, I am so grateful to these landowners who are partnering to lease their land to Rainbow Trout Solar. I mean, they're benefiting, their families will benefit by, you know, keeping the land in their families, but I feel like they're really benefiting the whole community here, because we have this, you know, the opportunity to generate clean energy and improve our air quality, and Indiana's air quality is among the worst in the whole nation. So I really, you know, I'm here not just for me, but really for my kids, for grandkids. We need to think about, you know, the kind of community we want to leave to the younger generation. I mean, you know, whether we're here wearing blue shirts or red shirts, we all use energy. You know, that's the bottom line. And I think we can all agree that nobody wants a coal-fired power plant in their backyard. So I feel like the Rainbow Trout Solar Project provides us with safe and renewable means to meet our energy needs without having carbon emissions associated with fossil fuels. So I really encourage you to approve the permit for the Rainbow Trout Solar Project, and I thank you for your work on this too.
Thank you. Next, please.
Greetings, BZA members, and thank you for having us tonight. My name is Anna Sorg, and I live at 122 North Street, West Lafayette, Indiana. I am a Purdue student studying natural resources and environmental science with a concentration in climate and energy. And tonight I am speaking on behalf of the Sustainable Energy Club at Purdue University. Our co-president, Johanna Walter, was born and raised here in West Lafayette, so this issue is close to our hearts. I want to start with acknowledging the ecological benefits of this project. Farming is the pillar of our community. We all need to eat, and we all need to use energy, which is why it is important to regenerate our soil. Prior to this solar project, many fields had been row crop establishments. With this new project, the soil would get a chance to breathe and regenerate without the use of pesticides, herbicides, or tilling. Native plants, once established after 1 to 6 years, will boost the soil quality and mitigate any damage done by panel installation, according to the National Laboratory of the U.S. Department of Energy. Furthermore, findings concluded from a paper published in the Environmental Science and Technology states solar panel habitat can help improve crop production in nearby farms and fields through the increase of native pollinators. Last, I would like to acknowledge the importance of sustainable energy for young and future generations like myself and the people that I represent. As stated prior, climate change is inevitable and fossil fuels are the main culprit. Everyone needs energy, and continuing with business as usual, there will be a deficit. Sustainable solar energy is the future, and Lafayette, Indiana has the chance to be on the forefront of technology, community, and human development. Thank you.
Thank you. Next, please.
Hello, my name is Jared Svetlev, a Purdue senior in mechanical engineering on the Purdue Solar Racing team. I live at 720 Northwestern in West Lafayette. I want to thank you and make you think about what all of our work really goes to. When we make power from fossil fuels, all the work was really in producing what we burn and just throw into the atmosphere to hope that it gets eaten up by a plant eventually. But as we're seeing in rising temperatures, it's not fast enough. When we put work into nuclear fuel, it produces so much more energy, but we still have that nuclear waste that we have to bury under a mountain. When we let water run, we need the sun to lift it back up. And solar skips all that waste. We just let it sit in a field and it produces energy. And at the end of 40 years, when they start to break down, you can recycle almost all of the panel and move it somewhere else that maybe needs more replenishment. You let the soil regenerate and you move the panels somewhere else. And then I want you to think about the incentives for everyone involved. So when an industry develops in an area, what they really want is to increase their profits. They want to grow. And they want to ideally grow right next to them. They want cheap land, which means, unfortunately, they're incentivized to poison the land. When housing developers want to build more houses, they also want reduced value, which creates an unfortunate incentive to lower the prices in the area and create a worse area. But agriculture needs to maximize sustainable food production. They want the land to be useful, to produce the food that all of us need to eat. And this project aims and is required by all the work you saw to keep that sustainable future. It has to sustain the land and regenerate the ecosystem so that it's useful for all of us for whatever those farmers want to do with their land next. I want to thank you for your time and ask you to approve this project.
Thank you. Next, please.
So, my name is Kelly Young. I am 18 years old. I am a sophomore in mechanical engineering at Purdue University. I am the mechanical director for the solar racing team this year. And I don't want to take up too much of your time, but I just want to ask everyone in this room, on the board and in this room, to think critically and really consider all the perspectives in front of you, all the science and the information and the research that has been done, all the efforts that has been put into this project, and to just open your hearts and think about what is really best for my generation, future generations, and the lives of your children, your grandchildren, everyone to come. Thank you.
Thank you. Next, please.
Hi, my name is Gus Brannick. I'm a Purdue undergraduate student, my senior year in mechanical engineering. My address is 1812 Sheridan Road, West Lafayette, Indiana. I know it's getting late here, so I'll keep it short. We have a once-in-a-lifetime opportunity here to be at the forefront of sustainable energy in Indiana and can help lead the fight against climate change. Think about the years of positive, lasting impact you can have not only on the local community, but also on the state of Indiana, greater United States, and the planet as a whole. I implore you to listen to the facts that the wonderful people from the Rainbow Trout team, GNEX, RWE, and local residents of Tippecanoe County have laid out in front of you. Please, for the benefit of the local community, for your grandchildren, and for many more generations to come, vote yes on Rainbow Trout Solar in Tippecanoe County. Thank you.
Thank you. Next, please.
Hi, my name is Gavin Loyal. I'm an electrical engineer at Purdue University. I live at 253 Sheet Street, West Lafayette, and I ask that you support this project as it appears to benefit the residents of this town as well as the future generations. Thank you.
Thank you. Next, please.
Hi, my name is Kevin Chang. I am a junior at Purdue, and I live at 2963 Snowdrop Drive, West Lafayette, Indiana. And every time I hear opposition to proposals like this, I think to Plato's allegory of the cave. Now, if you know the story, you know who I think the cavemen are. So I encourage the people in the red shirts today to enlighten yourselves about solar energy and approve this project. Thank you.
Thank you. Here, next, please.
Hi, my name's Vivian Schmall. My address is 320 South Grant Street in West Lafayette. And I know we've all been here a while. I'm the electrical director for Purdue Solar Racing. And just to keep it short, I've lived in Indiana my entire life. I've seen, sort of both sides of arguments in this case. And I just hope y'all agree to support solar today. Thank you.
Thank you. Next, please.
Hi, I'm Daisy Banks. My address is Hilltop Drive, West Lafayette, and I go to Purdue University in mechanical engineering technology. I'm on the Purdue Solar Racing team, and I also ask you to support this project. Thank you.
Thank you. Next, please. Remember to sign in. Yep.
Hello, I'm Ben Sisk. I'm a sophomore and I'm majoring in computer engineering at Purdue University. My address is 1101 3rd Street, West Lafayette, Indiana. And I support solar energy, and I think this is would be a very good project for the community. And this would be something that would make me more eager to be part of the community after I graduate, like living here permanently. Yeah. Thank you.
Thank you. Next, please.
Hello, I'm Zach Tan. I live at 460 North Grant Street, and I'm a mechanical engineering junior at Purdue University. When I graduate, I want to be proud of my time here. I want to look back and understand that I had an impact on the environment and the people that live here. And I believe that project does just that. I want to be able to, with this project, be able to create renewable energy that not only helps the world, but helps the community as a whole. So that when I eventually either grow old and look back at my time when I was a young student in the Purdue and the greater Tippecanoe area, I can be proud of what I've done. I can make an impact on the people around me and with solar. Thank you.
Thank you. Next, please.
Hello, my name is Jonathan Antonov. I live at 720 Northwestern Avenue on 1st Street in West Lafayette, Indiana. I'm a mechanical engineering student at Purdue University, and today I'm actually here to give a speech on behalf of Linda Swihart, who could not be here this evening. I'm going to hope I could do the same bravado she would have wanted. I'm Linda Swihart, and I live at Shelby Township, just south of SR 26 on 500 West. I support solar energy in general and utility-scale solar power installations because of the benefits of renewable energy, no emissions, long-term returns, low maintenance, and they're quiet. Developing technologies that continue to improve in panels. I've been a student at Lafayette and Tippecanoe history for years, and rather more intensely since I retired. Lafayette was a river city and a canal city and then a locomotive city. The first trains were powered by steam generated by heating water by burning fuels. Later trains were powered by burning diesel. Hard to guess if an electric train will come through here. Times change and technologies change. A change to solar energy is a change for the better, at least as far as I've been able to learn, and I intend to continue to learn. Vote yes for Rainbow Trout. Thank you.
Thank you. Next, please.
Hello, my name is Zoe Neal. I live at 346 Sylvia Street in West Lafayette. About 25 years ago, roughly the year 2000, I and a lot of other people started to understand the kind of big picture, the mechanics of climate change, and it's weighed on me ever since that we're, maybe destroying this planet, trashing it out. And it weighs on me all the more now that I'm a father of 2 children. As soon as I had the financial means, I purchased my own solar panels. I've put them on the roof of my house. It is incredible that a system that costs like less than half of a car can produce as much electricity as our household use. It's amazing technology. It's incredible. And over the years, I've advocated, why don't we do more renewables and less fossil fuels? Why do we have to grind up the planet and burn it to have energy? And I've been told time and time again, that's not for you to decide, that's for the market to decide. Now the market has decided that a field full of solar panels is as lucrative, if not more so, than industrial agriculture monoculture. And there are a bunch of people here, I don't know, I'm guessing that the fossil fuel industry is scared and is rallying the paranoid and the gullible to ask you to interfere with the market and say no. And I'm going to ask you to let the market decide, let it decide, yes, try this out. This project is totally reversible. If at any time there's more money in farming corn, the panels can come down, the racks can move out, and the soil's as good as it ever was. Thank you for your time.
Thank you. Next, please.
Greetings. I'm Paul Brennan. I live at 131 Knox Drive, and I'm over 35. So, and what I wanted to say is that really nobody wants a power plant, well, very few are seeking a power plant nearby. But this is the cleanest option I can think of, and we need power. Ask the people in Lebanon. They need power and water, I guess. They're going to have, they're looking at a big Google search engine plant there, I guess. And in Indianapolis and elsewhere, here we're going to have a plant that produces power. It's clean, and we need clean energy. And in this particular case, we have a situation where the farmers who own this land find this to be the best economic use for their property. This is their land. Why should we limit what they can use it for in this regard? And I guess, just to keep it short, if not here, where? If not now, when? This is the time to make such an effort, and I certainly hope you approve this project. Thank you very much for your time and this evening.
Thank you. Next, please.
Hello, my name is Reed Davison, and I live in 1107 Main, Lafayette, Indiana. I may receive some moans or groans from the people behind me, but I do love them. They are my neighbor, even if they disagree. I want to first say that I believe that many of the initial concerns with the project were valid. I also want to say that the developer should have done more to communicate with the community before they started. I share a fear of large corporations coming in and not listening to the community. However, better late than never, the developer has listened to the community and responded in good faith, going above and beyond what the ordinance required. After initial contact, when concerns were raised, adjustments were made. There were fears of fire risk. The already low risk was reduced by removing utility-scale batteries. Some said that the project was too large. The developer reduced it by 22%. Others worried about appearance, so large tree species are being planted to screen it from view. None of these steps were required. They were voluntary concessions to address the community concerns. And yet every time one concern is addressed, a new one is raised. The goalposts keep moving. At some point, someone has to ask, what message does this send? We do have a moratorium, but this project was submitted before that and should be grandfathered in. Now people want to change the rules of the game while we are in the middle of playing it. If we do that, what message are we sending to the investors and developers in any industry who might want to bring projects here? The message would be, don't invest in Tippecanoe County. Don't spend time planning, working with the community, and following the rules, because the rules may change and the rug will be pulled out from under you. What kind of unstable environment does this encourage? It discourages investment and innovation. It hurts our county's reputation and our future for growth. This project has done more than what's required. It followed the ordinance, it respected the process, and deserves a fair hearing based on the rules that were in place when it was proposed. $30 million in tax revenue. Annualized, that's $860,000. This is 10% of what the county has to make up because of our friends at the State House in SB 1. I know Sheila Klinker is behind me. It wasn't her. God bless you. There would be less cuts to schools and other county projects if this were to go through. I urge you to support this project, not just because what it brings you today, but the message that it sends about Tippecanoe County as a place that values fairness, stability, and a welcoming environment for investment. And then I also have a couple of messages from people that had to depart early. May I approach to give you these? Thank you.
Thank you. Next, please.
Good evening to the members of the board and all us here today. My name is Theodore Porfiriev, and I live at 430 Westwood Street, West Lafayette, Indiana. I'm a sophomore at Purdue University. Before I begin, let me be clear. I hail from central Massachusetts, far from Boston, where fields and forests are common. My purpose here today is not to disparage or invalidate the feelings of those in opposition today, but to provide my own experience with grid solar. Massachusetts was one of the states which first and most greatly embraced grid solar power almost a decade ago now. I'm no stranger to solar panel constructions being built near my home, my roads, and my schools. I will freely admit, at first, it was bewildering. My family was scared. But then when the construction finished, the solar fields were simply that. Clean fields of solar panels, green grass, and trees, and they have been that for years now. There have been no chemical runoffs, no ugly barren fields, and no toxins. Some of those projects were even later decommissioned, and the land has returned to use in agriculture, and much of the land around the solar panels remains pristine fields and forests. Instead, solar development has contributed to my community through providing energy without smog, to my county by increasing tax revenues to pay for new roads and schools. It has given my community hope not only in the form of jobs and investment, but in a more important sense, for the hope of a planet that will be able to provide for itself without destroying our own environment, in a future for us and our children where the air is clean, climate change has been halted, and we have the jobs and resources necessary to thrive. If you approve Rainbow Trout Solar, I am confident that solar will be able to provide the same hope for your community that it has for mine. Thank you.
Thank you. Next, please.
Hello, my name is Jeffrey. I am a junior studying computer science at Purdue. I also happened to be elected president of Purdue's Climate Action Collective. And before I start, I want to preface by saying that my voice, honestly, probably doesn't matter as the people who actually live here. In a year, I'm going to be gone, and you know, I don't even live in the area that's going to be affected. I know a lot of people here were talking about their concerns of the people who actually live here, right? And I want to say that those concerns and fears are valid, even if some of them aren't backed by, you know, science or whatever studies that the company has done, right? I would still reiterate that those fears and concerns are valid, right? However, right, we're talking about the cost of climate change, right? So I know one thing that you guys were talking about was the decreasing property values, 2% to 3%, right? And by the way, I'm talking more to the room here than.
If you could please address your comments to the board.
Oh, it has to be to the board?
Yeah.
Oh, really? Okay.
It should be addressed to the board, please.
So.
And also, if you could, give your full name and address.
Oh, Jeffrey Wu. Oh, okay. I live in 3rd and West in West Lafayette. I don't know the exact number, but so, sorry. So the thing is that I understand there are concerns about the cost of what this project could do to the neighborhood. But if you really consider the cost of climate change, then it is trivial in my view, because we're talking about like states like Ohio that have dried up groundwater, in which farmers have lost entire fields of crops because of the climate change happening there, right? And so if we're concerned about like 1,700 acres here, we're going to be losing everything by a certain year, right? So, and if you're concerned about like wildlife, you're going to get, all the wildlife is going to get wiped out if you don't do something about climate change, right? I'm not even going to defend this project specifically, because I honestly, again, my voice does not matter. I do not live here. I do not get affected. And I do not know enough, frankly. I only heard about this maybe yesterday, right? So again, I will acknowledge all of that, right? I will acknowledge all of that. And yet, I still have come here, it's like 10 p.m., come here to say my piece, saying, and also like, even if you include like Louisiana, Mississippi, the Florida, the Carolinas, right? These places are suffering massively. I mean, these people are dying, right? These are fellow Americans that are suffering because of the effects of climate change, because we don't do the basic steps, right? So, and you know, of course, like even like, you know, my home state of California is burning, but you know, I understand like that might be a good thing here. You know, I'm joking. But so ultimately, my goal here was not necessarily to be on a specific, like this has to go through, but to make you understand that this is such a daunting task. Like, you know, like this is never in mankind's history have we ever had to deal with such a horrible phenomenon as climate change. And people must recognize that something like this, even if it's small, even if it won't solve climate change, if China continues, polluting the world, then this project still matters, okay? We cannot pretend that we can let other people decide how to solve the problem. I heard people saying oh, why don't they do this in Arizona? Well, we're not in Arizona. Well, let's do our part, okay? This is a global effort, okay? So I don't want to hear, any other excuses beyond that. But if you live there, then there's valid concerns. But again, all right, thank you.
Thank you. Next, please.
Howdy, my name's Colleen Curtin. My address is 1100 Michigan Road, Indianapolis, Indiana. I too am not specifically from this community, although I am really proud that I get to talk to you all tonight because I represent the Sierra Club Hoosier chapter and I get to speak on behalf of thousands of members across the state and hundreds of members in Tippecanoe County. We strongly support this project along with our hundreds of members who are residents of this county, some of whom spoke to you tonight. I'm incredibly proud of the folks who are able to do that, but I also wanted to give voice to the folks who are not able to stay here for hours and hours tonight from your own community and say that we really support this project and hope to see it come to fruition. Thank you so much.
Thank you. Next, please.
Hi, I'm Mary Ann Butters, and I live at 5392 Gilmer Road in Greens Fork, Indiana. It's the only Greens Fork in the world. Just in case you are not aware of my proud little farm town, it's in Wayne County. To help you with that, Richmond is the county seat. I'm also a former editor of the Lafayette Journal and Courier, so I certainly love Tippecanoe County, and I had to leave that position to help with my aging parents back in Greens Fork, but I still have a passion for Tippecanoe County, and when I learned of this project, I just had to come and visit with you all, because until January of this year, I was a Wayne County Commissioner, and I grappled with these very issues, with wind, with solar, with the BZA, with the APC, with the ordinances, and just sweat bullets over the wind and especially the solar ordinance that we just completed. And believe it or not, in a county that's less than half the population, we had public hearings with even more people than this. And so I'm here tonight to speak on behalf of your favorable approval for this exception for rainbow trout. And it comes after many years of deep blood on the forehead kinds of research into solar energy and the impact it would have on our county. And forgive me for this presumption, but I found after so many years here in Tippecanoe County and growing up on a farm in Wayne County that we have so much common ground, very similar. For one thing, Wayne County has a whole lot more college students than it does farmers. And that's something you certainly share with us. And we also have a lot more city and town folk than we do rural folk. So when it comes to opinions and the like, as a farmer, I found it hard growing up and being a voice of a farmer. My district that I represented was almost exclusively farmland, and my fellow commissioners were, as we call them, city boys. So I had to represent the voice of the farmer and the concern of the farmer. So when it came to matters of wind and solar, I had to be looking out for that farmer. So as we were grappling with wind and solar ordinances and especially zoning matters, we've had to do deep research. And so as I was prone to do, and being a former newspaper person, I went to a lot of counties and talked to a lot of other commissioners and professionals on the for the APCs and the planning and zoning people to see what their experiences were, and found in just a couple of my neighbors vastly different opinions and vastly different experiences, especially to our north. Randolph County is at the vanguard of renewable energy with more windmills and solar and ethanol plants than you can count. I call them very, very soft on the expansion of renewable energy. And to our west, there's Henry County that is very, very hard. The people of Henry County hate solar, they hate wind. In fact, they hate wind so much, they primaried out every single member of the county council and the county commissioners, all 10 of them, if they even gave consideration of that, of any favorable look at wind or solar. But Wayne County, I call us the Goldilocks County because we're just right. And what we did was pretty well zone out wind for all of its negative impacts, not just on agriculture, the environment, and the economic development damages that we found in other counties. But with solar, it was a completely different story. We found that all of the objections that had been raised regarding property values, well, you know all the objections. You're probably going to hear a few in just a bit.
Your 5 minutes are up, ma'am.
And so we have a very favorable solar ordinance, and I
your 5
urge
minutes
your
are
approval.
over.
Thank you.
Thank you.
Next, please.
Yes, my name is Jonathan Neal, and I live at 1001 Ferry Street in Lafayette. And I am an urban solar farmer. I have 54 solar panels that power my house and my building. And it works very well. I don't hear them. Most people don't even know they're up there. I'm here tonight because there is a war on renewables in the U.S. A nationwide war that has infested our community. Solar is the cheapest form of energy, and monopoly utilities fear losing their monopoly and being left with stranded assets. Fossil fuel companies fear losing market share to cheaper renewables. Unable to win in the free market, billionaires are fighting renewables with massive donations to politicians. They have attacked home solar. They have ended net metering. Their rates overcharge and underpay homeowners with solar. This predatory practice increases the time for payback on investments in solar. They have successfully won a wind turbine ban in our county. They want a temporary moratorium on utility solar. They don't want a better utility solar policy. They want to ban utility solar not only here, but everywhere. And they want to do this because they profit from their monopoly power generation. They proliferate misinformation. They have websites with deceptions to create fear and panic about solar, and they're very good at it. And what we see here is a flock of Chicken Littles proclaiming that the sky is falling. The sky is not falling, and remember, Chicken Little and friends got eaten by Foxy Loxy, who takes advantage of their panic. And I'm disappointed that my fellow citizens of this county have been seduced by Foxy Loxy. Foxy Loxy is a master of stoking anxiety and irrational fears of the new or the unknown. Foxy Loxy lurks in the shadows of the fear and panic we are witnessing here. Fear and panic would deny farmers reasonable use of their land. Fear and panic would deny our county and schools a significant source of tax revenue. Will fear and panic hold more sway than reality? Here's a reality check. Effects of this project on neighbors is overblown. Unlike other crops, solar farms do not generate odors from spreading manure or ammonia fertilizers. Solar farms do not spray pesticides that drift onto neighboring property or kill bees. Solar farmers do not create dust every year from plowing, harvesting crops, or create clouds of biting insects when they harvest their corn or soybeans in the fall. Solar farms provide ecological diversity of plants that promote pollinators and songbirds. Solar farms and their cover vegetation improve the soil and prevent erosion. Solar farms preserve farmland for future use and prevent other types of unwanted developments. Solar farms do not destroy farms and farmland. Solar farming is farming.
1 minute left, sir.
Solar farming is more efficient farming. Currently, the largest single use of corn is not for food, it's for ethanol production. And corn ethanol is an inefficient process that would not be here if it were not for our tax subsidies, a very inefficient use of our tax dollars. Solar farming is modern farming, the harvest of electrons from sunlight. Solar farms are the future. Do you vote for your future or will be stuck in the past? Foxy Loxy is very handsomely paid by dark money interests, billionaire monopolies that pick our pockets every day. And caving to misinformed Chicken Littles will cost our county school tax dollars and add to electric rate increases. So I encourage you to approve this project for the good of the county. Thank you.
Thank you. Next, please.
Hi, my name is Debbie Chappell. I live at 70 Robin Hood Place, West Lafayette, Indiana, just a few miles from this project, Jackson Highway area. I've been in the area since 1976, seen a lot of change in that time in our community, and I would just say change is inevitable. We need the renewable energy source, and I would encourage you to vote yes on this project for the years of work and development that have gone into it and the work that will continue to go into it. Thank you.
Thank you. Next, please.
Good evening. I'm Joe Bumbleberg. I'm an attorney. My office is in the Chase Tower, 8th floor, and I'm here tonight on behalf of Grace Benda Ernest. Grace's family settled in Shelby Township in the 1860s. She indicated to me that the first settler there was her great-grandfather, John Michael Bender. And over those years since then, the Bender family has had the farms in this particular township. As I listen tonight and study the comments that Grace gave me, I wonder if in 1936, when we were talking about the Rural Electrification Act, that there would have been people who would have been opposed to that progress. Likely there would have, but without that, where would we have been today? But in any event, Grace said to me, I oppose the solar because I've studied it and it's good. And she said, on top of that, I think that our family plan is to have ownership that will continue for many years to come. And if they induce this introduction of Greenix Solar, that family, are confident that the future of Tippecanoe County landowners has a better than even chance to continue for future generations. So on behalf of Grace, who has the good ideas, I ask you to support the solar. Thank you.
Thank you. Is there anyone else wishing to speak in favor of the proposal? Last chance to speak in favor of the proposal. Hearing none, how is the board doing? Are you ready to continue, or does anyone need a break? Ready to continue? We will continue. We'll have the attorney for the opposition, Mr. Jason Kunchme. Kuchme.
Yes.
Thank you for the correction of the pronunciation.
Yeah, I'm used to that.
And you've got 30 minutes.
All right, thank you. So again, Jason Kuchme, I'm an attorney with the law firm of Snyder Morgan and Kuchme, 4211 Clubview Drive in Fort Wayne. And I represent a number of property owners here in the county, many in close proximity to the proposed project. And obviously, I've been asked to speak against Rainbow Trout's application for special exception for the industrial solar operation. I did give you a binder before we started here tonight, or you got like 13 tabs in there, I think. Tab 1 of your binder is a list of the individuals on whose behalf I'm speaking tonight. So there's 16 people, so I don't want to be characterized as speaking on behalf of all of those in opposition, because when I'm done, there will be a number of other people speaking as well. Just by way of background, I've been heavily involved in solar issues for the past several years in probably about 30 different counties in Indiana. That involvement actually included a recent GeneX project in Decatur County, as well as a recent RWE project in Decatur County. As you know, the Rainbow Trout project is a collaborative effort between GeneX and RWE, and interestingly and importantly, both of their projects were denied separately by the Decatur County BZA, with the GeneX project just being denied earlier this month. Tab 2 in your binder actually contains the findings of fact from the Decatur County BZA for both of those proceedings. Another project I was involved in was the Mammoth Solar project over in Pulaski County. And that project initially received approval for a special exception from the Pulaski County BZA. And I filed an appeal of that decision on behalf of my clients, and the trial court agreed with my clients and reversed the BZA's approval. You know, Mammoth Solar, they brought that reversal to the Indiana Court of Appeals, which also agreed and affirmed the reversal of the BZA decision. And I've included an excerpt from that decision from the Court of Appeals at tab 3 in your binder. And that Mammoth Solar decision is important tonight for a couple of reasons. First, that decision confirms that you cannot approve Rainbow Trout's application if it is incomplete. Further supporting that legal principle is the language in your very bylaws, which plainly state that only complete applications shall be placed on the BZA's agenda, and that incomplete applications will not be placed on the agenda. In your binder, you'll see the highlighted language from the Mammoth Solar decision confirming that the requirements for a complete solar application were mandatory and afforded no room for discretion. The decision also held that if a BZA misconstrues an ordinance, there is no reasonable basis for the BZA's decision, and the reviewing court is then required to reverse that action as being arbitrary and capricious. Because Mammoth Solar failed to submit a complete application, the BZA's approval was reversed. And the result is the same here. Rainbow Trout did not submit a complete application, and you are literally legally unable to approve that application. Tab 4 includes your application requirements from your zoning ordinance. And before an application, first even before an application can be filed, there has to be a pre-submission meeting. I know council had mentioned that there was in fact a pre-submission meeting, but your ordinance requires that both the applicant and the property owners must be present at that meeting. They must be. That's the language in your ordinance. And I'm told that only the solar representatives were present, and obviously the solar representatives are not the property owners. They're leasing the property. They've already acknowledged that tonight. So therefore, right out of the gate, an application could not even be filed. Second, the application must include an approved stormwater plan and an approved driveway plan. None were filed, and that was admitted, again, tonight in their opening presentation. It's not in dispute. They said they would, in fact, provide that later in connection with the ILP after the special exception is obtained, but that's not how it works under the language of your zoning ordinance. I would direct your attention to section 4-11-14C of your zoning ordinance. It's in your packet there as well. It states that there are 9 application items, and they shall be submitted with a special exception request or an ILP application. That's the language in your ordinance. Now, notably, the zoning ordinance does not say which of those 9 items must be filed with one or the other application. And that is because all 9 must be filed with each application depending on the circumstances. Again, the zoning ordinance says or, it doesn't say and. So if a special exception is required, all 9 of those items must be included with the special exception application. Or if a special exception is not required, all 9 of those items must be included with an ILP application. They don't get to cherry pick which one they want to do now, get the approval, and maybe supply the other ones later. And remember, as I said, when you're rendering your decision tonight, if you misconstrue the ordinance, that decision will be reversed by the courts. And the next requirement for an application really should be the final nail regarding the incomplete application. Sub 9 says that an applicant shall provide a redacted version of the executed power purchase agreement, or the PPA. So again, your ordinance says shall. And as Mammoth informs, when it says shall, there's no room for discretion. An executed PPA must be provided with the application. Just like the other documents, it is undisputed that a PPA was not filed by Rainbow Trout. And one doesn't exist. Even today, it doesn't exist. At the excerpt at tab 5 of your binder, there's an excerpt from the staff report. It states that an executed generator interconnection agreement was filed as a substitute for the PPA until such time as a PPA can be provided. That's the language in the staff report. The staff report further noted that staff has come to understand that an executed PPA may never be granted for this project. And staff recommends the submission of an executed PPA to be a condition of your approval tonight. And that's just wrong, just on many levels. Neither the planning staff or this BZA can rewrite the zoning ordinance, nor can you ignore the requirements of the zoning ordinance. The commissioners enacted your zoning ordinance, and they have made the decision to require the executed PPA as part of the application. And if one is not included in the application, that application is incomplete, and it requires the denial of that application. It cannot be put on the agenda, and it cannot be approved by the BZA as confirmed by the Mammoth Solar decision. So again, the planning staff and the BZA are not at liberty to rewrite the zoning ordinance, and I would note, just to underscore that point, that the applicant did not seek a variance to get out from any of the requirements of the zoning ordinance. They just ignored it. They didn't ask for a variance. There's no application for a variance pending. Tab 6 in your binder are Plan Commission minutes from when this PPA ordinance application requirement was being discussed. Those minutes plainly state that the requirement of a PPA allows the staff to see the credibility of the solar developer at the time they file for a permit or a special exception request. Having everything lined up, it says, including the PPA, prevents unnecessary speculative activity, so when someone is going for a special exception, they are committed to creating this solar farm. All right, so here we are today. Rainbow Trout is going for a special exception, and it has not shown the required commitment. The application in no uncertain terms requires that executed PPA, and again, it does not exist. It wasn't filed with the application, and again, the staff report noted it might never exist. You know, they don't have the liberty, they can't say, oh, we're going to accept the GIA instead. That's not what the ordinance says. They can't rewrite the ordinance. They have to just apply the ordinance. So because a complete application was never filed, I would say you have no choice but to deny the request for special exception. You know, you're going to hear, when I'm done talking, from a lot of intelligent and a lot of passionate people when I'm done talking. And they're going to walk through each of the requirements for approval for a special exception, and they're going to show how Rainbow Trout has failed to meet its burden. And again, it is Rainbow Trout's burden to meet any of the elements. They didn't meet any of the elements. The speakers in the public comment will forge the path, and they're going to give you what you need to do the right thing, which is to deny the incomplete application and to protect the 420 homes that are located within 1 mile of this proposed project, and to protect other nearby homes, and to protect the county. You know, there's a reason the commissioners enacted a moratorium on solar. And rainbow trout's failed attempt to sneak in before the enactment of that moratorium should be rejected tonight. And before I yield any of my time tonight, there are some other additional important topics that I want to touch on, just given my experience. Tabs 7 through 10 of your binder contains information confirming the negative impact on property values that are associated with these industrial solar projects. Tab 7 includes written statements from a number of Indiana brokers confirming their actual experiences trying to sell homes near solar developments. Those statements confirm canceled showings, refusals to view properties, real-life examples exemplifying what I believe to be the obvious. People don't want to live near these. And those that do, they struggle to sell their homes. The market goes away. Tab 8 contains another excerpt from that Mammoth Solar Court of Appeals decision, and it notes a finding that was made by the Pulaski County Board of Zoning Appeals, which said, "It is undeniable and unavoidable that a significant number of the 220 homes within 1 mile of the proposed site would see a decrease in property values." And again, that reflects common sense. Normal folks don't want to live anywhere near an industrial utility. And the negative impact is even worse with the rainbow trout project, where there are 420 homes within a mile of the proposed project, almost double what Pulaski County saw. You know, and you can just simply ask yourself, I mean, do you want to have an industrial utility in your backyard? You know, tab 9 contains a summary from an MAI appraiser of several peer-reviewed studies regarding the impact of industrial solar on neighboring property values. And those studies include several different universities, and across the board, those studies confirm what the local realtors found. There is a negative impact on property values. Tab 10 contains some slides that were used in a hearing in Bartholomew County on a solar application. And just like in Decatur County, that solar application was denied by the Bartholomew County BZA as well. And Jeff Hillicord, he's a real estate broker in Columbus, Indiana, and he spoke at that proceeding, and those are his slides. He reviewed the report that was prepared by Kirkland Appraisers, which is basically the same report that was given to you as part of the application for rainbow trout. When Mr. Hillicord spoke, he confirmed that the Kirkland report does not paint an accurate picture of the studies that he references in his report and those that he relies on for his conclusions. For example, the Kirkland, he stated that a Lawrence Berkeley National Lab study found a 1.5% impact within a 1 mile of a solar farm as compared to homes within 2 to 4 miles of solar farms. But what Kirkland neglected to say is that that same report stated for homes within a half mile of a large-scale photovoltaic project compared to homes 2 to 4 miles away, they found a reduction in home sales prices in Minnesota of 4%, North Carolina 5.8%, and New Jersey 5.6%. And that same study also stated that their results suggest that there are adverse property value impacts for homes close or very close to an industrial solar farm and those predominantly in rural agricultural settings surrounded by large projects, specifically in rural areas where the solar project displaces agricultural land uses and are larger projects. Kirkland's report also references postdoctoral research by Nini Abishidze, so my best chance, I know my name gets butchered as well, and her report was entitled Utility Scale Solar Farms and Agricultural Land Values. But Kirkland failed to reference that same individual's 2019 doctoral thesis entitled Solar Farms and Residential Values in North Carolina, where she analyzed 15,935 transactions and concluded that construction of a solar farm decreases property values of houses within 1 mile of a solar farm by 8.7%. She said the effect increases to 12.5% if those homes are within a half mile. And there's just many other examples of the Kirkland report cherry-picking favorable statements and disregarding statements and conclusions that in fact found a negative impact And if you actually do a true evaluation of his own sources, they would support a conclusion that there is a negative impact on property values. Now, aside from property values, these industrial solar developments do not really benefit local communities, as is often suggested, and frankly, as was suggested tonight. Solar companies' own experts in cases that I've been involved with have admitted, they've admitted that their projects will result in a net loss of jobs in the county. You know, once these are up and running, you don't even need one hand to count the number of new jobs associated with that utility. They told you what that is tonight. It'll create between 3 and 5 jobs, they said. But on the other side of that equation, when you take out large amounts of farmland out of operation, that results in significant job loss, among other things. You have less farmland equals less sales, equals less seed, less fuel, less labor, less taxes. It goes right on and on. And these losses are significant to a community, and they frankly outweigh any perceived benefit. You know, tab 11 in your binder is a study that was done by a Michigan State University professor confirming the negative direct, indirect, and induced effects of these industrial solar developments in the millions, many millions of dollars. I mean, these projects are not the panacea that the solar companies make them out to be. And I've been contacted, to be honest, many times over the years by leaseholders regretting their decisions once construction starts and asking, can you help me get out of this lease? And you're also, tonight, I know some of the speakers, you're going to hear statements from them about some of the troubles that other counties have experienced after approving some of these projects. Some of the other common things I hear in the BZA proceedings, and frankly, I've heard them tonight, is that you can't tell the solar leaseholders or other people what to do with their land. Okay? Obviously, you know that's not true at all. That's why we have a zoning ordinance. We separate incompatible uses, and we place restrictions on certain developments in order to minimize the impacts on neighboring property. And the impacts of industrial solar are significant. Now, that's why you have to consider, you know, the criteria in your zoning ordinance, and that's why you can't approve the application if even one of those requirements is not met. You know, I also hear arguments that, you know, solar is good for the county. It provides money for the county. And again, we heard it again tonight. So I've been in 30 counties, and it gets a little repetitive, some of the arguments that we hear in favor of the projects. You know, there's no economic development agreement in place with Tippecanoe County, and I'm not aware of any conversations with the commissioners in that regard. So I think right now, any statements made in that regard are just speculation. But regardless, the question is not whether the county is going to receive $10 or $10 million in its coffers. The issue tonight is only whether a special exception should be granted, and that is a use issue. And you are to consider the special exception criteria only in addition to the question of whether there was a complete application. I mean, should we even be here tonight? Which, as I've discussed, the answer to that is no. You know, another common talking point, another one that we heard again tonight, is the suggestion that this project will allow the farmland to rest, and then we can return to farming after the decommissioning and pretend like nothing ever happened. Again, not the case. And I've included supporting materials in tab 12 of your binder. In fact, the Virginia Department of Environmental Quality stated that once altered, its prime agricultural soils and forest lands cannot be restored to prime productivity. And those documents, there's plenty of citations regarding drainage issues, flooding and property damages. There's discussion of soil structure change due to the compaction in these projects. And there's plenty of discussion as well on the loss of fertility. There was even reference in tab 12, there was a study that was done by a soil scientist in Kentucky. And so he did a study where land was allowed to remain fallow for 10 years. And he compared it to land on the same property that was actively farmed for those same 10 years. The fields were then cropped identically for 4 years after, and even with nutrients added, according to soil tests, the formerly idled land lagged far behind the continually cropped land. So you cannot just pull the panels and the other structures out after 40 years and pretend everything will be the same. It won't be. And frankly, there's a reason why many counties in their zoning ordinances are putting limits on the number of acres that are available to industrial solar. certainly is something I hope you would consider, the Plan Commission and commissioners would consider when they amend your ordinance. And then really the last point I want to touch on is your comprehensive plan. Your comprehensive plan has the objective of preserving prime agricultural land. It says we want to promote only development that is compatible with the soil type and the drainage patterns. It states that prime farmland is protected by discouraging development in the areas characterized by highly productive soils. Your comprehensive plan states that without disturbing our best agricultural land, quote, which is protected by the rules of the decision-making model, we still have enough land with strong development potential to perhaps triple our population. And there are just numerous other references all throughout your comprehensive plan, all about protecting ag land and preserving it from development. In tab 13 in the binder in front of you, I've included pictures from 2 solar projects in Indiana. The first page, that shows you a picture, I believe it was in construction phase still, but of the substation and what that's going to look like. The second and third pages, they show you rows upon rows of the racking and the panels, again, of a project that's still under construction. And the remaining photos in tab 13, those show a project in Stark County, Indiana, in Knox, just where I think you had the other speaker. She said she was from Knox as well. That project, you can see in that first photo, literally shows the complete removal of the topsoil. It shows the flooding on the project. And it just gives you like a really good sense, I think, for the industrial nature of this development. This isn't all pretty flowers and butterflies going around there. This is an industrial solar plant, a utility. This is not protecting agricultural land. This is not preserving agricultural land from development, as your comprehensive plan requires. This is hundreds of thousands of giant solar panels, substations, cables, inverters, and everything else that goes with it. And these are not temporary. 40 years is not a temporary use. Certainly the Decatur BZA found that it was not, and I'd like to hope that you would have the same common sense. In this project, I had noted before, may possibly include the dangerous battery storage. I know council indicated tonight that the project will not, but I do know that battery storage was referenced in the generator interconnection agreement, so I'm not sure what to believe, but I assume maybe they pulled that out of the plans. But I also haven't seen a plan or anything firm, but there was reference to agrivoltaics somewhere in the materials. And that same thing was argued and rejected in Decatur County. If you do the sheep grazing, is what they were trying to do, saying, oh, it's still an ag use. We're going to have sheep walk around and eat the grass. Again, Decatur County said it doesn't make it an ag use. It doesn't preserve the ag land. And as they found, 40 years of industrial solar is not a temporary use. So I want to thank you for allowing me to speak tonight. And as I noted, you're going to receive a lot more information regarding the deficiencies and the negative impacts of this proposed project. And you will also receive information, again, on each of the special exception requirements and why those requirements were not met. So in the end, we would ask that you please deny the application, let the county address the solar ordinance and establish better regulations, standards to protect both the county and the residents. So I would thank you. And then just as an aside, my clients did ask me if you would consider reducing the rebuttal time by 9 minutes. I think council exceeded the 30 minutes that we had discussed. So thank you.
Thank you. Those wishing to speak in opposition?
Already there.
Okay. And if people want to line up like those before, they'd be appreciated.
Is it good for me to get started, or? Yeah? Okay, awesome. I am Dr. Nicole Dutlinger. My address is 511 Kerber Road. It's just right outside the quarter-mile radius of this project. Tonight, you're going to hear from many concerned residents. All of them are wearing red. This was not a political statement. This was the color used for stop signs. We want you to know to stop. Stop this project. and do the right thing tonight in your vote. We are not against solar energy, but we are against industrial scale projects that fail to meet the requirements for a special exception. From the start, the county mishandled this application. On May 16th, APC staff accepted a filing that used the word preliminary 49 times in just the first 18 pages. Rainbow Trout admitted more information was needed, but never provided it. There's no such thing as a preliminary application in zoning law. Applications must be complete, yet when we raised this issue, staff brushed it aside. The APC Executive Committee also failed to apply comprehensive plan standards used in past cases like the Rogers Group mine. That project was carefully scrutinized against the plan's land use factors, but this project did not get the same scrutiny. The comprehensive plan states that land uses should consider local soil characteristics, should account for drainage and flooding characteristics, and should protect the rural agricultural areas from damage. In June, the county commissioners enacted a moratorium on large-scale projects, recognizing the ordinance is insufficient to protect the public. Yet, Rainbow Trout pressed forward. The staff report before you tonight contains inaccuracies and some political advocacy. This is in no way a comprehensive list, but some of the worst. It claims ordinance requirements are met, though the application itself says otherwise. It claims the buffer yard is sufficient, though it fails county standards. It claims noise will not be a problem, while admitting it will reach 49 decibels overnight, which is an ordinance violation. It suggests requirements are met to the best of their ability, but zoning rules must be met in full. Staff further admits the petitioner may never secure the required power purchase agreement. Instead, they point to a build, operate, transfer contract, or even an unenforceable attorney email. That is not compliance. It is an attempt to rewrite the ordinance. Most troubling, the staff report argues that cropland must be sacrificed for climate change concerns. That is political lobbying, not technical analysis. The role of staff is to apply the UZO and the comprehensive plan, not substitute personal beliefs. Most special exceptions, like ag halls and Airbnbs, aren't driven by outside political views. When reviewing a special exception, you are required to limit your considerations solely to if the proposed property use does or does not harm neighbors. This should be no different. Views on larger issues society is facing or the way the community should progress belong in the comprehensive plan and not in one-off special exception votes. Just as judges should not legislate from the bench, staff should not be asking you to rewrite ordinances or comprehensive plans at a special exception hearing. Over the last decade, you have denied about 20% of applications. Denying this one would be consistent with those past decisions and with other counties that have rejected industrial solar use until stronger protections are in place. This project does not comply with zoning rules, undermines the comprehensive plan, and sacrifices prime farmland. For these reasons, we respectfully ask you to deny this special exception. Others will now address the ordinance requirements, community impacts, and threats to health, safety, and welfare. At the end of each presentation, there will be a ballot slide demonstrating which voting factor the speaker covered. Thank you so much for your time.
Thank you. Next, please. And if you could please sign in, please.
My name is Byron Jenkinson, and I live at 5224 West, 350 North, approximately a half a mile from the proposed project. I'll be speaking to ballot factor 2 this evening, which requires you to determine if the requirements of the UZO will be met by this suggested use. The UZO defines prime farmland, and you've heard that from our lawyer, but it comes in section 225(1). I'm not going to say any more because I'd just be repeating myself. I have a PhD in agronomy. My research was involved in landscape hydrology and soil development. My experience makes me certain that this project in this location is a bad idea. My concern starts at ground level and below. As the soil is classified according to its characteristics, and these predict its highest use, these soils are poorly drained and have high water table, but they are very deep, fine textured, and will hold water and nutrients well. This combination makes this agriculture the highest and best use. When these soils are properly drained, they are considered prime farmland. If soils cannot properly drain or are disturbed, they lose this prime status. A soil is a very delicate ecosystem. As you can see on the slide, even over a county drain, which is in the ponding there, this soil has high water tables, sheet erosion, rilling, and ponding. About 72% of the soil in the project area have high water tables that drain very slowly and for extended periods of time. Staff report about the project indicate that soils would get a break from tilling during this project. But this shows how little they understand about this area, because the farmers already use no-till practices for this delicate ecosystem, and they've been doing that for about 20 years now, because they understand the prime farmland they have is very sensitive. Soils in these areas also are easily compacted. The rutting caused by heavy equipment will promote erosion due to channeling of water, and the compaction will also damage subsurface features, or the drain tiles we're talking about. The petitioner has repeatedly claimed the prime farmland will be returned to its original status at the end of 40 years. Nothing could be further from the truth. It is simply not possible after construction, operation, and decommissioning to restore the soil biome to its current state. These two figures show the landscape and how it will be altered. The grading effort that will be done will be changing the contours of these fields dramatically. In addition, the stockpiling of soil is a senseless and destructive process. Topsoils are live ecosystems. Stockpiling ensures the killing of microorganisms, earthworms, and other soil species, and the gradual loss of all organic matter. This project would destroy the AA characteristics of the soil and would injure non-participating tracts. You must vote on ballot factor 2 that this use will not meet the standards of the UZO because it will destroy this land and the adjacent land as prime farmland. Nature has given Tippecanoe County two great gifts: good soil and plentiful water. We must protect them. Please vote no on this project. Thank you.
Thank you. Next, please.
Good evening. My name's John Aid. I live at 8640 West, 125 North, West Lafayette. I'm speaking on ballot factor 2. Again, it's the UZO comprehensive plan, specifically the section 2-52-2 of the plan. Both states' prime farmland should be reserved for a wide range of agriculture activities, and the homes primarily of those engaged in such activities. As you can see from the picture where I'm located, our farm was established by my grandfather in 1909. Over the years, it's primarily been used as a grain and livestock farm, which is part of the comprehensive plan and AA designation envisioned it. I've had the opportunity and been blessed to work in agriculture for the last 45 years. We've lived in 5 states. In Australia, I managed grain processing as well as domestic and international trading with over 6,000 farm customers. I can credibly say the quality of agriculture, land, and soil are not all the same. This land stands out for its high productivity. My wife and I might have retired, but I still run a 200-head registered cattle business with breeding stock that I sell throughout the United States. This brings me the reason why I'm here to talk to you today about the concerns of the Rainbow Trout Solar Project. It will surround 3 3/4 of my farm and property. My business is integrated to our cropland, relies on the protection of your UZO comprehensive plan provided for AA land. If you don't maintain the rural agriculture areas surrounding the home and the farming operation, you will cause me direct financial harm, and let me explain. As you can see, my home, cattle, and cropland are all going to be surrounded on 3 sides by this solar installation. I'm already experiencing flooding and ponding after a heavy rain. That was in April this spring, the only 2-inch rain we had. And recognize that starting of the soils, excuse me, and recognize that these issues, many of these soils are susceptible to flooding and ponding. North Carolina State study showed in Madison County, Indiana, a solar site that showed a concentrated water level leaving the site to be 29% faster in terms of velocity and force from the panels that were installed over that ground. There is no way you're going to surround my property with industrial scale construction for 2 years, not making flooding a worse problem. In addition to the flooding, once installation is complete, I'll face a heat island. Research has shown surrounding areas of solar fields can see an increase of temperature 5 to 7 degrees. I use my Indiana location to develop my breeding bulls and my top females for sale. Oklahoma State research study shows that breeding cattle, when increased temperatures during the summer, that will affect their breeding and conception, and it will only exacerbate my problem that I have, will have a negative impact on my cattle business. Aside of the impact on my cattle business, there will also be the personal impact on my home. Research provided by Mary McClinton Clay of Paris, Kentucky, a licensed appraiser, has documented several different real estate transactions, has recorded a range from 5 to 40% decrease in value directly surrounded by a solar farm. This could cost me over $200,000 on my operation. Use common sense. Why would anyone want to buy a piece of property that's surrounded by 3 3/4 side? I understand owners believe that they have a right to manage their land the way they see fit, but that does not give them the right to damage their existing neighbors. To bring 2 years of construction, earth-moving machinery, pile pounding into our neighborhood is clearly a destructive and unfair burden to our community. We'll talk about additional risks with the other people. The UZO comprehensive plan states AA land should be preserved.
1 minute to go, sir.
And families who engage in this activity don't jeopardize the guarantee to me. It also denies the decrease of real estate value, financial and business, and peace and comfort where we live. Therefore, you need to vote against the factor 2 and substantially subvert the ordinance on ballot 3. Thank you.
Thank you. Next, please.
Good evening. My name is Steve Shelby. My wife and I live at 9131 West, 125 North, about 1,200 feet adjacent to the proposed solar installation. We're one of 440 homes with almost 1,800 people who will be affected by this project. But before I go on, one quick thing. I think it was wonderful the opposition had 30 people come up here and speak about the project. But if you noticed, of the 30, 2 were from Shelby Township. 2. This photo shows where the solar farm will be next to my property. My family has owned and farmed this land since 1828. The Little Pine Creek winds through my front yard, and both my home and farmland will be damaged if drainage is mishandled. I'm speaking tonight to ballot factor 2, section 4-11-14C2, that requires an approved stormwater plan, and section 4-11-14C5 that requires necessary governor approvals at application. You know, I was taught in school that when a deadline came in and I had to submit my information, it was a deadline. You couldn't submit information after the deadline. On page 15 of the petitioner's submittal, they admit their stormwater plan is preliminary and that local, state, and federal approvals have been or will be received. Nothing has changed since their May filing. That sounds incomplete to me. Because this soil floods easily, a proper stormwater plan is essential. Farmers like my family have spent hundreds of thousands of dollars installing and maintaining drainage tile to carry away excess water. These tiles run throughout the project and surrounding farms. A July Purdue Exponent article about the project said posts will be used to support the panels and will only harm tiles directly below them. Well, GenX site plan shows 60,000 posts will be pounded 6 feet into the ground, and these posts will easily hit and damage private tile that are only 3 to 4 feet underground, which attach to the Bender ditch for drainage. Damage to some tile is damage to all tile, and that affects the Bender ditch's ability to drain large quantities of surface water. GenX's submission shows the need for 53 water retention ponds. On page 301 of the stormwater plan, they claim grading will be minimal and drainage patterns won't be altered. But anyone who works these fields knows that heavy equipment, internal roads, and support structures will absolutely disrupt drainage, and no one can change the county watershed. Additionally, the most recent plan shows they plan for the underground cable connecting the 2 sections of the project to go under 2 streams, but there is no proof that they have secured required federal or state approvals to trench power lines underwater. On page 754 of the application, Stantec identified 7 wetlands and 24 streams with the project, 13 of them potentially jurisdictional. On page 762, Stantec recommended a U.S. Army Corps of Engineers jurisdictional determination under Section 404 of the Clean Water Act, and possibly a nationwide permit if wetlands are impacted. There is no evidence that GenX has supplied these approvals. You know, the drainage and wetland problems aren't just important because the ordinance requires them. They are important because my property will be seriously damaged if drainage and runoff isn't properly managed. If these issues are not properly managed, there could be extensive flooding and substantial silt runoff into major waterways. If the panels are damaged by hail or wind, their toxic content will leach into the soil and contaminate the nearby Little Pine. My well, my neighbor's wells, and the Taze Aquifer, from which all Tippecanoe County draws its drinking water, could be contaminated and become a Superfund site, costing the county millions of dollars. For that reason alone, the special exception should be turned down. Poor drainage management has caused environmental violations at solar farms elsewhere, such as in Hopkins County, Texas, where an 1,800-acre solar farm caused severe runoff problems. The Texas Commission on Environmental Quality and the Sulphur River Basin Authority cited the contractor for failing to control damaged wetlands. This isn't an isolated incident, as seen by the headlines like these that seem to appear on a regular basis. Approving this project without a finalized stormwater plan and a federal permit risks the same outcome here. GenX's stormwater plan also ignores the issues created by installing over 15 miles of gravel roads 18 inches thick. These photos from the White Solar County Farm, GenX does not have any roadway ditches or road drainage plans included in their submittal. Roadways, heavy equipment, and 60,000 posts that damage private tile will cause flooding. Drainage is an issue. This is a picture of my front yard after a heavy 5-inch rain. Now, fortunately, it drains off quickly because of the Bender ditch today, but it won't happen if 60,000 posts crush private tile, overflowing the Bender ditch, flooding my fields, and retaining all that water in my front yard. This project has been developed by a Purdue professor, this projection, showing that what will happen if drainage patterns are disturbed. The damage from the project would cause huge sections of the solar farm and the facility to revert to the former wetland conditions. My family's fields and my neighbor's fields will flood, reducing yields and land value. For ballot factor 2, I urge you to find the project will not meet the ordinance requirements because the stormwater plan is incomplete and the necessary approvals are missing. Thank you.
Thank you. Next, please. Need to sign in.
All right, mine comes with a handout. My name is Joe Soborowski. I live at 938 Shepstow Lane. I'm a professional pilot. I flew for the United States Air Force. I was an Air Force liaison to the FAA. I have no clue what drainage tile is. I don't know anything about farming, so I learned a lot there. But I do know about airspace, and I know about aircraft safety. So if you take a look at the handout you were just giving on the first page, this was a map provided to me by the APC staff, and it shows what the county considers an airport district. You'll see that what follows the approach path, the precision approach path, the 1-0, is a funnel that extends out beyond 7.5 miles and is over 3 miles wide. Okay, that's the airport district. You'll also notice that the proposed project falls within the airport district. If you turn to the next page, it highlights the ordinance requirements for land use within airport districts. One of the most striking ones is that no use of the land within an airport district shall result in glare in the eyes of the pilot. Okay? So now, I'm a pilot, and I appreciate that. And it sounds, you know, it's important to kind of take this in perspective, right? What's the rationale for this UZO, right? So I took a look at the aviation safety reporting system and took a snapshot of some of the data. Here's a snippet of solar farm glare and the hazard it caused. An airline captain, so a professional pilot flying people like you, me, our loved ones, on approach reported the solar panels reflected the sun like a mirror, creating blinding glare worse than a laser, causing confusion and distraction. Another airline captain on an approach reported solar farm glare equal to a green laser that left blinding spots for an hour. The crew reported missing their approach checklist on that approach because of distraction. Another airline crew reported that glare from a solar farm forced a go-around from an unstable visual approach. An airline captain reported that glare hazard from a solar farm had only two safe solutions: fly at night or shut down the solar power plant. This isn't just airliners. A small aircraft pilot reported glare from a solar farm forced a pilot to lower their seat to block the light, but this eliminated their forward view and their ability to scan for traffic. Another small aircraft pilot reported that on departure, the pilot had to abandon visual scanning and switch to instruments because of glare from a solar farm. Okay, this is not hypothetical. There was a recent news story at one of Europe's busiest airports in Amsterdam, Schiphol Airport. They had to file a lawsuit and get a court order to have solar panels removed from a solar farm because of the glare hazard that was caused on aircraft on approach. You can look that up. So that leads me to, okay, this is a real hazard. The ordinance says no glare. Looking at the glare study provided by the petitioner, you see that says no glare. But they don't look at the airport district. And they don't have the appendix that has the additional information to support their no glare analysis. So I bought the software and did the glare analysis myself. If you turn to the next page, you'll see the FAQ from the glare analysis software. The first thing it says is photovoltaic PV modules can reflect more than 60% of sunlight. It can be 10 times worse during sunrise and sunset. If you flip the page over, you can see the glare analysis from the glare analysis software using the petitioner's own parameters that says anti-reflective coatings. You see that it's estimated to have 28,850 minutes or over 480 hours of glare in pilots' eyes. And that's only one path in this small, right? So that's a very small path for that entire cone. Now, the ordinance is pretty clear. Glare in airport districts is not allowed. All right? Pilot reports prove this is a real hazard. You can check that out. And the glare analysis, the tool, the part that they left out, shows that glare will occur in this location. Okay? That means this project fails your ballot factor 2 because it cannot meet the glare prohibition of UZO 53. It also fails ballot factor 3 because it subverts the purpose of that ordinance, which was solely put in to protect pilots, passengers, people that live in airport districts. It would be completely irresponsible to disregard these protections. Thank you.
Thank you. Next, please.
My name is John Evans, and my family and I live at 952 Kerber Road. So to give you a little bit of context of where we are in terms of the solar project, you can see our house there and the proposed project highlighted in red. So as you can see, we're surrounded on 3 sides. And tonight I'm going to be speaking to ballot factor 2, the UZO requirements, specifically section 4-11-14C6, which requires that an appropriate buffer yard be installed. So the APC staff report states that chapter 9-4 of the UZO does not provide any guidance on what type of buffer yard is required for this type of development. And they briefly touched on that earlier in tonight. While it's true that the table in 4-9-3A doesn't state which buffer yard should be used, 4-9 does outline the only 3 acceptable options in Appendix E1. And you can see that here on the screen. You'll notice that all of these options require evergreen trees planted at a minimum height of 8 feet on 10-foot spacings. On pages 91 to 93 of the landscape plan, the petitioner states they will either use red cedar, holly, or Virginia pine trees planted at 4 to 6 foot tall on 15-foot separations. This plainly does not meet any of our section 4-9 buffer yard standards, as they are half as tall and spaced 5 feet farther apart than any of the approved layouts. Excuse me. Additionally, these trees are rated as medium to slow growing according to the Arbor Day Foundation. They will not even reach the height of the panels for 10 to 15 years. In the meantime, glare and visual impairment will harm me and other nearby property owners. The petitioners include visual renderings of their buffer yard layout and the landscape plan on pages 94 to 97, but only mention much later in the application that these renderings represent what the plantings will optimistically look like in year 5, not in year 1. If you want to see a real example of the proposed buffer yard, we just need to look to nearby White County. So, this is a picture taken in May of this year and shows the same small red cedars on the same spacing proposed in this project. As you can see, they do nothing to impede glare or visual impact, and note that half the red cedars are dead, just like the ones we brought in today. The petitioners only guarantee the plantings for 5 years at a 90% survival rate. For personal experience trying to grow a windbreak on my property, this does not guarantee an established stand and is inadequate for a project that will be in operation for between 20 and 40 years, especially considering the petitioner's own property value report that emphasizes the importance of proper screening. The petitioner submitted a landscape plan that has no provisions to replant or replace dead trees after 5 years, leaving the potential for even worse screening than what you see here on the screen for up to 35 years. Shockingly, there was no visual impact study for the massive substation by Montmorency that will be within a few hundred feet of 24 homes. There's also areas of the project with no screening at all. This plan clearly does not meet the UZO's Buffer Yard 4-11-14C6 standards, requiring a will not vote on Factor 2. You should also consider voting on Factor 3 that this project will damage public welfare because the buffer yard is not adequate to protect property values, which this topic will be addressed later by another speaker. These do not solve anything. Please reject this special exemption based on the deficiencies submitted in the buffer yard plan. Thank you.
Thank you. Next, please.
Good evening, board. My name is Clay Kohler. I live at 8511 State Road 26 West. You can see my property there. It immediately backs up to it. We have 40 acres there. Also, that is my son, George, who is medically challenged, and that's a big reason why I'm here tonight. Solar is often hailed as the cleanest energy solution, but like any large-scale infrastructure, it has its environmental trade-offs. I'll be discussing the photovoltaic heat island effect, the PVHI effect, and its implications for this project. Comprehensive research has been done that shows that industrial-scale solar raises ambient temperatures by an average of 5.4 to 7.2 degrees Fahrenheit. UZO 4-10-4C states that no heat from a furnace or producing equipment can be sensed at the zone boundary line that raises the temperature of ambient air or materials by more than 5 degrees Fahrenheit. The UZO should be applied to this industrial scale installation the same as any other industrial development. Have you guys ever visited a desert environment or stood on a parking lot on a hot sunny day? The radiant heat coming off of the ground is the heat island effect in action. This graphic clearly demonstrates that solar panels produce an even more pronounced heat island than the desert or a parking lot, with the effects felt across all seasons and all times of day. This graphic represents how solar radiant heat reacts with the environment. Image A shows a natural environment. Solar radiation dissipates through interaction of the rays with vegetation. Standing in the shadow cast by corner or the shade of a tree, you can feel this impact. Image B shows how solar panels create a heat feedback loop, heating the ground and the air above natural levels and perpetuating the effect, reflecting both heat into the immediate atmosphere and back to the surface. This feedback loop leads to a large increase in ambient temperatures the researchers have observed. The natural ecosystem and human health will both be impacted by these installations. Animals will be forced to adapt to a loss of habitat and environmental change from higher temperatures, including protected migratory waterfowl and bald eagle populations that frequent our area. Of particular concern to our family and others living in the impacted area are the loss of the ability to enjoy the outdoors due to higher ambient temperatures and lower air quality that are known effects of these industrial scale solar sites. My medically fragile son, George, his quality of life depends on a safe environment. This is a clear danger to his well-being, as higher temperatures have the ability to exacerbate his illness and others in potentially vulnerable populations. On your ballot, it's clear that the developers of this project have included no assessment of the impact their panels would have on the temperatures in the local environment. They included an assessment of noise, but the heat island effect is glaringly absent. At best, this is an oversight, and at worst, an intentional omission not to disclose the real impact on residents and wildlife in our community. The requirements on your ballot for the development standards of the Unified Zoning Ordinance will not be met, and granting this special exemption will subvert the general purposes served by the ordinance. Thank you for your time.
Thank you. Did I hear you need a quick break? If you want a motion for a quick break. We're not going to all get up, but if you can.
How long you want to go?
Just
10?
5 minutes? 10 minutes? Okay.
What do you want, 10?
10's fine. All in favor? Aye. Okay.
10:38.
See what you gotta do, right? Yep, I know what I gotta do.
Oh, wow. I need to stand up, though. You knew this one was going to be long. Well, they've got a total of 15 here. If you can get on there. But then there are others too that would be. Yeah, less than 5 minutes. I see they even had a sheriff's deputy come in just to make sure, but they've been pretty civil.
Yeah.
I mean, there are a couple of crazy people, but if we can start to find our seats. Sounds like I need to gavel again.
Yeah, give them 1 minute.
Yeah.
They're sort of slowing down, sort of.
If we could find our seats, please. so we can reconvene.
I think RWE went home.
I will go ahead and reconvene this meeting, and I'll go right ahead.
My name is Keith Johnson. I live at 1305 Ravinia Road in West Lafayette. My wife and I co-own a property, 21 Kerber Road, which is about a half mile from the industrial power plant. I'm speaking about the pollinator plant because I have professional experience in the use of warm season native grasses that would likely be included in a pollinator plant mixture. I'm speaking to ballot factor 2, the UZO requirements, specifically section 41114C7 requires that an application contain a pollinator plan certified by a registered landscape architect, a certified ecologist, or a licensed horticulturalist. To attempt to meet this requirement, Rainbow Trout submitted the landscape plan at pages 79 to 118 of their application, but this report was not prepared by a person with the required credentials. The authors were biologists and environmental scientists, so they do not satisfy the ordinance. The staff report erroneously states that the pollinator plan has been submitted, but they are flat wrong. In fact, at page 92 of the landscape plan, Rainbow Trout explicitly states that they have not prepared a pollinator-friendly seed plan, but they will do so in the near future. This plainly defies the ordinance and must lead to denial. The landscape plan is also meant to address section 41114.8, which requires the area to be planted and maintained free of all invasive species. I will also say, with the beautiful trees next to me, that this particular plant, the red cedar, is an invasive plant in many, many states on the type of land that this native species would be utilized for in pollinators. So take that into consideration as well. In fact, at page 92, that they will do so in the future. The landscape plan is also meant to address section 41114.8, which requires the area to be planted and maintained free of all invasive species. Based on my expertise, I strongly disagree that the plan guarantees successful native plants or an area free of invasive plants. For example, they say they will only actively manage the internal vegetation for 5 years by mowing 1 to 2 times per year and applying herbicides, but this would never be adequate to keep out all invasive weeds. It is also unclear how they plan to apply herbicides to such a large area with such tightly packed rows of panels. A backpack spraying is not going to get the job done. Occasional mowing does little to stop honeysuckle, Canada thistle, autumn olive, pokeweed, poison hemlock. Untimely mowing will also reduce full pollinator-friendly benefit potential from native grasses, legumes, and forbs, as mowing removes the flowers that attract pollinator species. If mowing occurs in the time frame of April through July, many young birds and their nests will die. Additionally, beyond suggesting 3 possible types of trees for the buffer area, the plan has 0 detail about other internal or external plantings. We cannot even begin to assess if there is a possibility the offered plants will thrive and will suppress invasive species with the scarce information provided. Finally, during construction and decommissioning, the fields will be entirely pollinator hostile as the land will be barren. For all these reasons, you must vote that section 41114C7 and 41114C8 will not be met.
Thank you. Next, please.
Hello, my name is Greg Erzman, and my wife and I live at 441 Kerber Road, West Lafayette, Indiana, about 400 feet across the road from where this planned development is going to happen, if voted for. I'm addressing factor 2 on your ballot about if the project meets the OOZO requirements. As our attorney has mentioned, the application lacks a PPA. This omission is not excusable. Staff's desire to dismiss this requirement as one of mysterious origin cannot be taken seriously. During the November 2020 ordinance drafting process, Rubita Fola and Sally Fahey described their PPA requirements as follows. Rubita and staff is requiring that the applicant provide a power purchase agreement. The requirement of the power purchase agreement in this phase will allow staff to see the credibility of the solar developer at the time they file for permit or a special exemption request. Sally Fahey said the whole concept of a special exception is that the last approval need prior to obtaining a building permit. To have everything lined up, including their power purchase agreement, is the last step in making sure that they are ready to go from the special exemption immediately to the building permit. This prevents unnecessary speculative activity, so when someone is going for a special exemption, they are committed to creating this solar farm. Staff's advice tonight to overlook the PPA, deferring receipt for the future, and acknowledging it may never arrive is ridiculous when examined against the drafting history of the ordinance. It's also ridiculous in light of how Rainbow Trout's application has been handled. At the time of application, Rainbow Trout indicated they had reached an agreement in the pre-meeting to give a GIA instead of the PPA. When our group pressed the issue of application completeness in late May, we were told the PPA would be a condition of approval. However, an email exchange reveals that in June, APC staff allegedly told Rainbow Trout that staff would be recommending denial of the project for lack of a PPA. Despite all of this, we are now told tonight by staff that Rainbow Trout has promised to give a PPA in the future, but that staff also has learned a PPA may never be secured for this project. The series of events is senseless and ignores the legal requirements of the ordinance. A PPA is significant because it represents a commitment to sell power to a set buyer for a set rate. With no PPA in place, there is no customer, no reliable revenue stream for any duration. Without a PPA, there is no money to cover property taxes, operating costs, lease fees, or decommissioning funds. In the industry, this is called a stranded asset. You should not follow staff's advice, and you must deny this project for lack of PPA. Additionally, as I have watched this project unfold before the county, I've been flabbergasted at the number of times the county staff has seemingly ignored rules on the books. As a business owner who has operated in this community for over 46 years, I've never experienced such leniency with the rules. On my own personal property, putting up a building to be able to house my cattle and implements was no small task, and I was not allowed leeway to skirt the rules or possibly develop something a little bit later. Oh, I'll get to it. That didn't exist. I was expected to cross every T, dot every I, and have everything in place before I came to you to see what I could get done. I simply cannot comprehend how a county who has held me to the letter of the law can now find it appropriate to overlook or waive nearly every single legal requirement for a solar power plant, or defer the issues until a later date. This is disturbing and does not align with the way others who live, work, and invest in this community have been treated. In sum, you must mark will not for the ballot factor 2 because the project does not have a PPA. Thank you very much.
Thank you. Next, please.
Kenny McClary, 942 Chepstow Lane, West Lafayette, Indiana. I'm going to focus on the decommissioning plan submitted. This is a critical requirement that must be met under the current solar ordinances. Any deficiency and inadequacy will result in the failure to assure the ordinance requirement for, quote, any agricultural ground upon which the facility or system was located is again tillable and suitable for agricultural uses, unquote. An incomplete decommissioning and restoration plan also leaves landowners with huge financial burdens, severely impaired farmland value, and possibly bankruptcy. The submitted plan does not achieve the required endpoint of farmland restoration. The cost summary form itself is riddled with errors and does not cover all listed decommissioning and restoration tasks needed. Some key tasks have zero cost amounts included. Based on multiple real-world examples, there's a huge gap in the estimates. The first clue is the inadequacy of the total of $8 million that was submitted to you. It represents only 5% of the $160 million cost of installation. Industry and government references expect decommissioning costs to be between 20 and 30% of original value, depending upon the restoration objective for the land involved. This slide shows the summary of the major errors and omissions. The petitioner used optimistic, inappropriate, and incorrect cost assumptions on waste disposal. Hope is not a plan. Wishful thinking doesn't make real costs disappear. As you can see in the detail sheet just passed out, equipment counts were wrong, gravel and topsoil costs were underestimated, restoration costs were not included. Once all tasks described in the plan are accounted for, the total cost will be within the range of 50 to 60 million. This corrected estimate does include 10% contingency amount to cover county infrastructure repairs, another big omission in the submittal. A similar cost estimate can be reached independently using the U.S. Department of Energy's National Renewable Energy Institute estimate of decommissioning costs per megawatt hour of solar power facility. Note that in 40 years, this cost will rise to 165 to 198 million. The petitioner has a battery energy storage system in their interconnection agreement. It's there. The solar ordinance specifically requires the decommissioning to include any other associated facilities. Therefore, the additional cost for removing BESS facilities must be part of the total estimate. 25 to 35 million additional is needed for BESS decommissioning. These estimates for closing BESS facilities range widely. They would predict external would between a range of 26 to 80 million. The 25 to 35 million we have estimated and provided here for you is at the low end of that range. Added together, total decommissioning costs are between 75 and 95 million. The low original cost summary submitted to you was totally unrealistic and unfounded. The petitioner's estimate was off by a factor of 10. To summarize, this project fails to meet the requirements of UZO 41114D. The proposed amount will not make the land returned again tillable and suitable for agricultural use or achieve the ordinance obligation to restore it to substantially similar conditions that existed immediately prior to construction. That's from the ordinance. The unfunded amount submitted will create a huge financial liability and loss of property value for the landowners. It provides no funding to repair the county infrastructure or private field tiles. It demands the question, who will pay the difference? Protect property owners in the county from harm. Do not let your legacy as a Board of Zoning Appeals be that you were the group who approved the project that created an unfunded liability of over $50 million and a future $150 million liability in this county. Item 2 on your ballot tonight requires you to deny a project that does not meet the solar ordinance requirements. Deny this special exception. I count as one of the property owners mentioned here tonight, the Benson family, as my very good friends. No matter what the outcome tonight and what your vote is, I will still count them as my very good friends. For Katie and Dave, I'm up here tonight to defend them too. This decommissioning plan sets them and their heirs up and the other property owners with huge unfunded financial liabilities.
1 minute,
I'm approaching this project tonight for all of them too. Thank you.
Thank you. Next, please. My name is Kevin Trumbull. I'm speaking for my wife, who's feeling ill this evening. We live at 501 Kerber Road. The solar project's about 1,200 feet from our house, at the end of our driveway and across from our mailboxes. I'm speaking in opposition to the project based on incomplete and insufficient decommissioning plan. You've just heard how severely underestimated their costs were. The petitioner has also failed to indicate the type of surety they will use. 2 forms of surety are included in the Unified Zoning Ordinance: performance bonds or a surety secured by deposit. Only an irrevocable surety secured by deposit can be allowed for this type of facility in amounts that protect county taxpayers and property owners from the risk of an operator abandoning or walking away from the installed facility. Here are the hard reasons why. GNX LLC is only the developer. RWE is only the capital source. Both are wholly owned LCCs, parent companies based in Europe. The construction firm is unknown. but we already know that the construction process will cause significant physical damage to land, drainage, and roads. The final operator owner of Rainbow Trout LCC is unknown. As we now know, all the business assumptions of foreign solar developers in the U.S. have been totally changed by various actions taken by the U.S. federal government, Department of Energy, and the Department of Agriculture to eliminate solar subsidies and restrict putting solar facilities on prime farmland. The financial sources and business future of the company that will ultimately own and operate Rainbow Trout LCC are unknown. Total costs submitted were generated by GenX and RWE paid direct sources without any independent evaluation of realistic costs, as you just heard. Assets and equipment being installed have functional lifespans shorter than the 40-year duration of the product. If abandoned, the land will be useless for farming and the equipment will be worthless. Any failure to fully cover the cost of decommissioning and restoration will devastate the property owner's land values. An abandoned facility will increase the loss in home values that nearby homeowners will experience. It will be a source of stormwater pollution, an even larger public safety and fire hazard, a source of invasive species, and an even greater threat to the wetlands and watersheds nearby. In short, abandonment would create an environmental public safety property value catastrophe. Soil compaction and drainage restoration will involve 3 to 5 years of post-equipment crop land recovery. Recent independent studies indicate decommissioning budgets, which should be closer to 20 to 30% of the original project cost. Heavy metal deposits left behind in soils by equipment must be included. Without proper soil cleanup, food companies such as the Michigan Potato Growers Association are now saying they will not accept crops grown on former solar facility fields. The petitioner has submitted a walk-away total to you in their submission, a number so small that they are willing to just surrender and walk away. GenX and RWE will be long gone in 40 years. A low initial cost indexed every 5 years for inflation over 40 years will never make up the initial gap in funding. It begs the question, who will pay for a proper facility closure? The petitioner failed to include any removal costs for the battery storage facility, even though the battery storage equipment items are listed in their generator interconnection agreement. The wording in the Solar Ordinance 41114 D2 is very specific. Costs for any other associated facilities must be included. Therefore, this decommissioning plan is incomplete. Deny this special exception based on the incomplete and inadequate decommissioning plan. The cost sheet summary is filled with errors and omissions and only captures a fraction of the total cost needed. There's no irrevocable surety security by deposit specified. Please protect the county and its residents from major financial harm by marking ballot items 2 and 3 as shown on the slide. Deny this project. Thank you.
Thank you. Next, please.
My name is Chuck Shelby. I live at 9321 South, 400 West in Lafayette. I want to talk to you about ballot factors 2 and 3, and then circle back to the value of AA land in the comprehensive plan. I'm a 6th-generation farmer in Tippecanoe County, and my son Brian is a 7th. My family has been working land in Shelby Township for almost 200 years. We farm in Tippecanoe, Montgomery, Fountain, and Warren counties. I was a little bit amused earlier tonight and maybe a little bit insulted by those who have never planted a crop in their life are trying to explain production agriculture. A couple of examples. No farmer in the United States is spraying their crop for rust. Rust is a corn disease. One speaker said all the corn goes into ethanol. We're going to grow about 16 billion bushel of corn in this country per year this year, and about 5 billion bushel go to ethanol. But first, I wanted to share an announcement with you by Secretary of Agriculture Brooks Rollins. On August 18th, USDA ends programs for wind and solar. Rollins said, millions of acres of prime farmland is left unusable so Green New Deal subsidized solar panels can be built. The destruction of our farms and prime soil is taking away the future of the next generation of farmers and the future of our country. Rollins represents the federal agency that oversees about 238,000 acres of cropland in Tippecanoe County. And what you're voting on tonight is not about solar good or bad or climate change. It's about converting some of the best farmland in the United States to a solar project. I'm not speaking theory here. I'm one of the few speakers tonight that actually farms and knows the impact firsthand. I've seen a lot of changes in farming in Tippecanoe County over my lifetime, but nothing as damaging to agriculture as the 1,700-acre proposed solar plant. It'll take more than 1,000 acres of highly productive farmland out of use for seasons and generations. And that's just a start. Farming isn't only about corn and soybean production. Each year, those 1,000 acres keep seed companies, fertilizer dealers, fuel suppliers, machinery dealers, bankers, and insurance agents in business. It's about $2 billion worth of revenue that goes into the pockets of our friends and neighbors. From a broader perspective, over the process of 40 years, you're talking about $80 billion. Farmers produce more than just money. It also produces fuel, ethanol, and biodiesel for a cleaner environment. It's also an ingredient in plastics and pharmaceuticals. Without agriculture, we would all suffer, and the quality of life for generations to come will be greatly impacted. I've also served as past president and board member of the Tippecanoe County Soil and Water Conservation Board. I've been planting and harvesting crops for 45 years. I know how valuable good drainage and healthy soils are. On the farms bordering this power plant, the Aid and Shelby family farms have spent hundreds of thousands of dollars again installing drainage tile and maintaining the ditches. This solar project would pound, again, 60,000 posts into the ground, running heavy machinery over it, causing compaction, tile would be crushed, and the runoff from the solar panels will overwhelm the ditches. When those ditches flood and tile breaks, we suffer yield loss. That adds up again to hundreds of thousands of dollars of economic loss to the Aid and Shelby farm fields. Gen X won't fix it, not until their lease is up. 40 years is a long time to wait for a promise to repair the land. Gen X tries to claim land values will go up next to their power plant. That's not true for us. Sure, farmland prices go up when farmland disappears, but right next to this project, if our land floods and our yields drop, it won't be as valuable as it was before. This project is bad for our farms, bad for our community, and bad for the future of agriculture in Tippecanoe County. It takes prime farmland and turns into something less. It causes economic harm to the whole ag community and damages our neighbor's property. It tramples the comprehensive plan and vision for Shelby Township, destroying AA land and substituting an industrial
1 minute left,
complex
sir.
in violation of Factor 2. It also destroys the livelihood myself and others enjoy in violation of Factor 3. In the end, my final thoughts are, you can build solar projects in many locations, but you can't recreate AA farmland or restore it to its original productivity. Also, what does a cornfield do? It takes sunshine, converts it to energy for food and fuel for people. I strongly urge you to deny this special exception. Thank you.
Thank you. Next, please.
Hello, my name is Alicia Aid Reed. I live at 324 Kerber Road in West Lafayette, and I am 50 feet from the proposed solar power plant. I've lived in Shelby Township for 56 years, and I inherited farmland that has been in my family for 144 years. Like John and Steve, I believe a solar power plant next to our AA land is inappropriate. Never did I imagine that I would be in such a project that's going to be in our front yard. My father and the neighboring landlord's father once served together on the Tippecanoe County Historical Society. I think they would be heartbroken to see the farmland destroyed. AA land in Tippecanoe County is among the most productive in the state and the nation. In 2023 and 2024, our fields produced 248 bushels of corn and 75 bushels of soybeans per acre. By comparison, the Indiana averages are 221 for corn and 60 for soybeans, and the U.S. averages are 175 for corn and 50.7 for the soybeans. On average, our averages are nearly 40% higher than the USDA national average for corn and 50% higher for soybeans. This proved what Byron explained. AA land has special qualities. But as Chuck noted, if our drainage tiles and ditches that we poured money into are damaged, then our yields drop and we suffer real financial losses. The comprehensive plan and land use manual explicitly recognize these soils as unique. They stated the county must preserve prime farmland, promote only development compatible with soil types and drainage patterns, and consider soil types in the planning process. This project fails on every one of those measures. After college, I tried to live in Chicago. I came back within a year because nothing compared to the clean air, the open fields, and the sunsets over the countryside where I grew up. There are many people that stop along our road to take pictures of those beautiful sunsets. But if this project is approved, the spot where the people captured God's beauty will instead show a power plant covering prime farmland. The landowners who leased this project talk about generational wealth. But what about my children who are set to inherit our Hoosier homestead? The comprehensive plan intended this land to remain in agriculture. If you approve this project, my dream of my children farming, living, and enjoying this serene area disappears. On ballot factor 2, please vote will not. The AA zoning was created to protect farmland, and granting solar special exceptions undermines that purpose. On ballot factor 3, vote will. This project will financially harm families who are still wanting to work the land. Farmers who left farming will profit, while those of us still farming will lose both financially and culturally. The area plan is clear. Preserve prime farmland. Allowing industrial solar through a special exception creates a loophole that directly contradicts that plan's intention and intent. Thank you.
Thank you. Next, please.
Good evening. My name is Heather Beasley, and I live at 2336 North, 600 West, in between Jackson Highway and Highway 26. I'm going to speak about the sheer size of this installation. The Rainbow Trout Solar Project is 1,700 acres, or for the sake of conversation, let's round up to 3 square miles. SIA in Lafayette is 1 square mile. Purdue University West Lafayette campus is 1 square mile. Caterpillar in Lafayette is 1/4 of a square mile. Wabash, Alcoa, Nanshan are all much smaller in comparison. So bottom line, SIA and Purdue are the biggest developments in the county to date, and this solar development is 3 times bigger. Keep in mind that I am only talking about the developed area for SIA, Purdue, and CAT. How much land they own is irrelevant. The area I am talking about is the built-out area, the parking lots, the buildings, etc., all the impervious surfaces. This compares apples to apples. The proposed solar plant is the largest development to be proposed in Tippecanoe County ever to date. Its impervious area will be 3 times bigger than the current largest development in the county. Let that sink in. This isn't a street corner gas station. It's absolutely massive and takes over the land that is already in productive and profitable use. Here are some not so fun facts that should ring your alarm bells. You could put 140 Ross-Ade stadiums inside this proposed solar development. You could put 1,017 Mackey arenas inside the proposed solar development. Are you surprised by the magnitude? Here are some more numbers. 275,000 solar panels, 275,000. 60,000 posts to hold those panels up. 198 cubic yards of gravel roadways, 12 feet wide and 18 inches deep. 15 miles of roadway, 21 miles of fencing, 20 miles of underground cable lines, and 34 inverter stations on concrete pads, along with an electrical substation. Why is the large size so problematic, you ask? Because it stops development to the north. It freezes residential, business, and school growth over a wide swath of a highly productive and beautiful countryside with immediate proximity near a flourishing Division I research institution. To tear it all up and pave it with steel and glass in order to create electricity that will be used elsewhere is not the highest and best use of this land. On your ballot, vote that this project will subvert the general purposes served by the Unified Zoning Ordinance because the sheer size of this project paralyzes residential, business, and school growth in Shelby Township. This is not the highest and best use of the land. Thank you for your time this evening.
Thank you. Next, please.
It's been a long night, but we do have a little bit more to keep sharing with you. I'm Jan Kohler. I live at 8507 State Road 26 West. The fence for this project will be about 50 feet from our front porch. And it looks like, the panels keep changing. We don't really have a final where they're going to be, but probably about 200 feet from our front door. Welcome to Shelby Township, Tippecanoe County, Indiana. Shelby Township is named after Isaac Shelby, who first surveyed this land in 1828. His great-great-great-grandsons, Chuck and Steve, and their families still live on this land and farm it. The Shelby Township community has grown to include many people who find their forever homes here in the quiet of the green fields. Varied and vibrant residential neighborhoods attract retirees, Purdue professors and professionals, farming families, and young families alike. They are drawn to the peace and quiet and the beauty of the land. But now this life is in danger. Developers have targeted the land for an industrial-scale solar power plant. Their plan? Destroy prime farmland and install 15 miles of gravel roads, 21 miles of fencing, 60,000 and the things that you've already heard. How big? Covers almost 3 square miles of farmland, 3 times larger than Purdue West Lafayette campus, 3 times larger than Purdue's or Lafayette's SIA facilities, 10 times larger than the solar field at the Indianapolis airport. Largest construction project ever in Tippecanoe County. What harm will this cause? It will cause serious harm to soil and drainage and cause erosion, ponding, and flooding. It will cause serious harm to property value, cause noise and light pollution, and job and income loss. But what developers didn't count on was the love and deep connection the people who live here have for the land in their determination to protect it. When faced with this threat to our safety, our health, our property values, our water supply, we turned to each other. We sought out the minds and voices, the leadership and help of our community of neighbors. Over 100 neighbors began meeting weekly. They listened, talked, questioned, researched, attended county meetings, put up signs, handed out flyers, and posted on social media. They organized tours for whoever wanted to come and see for themselves the richness of the crops growing in the fields that would be destroyed by a solar power plant. There's a better option, smart solar. We are not against solar, but residential neighborhoods and prime farmlands are not the right locations for an industrial scale solar plant. We ask you to help us protect this land for today and for the future. And I'd like to ask all Shelby Township residents to please stand to show how many of us are here tonight that are actually Shelby Township residents. Thank you for your time and attention.
Thank you. Next, please.
Good evening. I'm Donna Scanlon, 11401 South, 500 East, Lafayette. I am president of the Tippecanoe County Farm Bureau Board of Directors, and I am pleased to be speaking on behalf of the 25 individuals on our board of directors representing all aspects or many aspects of agriculture and the over 4,700 Farm Bureau members that live in Tippecanoe County. We have concerns regarding this project, and as such, we oppose the development. While we support renewable energy development and recognize it's important for our environmental future, we believe this specific project in this specific location being proposed raises significant issues that merit careful consideration, further analysis, and accurate answers before a regrettable exception is made. Our position on renewable energy is that we want to, we do not reflect opposition to renewable energy, but we understand the need for renewable energy and acknowledge opportunities for renewable energy and agriculture to coexist responsibly. We support these renewable energy projects when they prioritize rooftop or barn top installations on federal, state, industrial, commercial and residential buildings, impervious parking lots offering shade to vehicles, brownfield manufacturing sites, vertical scale projects that minimize land footprint, and development on non-agricultural land. We have specific concerns about this project, such as Rainbow Trout Solar is a proposed mega-scale solar utility project in Shelby Township with no local ties to this community. Project initiation and land acquisition by North Carolina-based firm GenX Power is funded by New Energy Capital, LLC, a franchisee of the Texas-based investment company Victory Capital Invest. As of spring 2025, the project is now owned and to be developed by RWE Clean Energy, LLC, a U.S. subsidiary of a German utility conglomerate, RWE Group. These large companies are leveraging their resources to negotiate terms favoring corporate interest over local priorities. GenX Power and RWE Clean Energy request for a special exception to allow their mega-scale Rainbow Trout Solar Energy project on over 1,700 acres of zoned agriculture, wooded, AW, and select agriculture, AA land, is a gross exploitation of Tippecanoe County's ordinance for large-scale solar energy systems. The ordinance defines large-scale solar energy systems as a ground-mounted solar energy system on tracts equal to or more than 10 acres. The ordinance was not written with such a deliberate abuse in mind, that of accommodating a large-scale project much greater than defined. In fact, solar projects over 100 acres are referred to as utility scale or mega scale, and this proposal is 17 times even that. Furthermore, removing such a notable volume of agriculture, wooded, and select agriculture zone land from the county for industrial purposes will have a lasting impact on Tippecanoe County and its residents as a whole. I relinquish the podium to one of my fellow board members.
Thank you, and just a reminder to please try and not repeat arguments that are brought up by others.
Absolutely.
But next, please.
You bet. Thank you, Donna, for introducing Farm Bureau and Board of Zoning Appeals. I'm Dale Craig. I'm at 6817 South, 700 West, West Point, Indiana. Wayne Township, Tippecanoe County. Not unlike the Aid family and the Shelby family, our family's been farming in this county for a long, long time in the south part of the county. I'm here speaking on behalf, though, not as for our families, but for the 800 farm members of Tippecanoe County as well, and with two specific concerns. And then, in addition, I'd like to thank Journal and Courier for the great article this morning informing the community of the Farm Bureau's concerns. Agriculture and food security impact. A BZA special exemption approval, especially for such an egregious amount of land, should consider what is occurring throughout the county as a whole. According to the American Farmland Trust, from 2010 to 2022, Indiana outpaced AFT's worst-case model of farmland loss by 15%. Tippecanoe County's agricultural capacity is being impacted by urban sprawl at an alarming rate. In an era of increasing food insecurity concerns, converting productive farmland to solar energy generation, especially when numerous other options in the county remain available, winter skies are dismal in Indiana and the sun goes down every day, as we all know, represents a suboptimal use of this very valuable resource. The preservation of prime agricultural land is fundamentally linked to both local food security and broader homeland security considerations. We request through analysis other options from the developer, including partnerships with our local manufacturing businesses better suited for massive industrial use. In addition, the environmental and infrastructure concerns are equally concerning. Prior to a special exception approval, we request a thorough analysis of the following environmental factors specific to this project size and project location to determine if such an exception is in the county's best interest. Wildlife impacts. Study after study document the negative impacts solar developments have on wildlife, especially the mortality of hundreds of thousands of bats and birds. The proposed site is located a mile from our Wabash River, even closer to supporting tributaries, and less than a mile from Ross Park and Martell Forest, which we each know are wildlife habitats, including the protected bald eagles and endangered Indiana bats. Though tree clearing will occur outside the nesting periods, which we recognize, wildlife is forced to relocate, which negatively impacts the ecosystem, of a substantial area originally set aside to be preserved. So the question is, what safeguards then exist for this area's endangered and protected bats and birds removal from the area, and what penalty results and which efforts to repopulate are required when a mortality occurs? So we'd ask the folks that doing this to point that out for us. Aquifer impacts. Got to be careful with that because you've already asked me not to talk too long about the aquifers. The areas in question sits above the TAFE permeable unconfined alluvial aquifer, which we well know. Due to the permeability of the soil, there's heightened concerns of contamination risk to potable water wells in the area. Water safeguards exist to sustain the quality residents' well water throughout the lifetime of the project. Should contamination occur, though, what requirements are in place to ensure residents and businesses maintain access to their high capacity and low capacity volumes of well water, which their lives and livelihoods depend upon? Third issue, private drainage impacts. Subsurface clay and concrete tile systems drain a large portion of this neighboring land in this area. The adjacent property owners rely on this active groundwater finger system, which is based on topography needs and not current lot lines. Though no fault of their own, adjoining landowners are at risk of damage to their private drainage systems as a result of the project of this scale and at this location with little to no ability for recourse. What protections are in place for non-participating adjoining landowners' private drainage systems? Finally here, heat generation and reflection. Recent studies by the University of Maryland, University of Arizona, University of Madison, Wisconsin, and by the Nevada Center of Excellence reveal massive and unavoidable heat island effects occurs with large-scale solar projects. Therefore, what are the thermal implications of a 10x the acreages or even 60x the projects? And how does this heat production reflect? 1 minute, please. You bet. Heat production or reflection from 600 plus acres of solar panels affect solar microclimates, including precipitation. As a result, how will this impact residents, agriculture, and the ecosystem surrounding the project dependent on rainfall? How will this impact the recharge rate of our county's aquifer? Should it be determined over time that a heat island is occurring and elements are affected, what is the required rectification and timeline? BZA, we request you deny this special exception. Carly?
Thank you. Next, please.
Thank you, Dell. My name is Carly Sheets. I live at 5650 West, 75 South, Lafayette, Indiana, and I'm here to continue the letter representation from the Board of Farm Bureau. The third concern that Farm Bureau raises is the economic considerations. This precedent-setting project creates a situation where outsiders are allowed to come in and cover an enormous amount of AA and AW rated farmland with solar panels, where the earnings from the project will transfer to an out-of-state firm and foreign-based utility company. If you grant this exception, you will be prioritizing out-of-state and foreign-owned businesses over the local residents and firms currently conducting business in our county. Furthermore, specific to this mammoth project, in this selected location of the decision-making land trust owners opting to host these solar arrays on their property, we're told that 0 live there. Mega solar projects have unparalleled impacts upon neighboring county residents. Unlike any other development of its kind, study after study shows that solar developments near residential areas decrease property values. Tippecanoe County families who responsibly saved and invested in the area will see their home equity vanish. This mega solar project sets a trend for future AA and AW rezoning in the area. The area as a whole is currently zoned AA and AW, granting this special exception of 10% of the area for industrial solar use will have lasting impacts on the remaining prime farmland's future. That is to say that more than 1,700 acres is under consideration. And a final economic consideration is the local economic trade-off. The county is not exchanging one form of economic activity for another. They are swapping a locally rooted, sustainable agriculture economy for an industrial energy economy. The local farmers who rent and care for this land, as well as the local jobs that depend on these farmers, like Tippecanoe, Keystone, Newton Oil, Rowe, Truck, Cargill, and Tate and Lyle, will lose a notable chunk of income, especially in accumulation with the urban sprawl that the county is experiencing, impacting our local economy. Unlike industrial solar, agriculture farming actually requires nutrient-rich land for crops, pastures, and livestock, and should be preserved for such. A fourth concern from Farm Bureau is the abuse of ordinance. Tippecanoe County involved the community in their established unified zoning ordinance, which states, with a view of conserving the value of buildings and lands and encouraging the most appropriate use of land throughout the participating county, city, and towns. These large companies are exploiting the ordinance, which does not address projects of this mammoth scale, causing the county to enact a solar moratorium for further scrutiny of the ordinance's inadequacies. Furthermore, this exception would not encourage the most appropriate use of land, as the zoning ordinance states. AA is to be reserved for agriculture. Approval of this exception request would disregard the ordinance's defined intent of select agriculture zones of substantial acreage be set aside for agricultural use. Again, the specific project is not requesting 10 acres or even 100 acres to be reallocated for industrial use, but 17,315% greater than defined by the ordinance's large-scale considerations, completely obliterating the substantial acreage set aside for agricultural use in this area by our ordinance. Another concern is the pre-submission meeting documentation. The ordinance requires large-scale solar energy systems to conduct a pre-submission meeting before submitting a special exception request at which both party, owner, and applicant must attend and shall be prepared to explain the justification for an SES proposal at this pre-submission meeting. Upon requesting a copy of the sign-in sheet and approved meeting minutes from APC for verification of full compliance with this requirement, we were informed that there was no such documentation. It is unprofessional for a project of this size being pushed by companies of this size with this much opposition and this much risk to not be required to produce the documentation of the required meeting and evidence that all required property owners were in attendance for public record. And note the singularity of the ordinance language, property owner and applicant. This further supports that the ordinance was not written for a project of this size or this location, and that this large outside companies are taking advantage of the inadequacies set forth within the current ordinance. We request copies of all notes taken at this meeting, as well as a list of all attendees to ensure this ordinance requirement was met in full. Finally, ordinance violation. The ordinance requires that the land be decommissioned, and I quote, so that any agricultural ground upon which the facility or system was located is again tillable and suitable for agricultural use. To date, no mega-scale solar system projects have been successfully decommissioned back to row cropping. The BZA is being asked to gamble 1,700 acres of their best farmland on an unknown and unlikely outcome. In fact, it is believed that solar projects of this scale cannot go back to farm production, and therefore a special exception approval would be knowingly violating the ordinance requirements. Soil compaction, we've discussed a lot of that
is up.
tonight.
Thank you. Next, please.
Chad Chisholm, 500 Sterling Drive in Lafayette, also a sixth-generation farmer, and also like to draw your attention to the map in our Farm Bureau packet. The federal government is phasing out subsidies for future solar projects not in the ground by 2027. By approving the request for special exception, the board would be actively approving and agreeing to cover 1,700 acres of the county's prime farmland with aging technology for decades to come. While solar will remain a feasible option for some uses, like buildings, parking lots, brownfields, the BZA has the foresight to see what the future is, and it is not mega-scale solar projects. In fact, Purdue may be paving the way with small modular reactors, SMR, developments. And the county should be reserving resources to support this local and future abandonment. Numerous large-scale projects in the United States have been abandoned due to company bankruptcies and closures, high costs of solar compared to the falling prices of other energy sources, underperformance, too expensive to run except under optimal conditions, environmental impacts, and quote-unquote, due to the high costs and complexities associated with decommissioning and site restoration. This is dated technology use. Our recommendation, we respectfully urge the board to deny the special exception request. We believe responsible renewable energy development and agricultural preservation can coexist when projects are thoughtfully planned and appropriately sited. This project, as currently proposed, does not achieve that balance. As the Board of Zoning Appeals, you're tasked to consider special exceptions for conditional uses and require careful review of their location, design, configuration, and impacts to determine against fixed standards the desirability of permitting an establishment on a given site. The economic benefits of this specific solar project for the government are outweighed by the burdens placed upon your residents. Now that the county has been made aware of these burdens, the exploitations of the ordinance, and the lack of adequate resident protection, granting an exception could cause the county to liability. Expose the county to liability. We urge the board to deny this request for special exception, at least until the county has time to update the ordinance to consider the specifics of utility scale or mega scale projects, which are 100 plus acres, let alone 1,700 acre scale project. These Texas and Germany-based developers are exploiting the county's ordinance allowance for special exception, which was written for large scale, which is 10 plus acres, and not mega scale, which is 100 plus acre projects in mind. Furthermore, when no mega-scale project has been successfully decommissioned back to prime tillable use, the BZA is gambling on an ordinance violation on 1,700 acres of prime farmland. Finally, mega-scale solar projects are not the future, and we urge the BZA to deny the special exception request, encouraging the most appropriate use of land per the Tippecanoe County ordinance. We believe this specific project in this specific location raises significant issues that merit careful consideration, further analysis, and accurate answers before a regrettable exception is made for decades to come. Consider the legacy of this generation of county officials. Preserving true agriculture use in this area will have a lasting value to county residents. Home values for those county residents, water quality for those county residents, critical wildlife and habitation protection, local jobs and businesses, local university endeavors, and our food and water resources, which are the commodities of the future. Thank you.
Thank you. Next, please.
Hello, my name is Ellen Milligan. I live at 1820 South, 950 West, West Lafayette. Our home is 4 miles from the solar power plant. I am here to provide a statement in opposition of this project from State Senator Spencer Deary, Indiana District 23, and a Senate representative for many of the citizens near the proposed project. Senator Spencer Deary toured the site, met with the concerned residents, and was able to see for himself the harmful consequences this project would cause. After his tour, he provided the following statement since he could not be here with us tonight to speak in person. I'm grateful to the concerned residents of West Lafayette who gave me a tour recently of the neighborhoods and farm acreage that would be affected by a proposed large solar project just west of the city. While the question of whether this project should be approved is a local decision of which a state lawmaker has no role or influence, I believe as a resident of the community that local leaders should be very deliberate about planning for smart growth. Semi-rural areas like this, located just outside the metro core, hold great potential to keep West Lafayette's housing supply abundant and affordable. With the recent announcement of another hospital coming to West Lafayette, we are all reminded of how our community is growing, and much of that growth will be to the west. We should be very careful to avoid approving anything that would limit our ability to plan for housing and development that smart growth requires. As a lawmaker, I want to empower local leaders to determine what's best for them without unnecessary limitations from the state. That's why I oppose bills that remove decision-making over issues that should remain local. I also recognize as a lawmaker that in coming years, our nation will need to generate unprecedented levels of electric power. That reality may make some unhappy, but we shift to an economy driven even more by AI and technology. There's nothing anyone can do to change the trajectory of our energy needs. In response, it's common to hear elected officials say we need an all-of-the-above energy strategy, and that's true. Both renewables and traditional sources like coal and natural gas will continue to be part of our grid for the foreseeable future, but not all power sources are created equal, and the mantra of all the above should never become an excuse that keeps us from working toward a better strategy for the future. For example, we need to do a better job directing solar developments away from prime farmland and instead towards brownfields and rooftops. In our relatively cloudy region, that sacrificed soil often isn't worth the power generated. Last year, I introduced Senate Bill 253, which would have reduced the incentives to remove the state's best farmlands from production. Indiana's prime soil is a natural resource that deserves protection. We also need to invest in energy sources that are reliable, clean, and efficient. And I agree with researchers at Purdue who believe our new best option isn't new at all. The same compact technology that has powered nuclear submarines for decades can be used on land as a reliable and clean source of power, even when the sun isn't shining and the wind isn't blowing. Rather than developing massive individual design nuclear power plants, the SMRs would be mass-produced in a factory, making them more affordable and faster to deploy. SMRs would be placed around the state, and depending on size, each could generate enough power to supply a university, a large manufacturer, or a small city. Submarines and aircraft carriers have already proven this technology works, and now it's up to policymakers to modernize our regulations and remove the red tape that stands in the way of energy-abundant future. It will take leadership and probably a little bit of pain to get there, but this strategy is going to work, and Indiana is leading the way. In closing, the Indiana citizens concerned about this project go far beyond the 400 owners who live within 1 mile of the project's boundaries. Many realize why this project is bad for Tippecanoe County, and they have toured the proposed location. Please consider Senator Deary's words in your decision tonight. Thank you.
Thank you. Just another reminder to try not to repeat a lot of arguments made by others. And we'll hear next, please.
Good evening, Board. Thanks for hanging in there with us. Members of the Board of Zoning Appeals, my name is Richard Bagsby, a resident of Eastern Tippecanoe County, right off of Indiana 26 East. I'm a real estate professional and a Republican candidate for Indiana's Senate District 22. I'm here to strongly urge you to vote no on the Gen X RWE Rainbow Trout project, and I'll explain why. I am not opposed to solar energy, only to poorly located and scaled projects that lack community input and proper oversight. Local control is essential. As a real estate broker and former construction superintendent, I believe that there are concerns with this project that will negatively impact surrounding property values. The questions that I raised when T-Cross allowed me to come out and tour the site, hopefully you guys had a chance to do that as well. Will Black Blanket Farms bed and breakfast be affected? Will local businesses suffer? Will agri-tourists want to visit near a solar farm? Why would a developer build a subdivision right next to such a facility? Excuse me. If the applicant claims property values won't decline, why not provide written guarantees? Many counties require this in their ordinances. The IRS defines farms as agricultural operations. Nothing about solar panels or batteries is in that terminology. So I think we should call it what it is, a taxpayer-subsidized industrial solar electric plant. These plants contain hazardous, sometimes carcinogenic materials, heavy metals like lead and cadmium. The panels are also vulnerable to weather damage. Catastrophic failures could pollute air, soil, and water. I won't belabor that. First responders, often volunteer fire departments with limited equipment, could be put at extreme risk handling emergencies. Our county commissioners recognized these dangers and enacted a moratorium on large-scale solar projects, an essential step to safeguard public safety. As BZA members, your primary responsibility, as I know you guys know this, is protecting residents and the community. Earlier tonight, we heard a gentleman wanting to put a shed in his yard. We heard the case, whereas will it affect the neighbor's vision or be an eyesore? Some of these panels literally encapsulate or wrap around residents' properties, as we've seen in some of the slides. Tonight you have the power to protect our community, protect these folks, to protect the over 400 residents that's going to be affected. You have the power to protect them with voting no on BZA 2199. But again, like I said earlier, I'm not against solar panels. I'm not against wind turbines. I'm for doing it the right way. The applicant can then reapply with a more responsible ordinance compliant plan. Let's prioritize safety, property values, and community well-being. Thank you, and God bless.
Thank you. Can you sign in? Next, please.
Good evening, everyone. Tracy Brown, County Commissioner, District 1. I'm here representing the entire Board of Commissioners. So on behalf of Tom, Dave, and myself, thank you for persevering this evening. And I do say good evening because last time I checked, it is not morning yet, but it will be shortly. I feel the weight of the decision that you're about to make because you're digesting a lot in a very short period of time. The Board of Commissioners has had probably close to 6 months since these conversations began to percolate across the community. And we've spent time with neighbors there. I recall driving all the way up to Monticello near the hospital and Twin Lakes High School and seeing my first large-scale solar project. And I hope you've seen one as well, because they're massive. They were not what any of us anticipated back in 2021 when the ordinance was updated. That happened in February 1st of 2021. The Board of Commissioners took that ordinance up. It was updated. A lot of great work went into that. And I went back and I checked the minutes from that meeting just to be sure, because I didn't recall any citizens speaking for or against the ordinance. And you remember this was on the heels of the basically the ban of wind energy, and everybody said, yeah, solar's the next thing. The reason we didn't have anybody to talk about it is because people didn't understand. They didn't know a lot about it. They'd seen, yeah, somebody puts it on their shed or the roof of their house. Nothing like this. I agree with what somebody said earlier, smart solar. Most of us are in favor of smart solar. And I'm going to tell you right now, our friends and neighbors that showed up here tonight, they're not fear-mongering, okay? They're not naysayers. These are people that have dug in and spent some time learning about the implications of a project like this. And it's because they love their community. And we ask people to get involved, and like so many others in the past, they have done just that. The current state of affairs is that, we started hearing about rainbow trout. It's probably been about 24 months ago when we knew, or even longer, when we knew there was somebody in town trying to sell the contracts and everything. And then over the past 6 months, like I said earlier, we've spent time talking to neighbors, visiting them out in the fields and learning a little bit more about the impact that they have forecasted. And I think they've done an excellent job of doing their research to show that there are some perils with this. To that end, we passed a moratorium on large-scale solar energy systems on June 16th. We did not rush to judgment on that. We gave a lot of consideration before we took that significant step. The moratorium is just an opportunity to pump the brakes, look at that original ordinance, and see what we missed. And there could be a lot that we missed. And we know this because this is not the only place in Indiana this is going on right now. It is going on north, south, east, and west. And there have been some very novel ideas about how you make a project more palatable and how it works for a community. And there's strength in us being able to, again, pump the brakes, look at the guardrails that make this something that can work for us. We're already assembling a team. That's happened. They'll be working shortly on this. And I liken this to many, many, many years ago, and probably nobody was around when this happened. Remember when the cities used to have their own small dumps and they got this brilliant idea, let's go outside of the city, out of sight, out of mind. We're going to dig a big hole in the ground, and that's going to become the county dump. That made perfectly good sense. This is not an indictment of the business that sprang from that in Tippecanoe County or the people that authorized it when it came to the regulation. But we all know what that became. It became a brownfield site, and it is a constant reminder of what can happen when you don't have enough information. And we are stuck with that hill that will never be developed unless it becomes a toboggan run, or you can't plant anything on it, you can't grow anything on it. But that's what we could very well be dealing with here. And we have time. That's the one thing that we have. We have time to take a long, hard look at this and make it work And in fact, if the folks proposing the project wanted to take it off the table right now, I'd be okay with that. I know they're not going to do that. You're going to have to make a decision, and I ask on behalf of the Board of Commissioners that that decision be to not grant the special exception. Thank you.
Thank you. Next, please.
Good evening. My name is Lewis Ed Watson. I am speaking on behalf of the Otterburn Volunteer Fire Department. To give you a little bit of credentials, I've been a firefighter since 1990, and I've been an EMT and a paramedic since 1986. I've been in this a while. I've not seen everything, but I've seen a lot. I feel like that if you approve this, and when we get a call there, because we will, it's no longer if, it's when, I feel like we're going into this blind. They have offered no training. They said they came up with a fire plan. We have yet to see that. We know nothing about it. All we were sent was a blueprints and said this is going in, and that's what we were told. We don't know how we're going to be able to care for this if we have an incident there. We're getting told different things every day, that it's going to be condensed and made smaller, which is going to make access for us almost impossible. We're now talking about going from stretching 250 feet of hose line if there is a fire there, or when there is a fire there, to now stretching between 1,000 and 2,500 feet of hose to fight a fire, because we will not be able to get between those solar panels or around that area to get in there to fight that fire. The other concerning thing is, according to the plans, there's 2 buildings that are going to be throughout there that are going to hold batteries. Those batteries are very dangerous, and if they catch fire and when they catch fire, they will burn for a long time. We will stretch our resources thin trying to protect the citizens out there and get them evacuated and figure out what we need to do. Eventually, the outcome is going to be to let it burn. It's going to burn for days, and we're going to have a lot of runoff, and who's going to take care of that runoff? There's going to be nobody there. They said they're going to hire 3 people, and they're going to be there, but are they going to be easily accessible? And if they are easy accessible, are they going to start pointing the finger and have to make 30 phone calls, and an hour and 15 minutes later, we still not got no decision on what we're going to do? I'm responsible with the chief of the fire department for 30 men on our department. We actually have a roster of 30 people, and we were very proud of that. And I am not going to send them people into some danger that we know nothing about. I am not going to be the person that's going to get somebody seriously hurt or killed. I feel like that there needs to be more planning for this. There needs to be more put aside for fire suppression and for EMS calls to this area. And I feel like that we need to be given a person that we can contact that can immediately be there within a 15 to 20 minute time span. An example I can give you is we had a fire at the power plant at Montmorency. 45 minutes to get somebody there to be able to let us in and contain the power so we could do what we needed to do to get that fire out. Luckily enough, within 20 minutes, the fire burned itself out. So we waited for the guy to get there. He let us in. We did check to make sure everything was taken care of. After he killed the power to that area, we did our job and we left. Had that fire still been burning when we got there, West Lafayette, Montmorency, Otterburn, and a lot of other areas probably would have been without power. I feel like you need to vote no on this. They need to plan a little better, and they need to meet with the departments and not do it at 3 or 4 o'clock in the afternoon. Most of the departments that are going to cover this area are volunteer departments. Volunteer means we don't get paid, which means we have to work jobs to be able to support our families and pay our bills. If they want to do a proper training, they need to do it in the evening when everybody can be there. The training that they put on was, I was told I was not able to make it, only lasted an hour. And the people that were there said that there really wasn't any information given. They felt like it was a waste of their time. And one person even explained it as they felt like they patted themselves on the back because they did what they were supposed to do. They did not do what they were supposed to do.
1 minute, sir.
That's really all I have to say. I really just think you need to vote no on this right now, and they need to, if they want to bring it back, they need to come back and represent and come back with better planning and better plans for this. Thank you.
Thank you. Sign in. Next, please.
Hi, good evening. My name is Jay Gephardt, and I live at 7721 Amanda Lane in West Lafayette, just off of Kerber Road. I've been asked to read the following letter on behalf of Larry J. Hager of Decatur County. Address is 4870 North County Road 80 Northeast, Greensburg, Indiana. Larry could not be here in person tonight due to family illness and someone in hospice. His testimony is relevant because Decatur County has been dealing with Gen X and RWE for over a year now. Here is his statement. What you need to focus on tonight is what Gen X and RWE did not tell you in their petition. The developers' talking points lack honesty, accountability, transparency. Who is RWE? RWE is a German company owned by and with the largest shareholder being the country of Qatar in the Middle East. For some context, during World War II, the countries captured by Nazi Germany had their power systems rerouted back to Germany and controlled and powered by RWE. Captured prisoners of war were forced to work in the power plants owned by RWE, which was confirmed to be against the Geneva Convention. RWE has admitted to this practice. Allied forces worked hard to destroy the power plants operated by RWE. 60 years after the war, RWE was forced to pay wages to those who worked for them during wartime, only if they were still alive. RWE was a previous owner of the largest investor-owned water utility in the United States, American Water Works, which is still in operation and is not without its own issues here in Indiana. A lawsuit was filed in 2017 against RWE for its destroying of the Hambacher forest in Germany, 1/3 of a mile in depth in all of Europe just for coal production. Yes, RWE is in coal production. 2018, RWE became the largest producer of carbon dioxide emissions in all of Europe. 2021, RWE sued the Dutch government for $1.6 billion for enacting green policies that would phase out and shut down their coal production. 2023, the village of Lützerath, Germany, and others were forced out so RWE could extract the coal beneath them. Who is Gen X Solar, LLC? It was founded by two Berlin, Germany natives as the tax windfall in the United States started ramping up for the alternative energy industry. George Veit is the CEO chairman and received his master's degree in philosophy in Berlin, Germany.
Can we concentrate on the project rather than criticizing?
Yes, I'm just reading this letter. Okay.
We'd like it to be germane to the discussion.
To the discussion, yeah.
Okay, I'll finish reading the letter. George just happens to be the head of the Center of Energy Education, which is a lobbyist group for their projects. They started 77 different LLCs, and the number is still growing in the United States for protection from liability issues with local government and landowners. Gen X doesn't build or operate industrial solar complexes. They get approval and sell their projects to the highest bidder. Contractual law comes into play at the time as to what is still binding to the new owner and what is not, for both the local government as well as the landowners. The Decatur County experience with Gen X has been straining. They withheld recording their leases at our courthouse. They published literature showing a much smaller project, 4,500 acres, than their application recorded, 7,100 acres, and they have been attempting to add thousands more acres to the project after their application. They made repeated attempts with our county commissioners to get them to sign an economic development plan contract with added wording that would have shown support for the project. Our commissioners did not support the project. We currently have a 2-year moratorium against alternative energy projects. Our local BZA has voted denial for RWE and Gen X projects twice in the past 12 months by unanimous votes. Based on the experiences other Indiana counties have shared about their dealings with RWE and Gen X, please deny this special exception tonight.
Thank you. Please try and, again, not repeat arguments by others and make sure that it pertains to this case rather than just criticizing others.
Good evening. My name is Connie Ehrlich. My address is 6830 Ripple Creek Drive, Lafayette. I'm a resident of Tippecanoe County, and I also own farmland in Pulaski County. I would like to share with you what is happening in Pulaski County, and hopefully this will help you to avoid the same disasters and pitfalls from allowing large commercial solar projects in Tippecanoe County. You heard Mr. Kushme mention Mammoth Solar and their massive solar projects in Pulaski and Stark counties. Mammoth applied for their special exception on 4,500 acres in Pulaski County 5 years ago. At the BZA public hearings, there was an overwhelming amount of people in opposition, much like tonight, stating many of the same facts that you are hearing tonight. After the BZA's approval was overturned by the courts for having an incomplete application, Pulaski County made commercial solar a permitted use in all ag district areas, paving the way for Mammoth's project, and now we are living with the consequences. Today, 5 years later, after the first approved application for solar, we now have 14 solar companies with over 35,000 acres with solar contracts. That represents 15% of all harvested cropland acres in Pulaski County. These are a few of the problems we have encountered in Pulaski County. Mammoth said that they would not remove any trees, when in fact several wooded acres were cleared and mature logs were hauled away by the truckloads. Mammoth said that they would not disturb the topsoil. Mammoth has scraped and removed the topsoil. They even transported soil by the truckloads to use as fill on other parcels. Mammoth also damaged the field tile, causing flooding in adjacent fields. It will be impossible to return the ground to the condition that it was prior to the solar development. Mammoth said that they will return the roads to conditions prior to construction. In Stark County, after Mammoth's project was completed, the estimated damage to the roads exceeded $1 million. It is reported that Mammoth settled with Stark County by giving them $267,000 and transferring a grant from the IEDC to cover the road damages. The IEDC grant was initially given to support infrastructure needs surrounding the development in Stark and Pulaski counties. I do not believe the grant was intended to release Mammoth Solar from the financial responsibilities. Mammoth also destroyed many of the roads in just 6 months of construction. The solar construction has generated a tremendous amount of heavy truck loads. And what you've heard tonight, you've got 272,000 solar panels, you have 60,000 posts. That requires a lot of semi-trailers and triaxle dump trailers. So in Pulaski County alone, we are really suffering with the public safety for our community. Mammoth's workers are not obeying the designated road routes. No, but I think this is very insightful, because I think this is what you're going to be looking at, because like Tippecanoe County, Pulaski County was hearing all these things from the solar people, making promises that didn't happen. I'm trying to give you some insight of what is currently happening in Pulaski County. So the traffic that one gentleman was talking about from farming and kind of complaining about that is nothing compared to the construction traffic from solar. Also, the other areas of concern are your setbacks. I think Tippecanoe County is the only county that's worse than even Pulaski County setbacks. I can't believe that you only have 50 feet. also in the findings of fact that Rainbow Trout has put out. It does not include the perimeter fencing. So that perimeter fencing is going to be very close to adjacent property, and I think that's a major problem. No one wants to live beside chain link fences.
1 minute.
Thank you. So Pulaski County is like so many other rural counties. We do not have the resources to deal with these large commercial solar projects. Many of the solar developers are backed by foreign corporations like Rainbow Trout. The solar developers have destroyed relationships and divided the community. It's been a cancer in Pulaski County. We have not been able to control it or limit the solar development. If you have any doubts whatsoever, please table your vote tonight and tour the projects that are in Pulaski and Stark counties. The people forced to live around these solar projects are living a nightmare that does not end. Their quality of life and property values have been destroyed. Please vote no to the Rainbow Trout Solar Project. Thank you very much.
Thank you. Just a reminder, we do not control the ordinance.
Hello, my name is Tula Dutlinger. I live at 511 Kerber Road, West Lafayette, a little over the quarter-mile radius. I am a junior at Benton Central. The petitioner wants you to believe that the property owners in the county will benefit from an industrial solar installation. I'm here to tell you this is not the case. Landowners in Tippecanoe County will be left with nothing but regrets and 40 years of waiting while they watch the land they love be destroyed. I'm going to read a letter from my Uncle Dave, who, along with Jasper County officials, believe the same things about the goodness of industrial solar. I'm here as his niece to speak for him and for the generations of Dutlingers who now know that the land generation placed their hopes upon is hopeless. Dear Tippecanoe County BZA Board members, my name is David Duttlinger. I am writing this letter to share my experience with a commercial-grade solar project. I'm a landowner in northern Jasper County. I'm the third generation to own our family farm. 9 years ago, we signed our solar contract with Orion Renewables. This was the same company that originated the wind farms in Benton County. The first contract they gave us was full of problems and issues. We went through many revisions, had lawyers review it, and we believed we had an ironclad perfect solar lease. Both us and Jasper County could not have been any more wrong. After the BZA board and becoming shovel-ready, our solar project was sold off to the highest bidder. We had many clauses in our contract that stated, leasee and landowner will discuss location and placement of access roads and critical infrastructure. We were assured that existing infrastructure, drain tiles, irrigation water mains, irrigation electric lines, and livestock fencing would be protected from the solar array. Our contract states that any damage done by the installation of the solar array will be fixed to the landowner's satisfaction. We also had language that stated all topsoil will remain in place. When construction began, we quickly realized that our contract did not mean anything to the subcontractor of the subcontractor. They were told to do a job, and they did it. They started off with plowing every acre of their proposed site. They wanted to eliminate standing corn stalks to prevent tribute hazards to the workers. They did not plant any vegetation on the open soil. We advised them that this would lead to serious wind erosion problems in the future. 3 weeks later, I drove past the farm ground that my family has owned for 3 generations to find a bulldozer leveling off an 80-acre field. They took the few inches off of topsoil from the tops of the hills and pushed it down on top of the prime topsoil into the bottom ground. We now have prime soil with 10 feet of subsoil sand pushed on top of it. Our topsoil in this part of northern Jasper County is very thin. In most places, we have 48 inches of productive topsoil. We then witnessed scraper pans come in and steal topsoil from the high spots to fill in the low spots. When the normal spring winds came, we ended up having a dust storm that occasionally was so thick that it impaired traffic on the roads. When construction of the infrastructure began, we were promised that all existing infrastructure would be avoided. They turned our existing irrigation water mains, electric lines, and drainage tiles into Swiss cheese. Perimeter fence posts and steel beams to hold up the panels were blindly driven to the ground. We confronted the developer. Their answer was, yes, it happened, we will fix it. Not being satisfied with the answer, I went to the Jasper County Commissioners. I pleaded my case, and the basic answer I got back was, you signed the contract, it is your problem. A few weeks later, I noticed when they dug a new ditch through our farm to drain off water from a transformer station placed on our property into a county-regulated drain. When construction was done and our farm ground was destroyed, we sought after legal action. Our family farm was day one, site one, phase one of everything that happened with our solar project. We were told by their lawyers and our lawyers. According to the contract and county status, the developer remains the ability to correct all actions once the project has been terminated. If it is not up to standards, then 50 years later, they will have the option to fix the problems or be held responsible for the problems. Thank you for your time and listening to a few examples of what we experienced with our solar project. Please vote no tonight, as you are bound to do under the health, safety, and welfare part of the ballot. Thank you.
Please hold your applause. It's after midnight already. I would ask that if you're going to get up and read a letter or give a speech about another project in another area, that we've heard plenty on that subject. We get your point. Let's try and get this hearing through with relevant information, please.
I'm Jackie Ralph. I live at 2236 Trace 22, West Lafayette, Indiana, and I am reading this on behalf of Jody Sondergraf at 5810 West, 1325 South. Like many in the room tonight, Jody has deep roots in the local agricultural community and is a landowner. She has serious concerns about the loss of farmland, so she asked her attorney for advice on solar leases. She provided us with a memo, which I think they just passed to you, from a local law firm that we are handing out to you. In that memo, the attorney warns landowners not to sign solar leases in the form presented by developers, calling them overwhelmingly one-sided and risky. The memo highlights sweeping control for up to 50 years, weak restoration and decommissioning protections, and financial terms that often turn out to be bait and switch. The memo also warns of long-term impacts beyond the leaseholder: drainage disruption, invasive weeds, constant noise, glare, and reduced property values for neighboring land. The law firm acknowledges these leases harm landowners and neighbors. This means the very risks we've been warning about aren't speculation. They're documented in writing by a respected local law firm. Thank you.
Thank you, and please sign in. Next, please.
My name is Heather Lindenman. I live at 912 Jill Place, West Lafayette, and my property is 75 feet from the solar installation. I am here to rebut the petitioner's claims that the solar facility will not impact nearby property values. The petitioner has submitted an impressive-looking 156-page document attempting to convince us that there will be no impact on home values for the homeowners living near the project. The Kirkland report that GeneX utilized has been discredited and shown to be wrong in multiple Indiana County BZA hearings. All his home value comparisons are invalid due to Mr. Kirkland's own admission on the first page of his report that his conclusions are only valid if properties are properly screened and buffered. The buffer plan submitted by GeneX for this project will have no practical impact for nearly 25 years, if ever. In the meantime, home values will be negatively affected. All the fancy computer simulations of 25 years into the future can't hide this reality. Mr. Kirkland's conclusion are not relevant when buffer yards consist of a line of dead 4-foot red cedars. In the petitioner's own study, there are over 120 homes located less than a quarter of a mile from the project. There are an additional 100 homes located between 1/4 and 1/2 mile from the project, and approximately 200 more homes between 1/2 to 1 mile from the project. About 420 homes in total. Others speaking tonight will talk about the actual anticipated negative property values. I will focus on the selective manipulation of data in the petitioner's document and the harsh real conclusion in their own data, which they ignore. The Kirkland study includes a look at properties around 39 solar installations. Of the ones selected, 31 are for small solar installations under 20 megawatts in size. This is less than 1/6 the size of Rainbow Trout, which is 120 megawatts. These are not relevant. Only 4 of the comparison projects included were for facilities over 120 megawatts in size. Using this large number of very small facility comparisons distorts the entire data set and conclusions. The study uses a matched pair method to try and draw conclusions about home values. 7 of the 10 matched pairs were for solar facilities under 10 megawatts in size, which is 1/12 the size of Rainbow Trout. These matched comparisons form the basis of all the home value comparisons, but they are irrelevant because they fail to take into consideration the large size discrepancies in the solar installations involved. Larger solar facilities like Rainbow Trout can stretch for miles and create larger visual impairment fields. Comparing the home value impact from much smaller solar facilities is unacceptable and hides the real negative impacts. The conclusions of the petitioner's own real estate study ignores the data summarized on page 597 of their special exception petition. Homes within 100 feet of a large facility will see value reductions between 5 and 15%. Within a quarter mile, the expected negative impact is 4.8 to 13%. Within a half a mile, the impact is still 3 to 8% reduction in home value. Even homes out 1 mile from the project boundary will see negative market value impacts. Using the petitioner's own data and average home values in Shelby Township, we can calculate the lost aggregate home market value for over 400 residents within 1 mile of the project who are only facing one project side of their property. We can supplement these losses by using data from a Stark County Realty study showing the reduction in home value is much more severe for properties bordered by 2, 3, or 4 sides of solar panels. We have 13 Shelby Township homeowners who will have more than one side of their property adjacent to Rainbow Trout. Their home value losses can be as high as 30 to 40% based on Stark County data. Putting this all together, using the petitioner's own real estate study, the loss in home value for affected residents will be between $6.8 million and $11.3 million. That doesn't look like no impact to me, and I know it doesn't to you either. This special exception request must be denied tonight because of the severe negative economic impact this project will cause on homeowner value based on a closer look at the petitioner's own data. Ballot item number 3 denies any special exception which subverts the intent of the ordinances to protect other nearby landowners from harm and material or permanent injury. The petitioner's own data shows significant loss of home value to residents within 1 mile of the proposed project. You must deny this petition. Thank you.
Thank you. Just a reminder again, please look at what you have written and just don't read it. We want you to, you can read portions of it, but a lot of it is being the same information over and over again that we've heard multiple times. So please try and limit the repetition.
My name is Jeremy Spann. I live at 3312 Huxley Drive in West Lafayette. And I have gone through and looked at what I have, and hopefully I'm not going to talk too much about what they've talked about earlier. So as a local real estate agent for the past 7 years, I've had the privilege of helping hundreds of families buy and sell homes in Tippecanoe County. Many of those clients are new to the area, drawn here by the incredible opportunities our community provides. Those opportunities did not happen by chance. They are the result of intentional and unified planning for growth. Historically, I have supported area plans, recommendations, because they've been thoughtful and forward-looking. Tonight, however, I must voice my concern about what appears to be a complete lack of consideration for both the current and inevitable future growth of an area located less than 10 minutes from Purdue University. According to the report that was presented by the petitioners, you might think that Shelby Township is little more than farmland producing biofuels, that it's an area prime for sacrifice, and also that it's inhabited by cavemen. So I can tell you that's not the case. It's rolling hills, ravines, parks, quiet neighborhoods, and farms. It's close to highways, easy access utilities, proximity to amenities, and yet remains tucked away in nature. These qualities are exactly what attracts families to buy homes here and why those families who live here love it. To suggest that this area is not poised for growth over the next 40 years is baffling to me. The landscape is diverse and the population growth, even when including the part of the township north of 52, has been steady and moderate. It's never dropped below 2% between 2019 and 2024, and for a rural township, that level of consistency is remarkable. Historically, Tippecanoe County has had a level of constant, responsible growth that has become an envy of other counties around the country. This is primarily the result of the cooperative partnerships between two great cities, local leadership, local business and industry, as well as Purdue University. And this project is inconsistent with what has made us great. The petitioners are trying to convince you that this is not an area of growth that should be considered in area planning. As Purdue and other industries expand, the development of this area has grown and will continue to do so. For example, over the last 25 years, the unincorporated parts of Wabash Township have experienced substantial growth. From 1985 to 2020, the same area of Wabash Township saw steady growth of 2%. It's very similar to what Shelby Township has. And it grew from 213 people per square mile to 477. It's practically identical to the growth of the area of Shelby Township, which is currently sits at 195 per square mile. And it's seeing those 2+% increases. If you want to see the potential future growth of the proposed area for industrial solar, you need to look no further than the past 40 years of Wabash Township. Unlike neighboring Wabash and Tippecanoe Townships, Shelby has not had recent land use plan. Yet the growth patterns in those nearby areas mirror what is beginning to happen here. And make no mistake, this proposed industrial solar farm does not simply use land, it consumes it. It consumes not only thousands of acres for the next 40 years, but also the property values of every home within view. To claim otherwise defies common sense. So we saw all of the numbers about home values. Use common sense and think of it this way. If you were buying a home and your view was solar farm, would you expect to pay less than if your view was fields? Absolutely. So use that common sense when you're thinking about home values, because the numbers can be messed with. So why is this being treated differently than the projects that we've seen brought to the board?
1 minute, please.
There were minor residential projects smaller than this have been held to far more scrutiny and oversight. So why is this being treated differently? Back to Wabash Township, they experienced 25% population growth, becoming a predictor of what's to come in Shelby Township. As Purdue and other industries continue to expand, so will residential demand. Allowing industrial solar of this magnitude here would create an economic and visual barrier to the west of Purdue, effectively cutting off future residential growth for at least 40 years while lowering the property values and the quality of life for existing residents. I urge you, do not sacrifice the future of Shelby Township. Please deny this special exception.
Thank you. Next, please.
My name is Robert Zanke. I live at 3408 Apple Lane. Because of vision limitations, our son Matthew is going to read my concerns.
Please bear with me. This is my father's account and his letter. Otherwise, he would be able to speak freely. My name is Matthew Zanke. This is my father's letter. These are his words. We built our home in 2007 as our aging in place home, believing that we could live out our lives here. The only thing that separates our property from the proposed industrial solar project is the width of Apple Lane, which is about 30 feet. We thought that we had built in everything for the future, except we didn't foresee 2 battles with cancer, a broken hip, and vision loss. In December, we applied for residence at Westminster Village, were approved, and are now on the waiting list. At that time, we were completely unaware of any solar project nearby. Rainbow Trout kept that well under wraps. We had our home appraised. Estimates range from $600,000 to nearly $700,000. Neither realtor mentioned the solar plant project, further showing how hidden the plan was. Since our home is less than 50 feet away, current independent studies by 4 major universities suggest properties near utility-scale solar arrays will lose a minimum of 10% of their value. That equates to a $60,000 to $70,000 reduction in our net proceeds. The only thing that separates our property from the proposed industrial solar project is the width of Apple Lane, which is about 30 feet. That would be a major financial hit for us as we plan this next life step. Why such a large loss? Data shows that selling a home in a less desirable area reduces the number of viewings. Fewer viewings means lower demand and lower selling prices. Then in March of this year, a neighbor told us about the large industrial solar plant to be built across the street. We were formally notified by a certified letter in May from Rainbow Trout's attorney. None of us want to live next to an industrial solar plant. It has all the risks and hazards of a chemical plant. That by itself reduces the number of home showings, and fewer showings mean lower demand and lower sales. My undergraduate degree, my father's, is chemical engineering, and I spent nearly 40 years in the chemical industry. You may notice I refer to this solar array as a solar plant. This is not a solar array. It is not a solar farm. It is a chemical plant. Few, if any, of the 200 plus affected homeowners would build a home next to a chemical plant, and that is exactly what is being proposed here. And I doubt that anyone would build next to a Staley plant as pictured in the slide. I know we wouldn't. In a chemical plant, you have raw materials. In this case, the raw material is sunlight, and its final product is electricity. In between, there are processes and equipment, solar panels, inverters, warehousing of electricity using lithium batteries, and shipping electricity from a substation to customers on the East Coast. But it doesn't provide electricity to Tippecanoe County. And just as there are safety and environmental risks in a chemical operation, there are similar risks and hazards in operating solar plants. In many chemical operations, there are waste products generated that must be treated and safely disposed of. The solar plant presents similar hazardous materials such as cadmium, lead, and arsenic, as mentioned before. These can leach out of the panels as they deteriorate into the soil and eventually find the way to our aquifer, which will poison our water supply. The other hazardous material is electricity and its associated risks and lithium batteries, which have a history of catching fire and exploding. All these conditions, again, contribute to fewer viewings and lower selling prices for homes. I would hope that no one would approve a chemical plant in Shelby Township. Finally, this isn't a minor exception. It's a major rezoning decision. Would you grant Tate & Lyle or Staley a zoning exemption to build on this prime farmland? The answer should be a quick no. How then can you approve in the middle of a neighborhood a zoning exemption for an industrial utility-sized solar plant to be built on the same site? Both have similar risks to residents, the environment, and do nothing to aid the local economy. As homeowners, we have rights too, and only 30 feet, the width of Apple Lane, separates our home from this project. Thank you for your time and attention. I urge you to deny this fatally flawed request and mark your vote for ballot item number 3, that this proposal does not meet the ordinance and does harm to neighbors and the environment. Thank you.
Thank you. Did we get an address?
3408 Apple Lane.
Okay, thank you. Next, please.
Hi, I'm Tammy Sandel from 7605 Amanda Lane, West Lafayette. My home is 0.3 miles from the solar installation. Those are my dogs with their home with their legs crossed, probably like all of yours too. And I'm speaking in opposition to the project due to incomplete and inadequate assessment of wildlife and habitat. This study fails to identify the presence of these endangered and legally protected species in the fields, wildlife, and wetlands, and the woods surrounding the solar installation. Sandhill cranes, great blue herons, terrestrial box turtles, the Indiana bat, and bald eagles are all protected federally or by the state of Indiana, or in some cases both. The petitioner's study was pretty minimal. They did online map reviews and then on-site visits over a 5-day span from March 31st through April 4th. That's when wintertime conditions are still prevalent. Maybe you could call it early spring. I checked online, one of the nights it did get down to 32 degrees that night. So it's really not any surprise that they didn't see some of these species who were still hibernating or hadn't done migration. The sandhill cranes migrate, that was the tail end of their migration time, so maybe they just missed them that way. But a check with local environmental groups or people who live here year-round could have easily confirmed the presence of these species. I have personally seen every single one. I wonder if people behind me, raise your hands if you've ever spotted any of these species in the trees or the fields. Yeah. It's beautiful. One of the highlights of my life was seeing a family of bald eagles out for their flight over Kerber and over the fields. The two adults with white heads grasped talons with the juveniles and practiced cartwheeling. It's a breeding practice and hunting. They were teaching them, just like we teach our kids how to ride our bikes on Kerber. So, to clarify, federal protections for eagles extend to their feeding grounds and breeding areas, not just their nesting locations. Eagles frequently use the fields for hunting. The monarch butterfly is a proposed threatened species internationally. They migrate into our area around mid-June and back south in late September, feeding on milkweed. The 2-year solar construction period will significantly disrupt their primary food supply and a substantial habitat during their 3,000-mile journey. Fencing we've heard about. The deer, coyote, and fox that roam this land freely will not be able to get through this fencing. It's too small for anything but a rabbit to fit through, and the study has no assessment of fence line barriers to terrestrial animal movement and what that might look like as things unfold. Finally, 2 key research sites are right near the proposed site, and they underscore the importance of the connection of our local ecosystem. Martell Forest and Purdue Wildlife Area, which is literally across the road from the proposed site, work every day to understand and sustain migratory bird patterns, air and soil temperature and quality, natural acoustics in the woods, and the rare mix of wetlands in the Indian Creek watershed. The petitioner's study completely ignores any potential impacts on any of these environmental aspects. I urge you to vote will not for ballot item 2 because no federal approvals have been secured for bald eagle habitat, and ballot item 3 calls for you to deny a petition if it subverts the general purposes served by the ordinance. This project presents no plan to minimize impact on our local ecosystem. It fails to even identify sensitive species, much less comply with the legal requirements to protect them. Thank you.
Thank you. Next, please.
Hello, my name is Elizabeth Muller, and I live at 5960 Hoover Road, 1/10 of a mile from ground zero of an electrical substation, battery storage area, and banks of solar panels. I'm going to speak to ballot factors 3 and 4A about public safety and traffic. I'm a school bus driver. My route is in the heart of Rainbow Trail's construction zone and will be heavily impacted. I pick up students on both sides of Jackson Highway, 600 West and 350 North. Each of these roads I drive has construction planned for solar panels, an electrical substation, and battery storage units. My number one concern as a school bus driver is to get children to school safely. Navigating traffic and road conditions in a large vehicle with precious cargo is a challenge on a good day. Jackson Highway is the busiest and most hazardous road on my route. Months and years of construction will make my job more dangerous. I cannot choose another route for my job. Children need to get to school. You can see on this slide that the traffic study on pages 509 through 549 does not accurately reflect the hazards the construction will create. The traffic counts were measured at locations that were miles away from the actual project area. Traffic count locations do not include areas impacted by construction traffic or any county roads directly used during construction or routine operations. The county roads that should have been in the study are narrow, curvy, winding, and most have no shoulders, just like my bus route. They have multiple turns, blind turns, curves, hills, and are a mix of gravel and pavement. There have been 3 fatal accidents on Jackson Highway in recent years, which proves the danger of the roads in question. Rainbow Trout has not provided any assurances about how the roads will be maintained during construction, and they have already damaged roads and fields in this spring to do soil testing without getting proper approvals from the county, and it hasn't been repaired. Nearby counties have all experienced the damage and deterioration of county roadways during solar facility construction. The petitioner has given us no reason to believe they will prevent the same levels of roadway damage here. There is also nothing in the plan about heavy or wide loads, no provisions for dust control on the gravel sections, no provisions to control mud migrations on the roads during heavy work activities. Please vote on ballot factor 3 that this project will endanger public health and safety with construction traffic, and on ballot 4A that the traffic will materially injure others using these rural county roads. Thank you.
Thank you. Next, please. Sign in.
Good morning. My name is Bob Feimster. My wife Gwen and I live at 5920 West, 350 North, about 250 feet from the proposed substation. You'll all be happy to know I've crossed out about half of my report here. I'm here to ask you to deny this petition because of unacceptable light pollution on my property and 20 others along County Road 350 North, Jackson Highway, and Hoover Road. Our neighborhood is being blasted out of our peace and quiet into 24/7 industrial noise and lights. The proposed electrical substation will create continuous noise and bright light all night right next door. Even with the new increased setbacks GeneX has proposed, these effects will still be there. We know this new substation will generate light pollution similar to the large public utility substation already on the opposite side of my property. My home will be bathed in outdoor light glare in all directions every night for the next 40 years. How much negative impact and serious harm should nearby property owners have to take? We're getting personal health impacts from light and noise pollution. We're getting a mile-long view and glare from a solar installation. We're getting fire danger from panels and a possible battery installation a few hundred feet away. We're getting 2 years of construction traffic literally at our front door. And don't tell me my home value and my health will not be negatively impacted. I know I will suffer a major loss in my home value if I can find a buyer. The county has an ordinance 4-10-4B, which limits illumination from an industrial source. No data was provided to show if the ordinance is met in this project. Light pollution is your ballot item 4B. And you must vote to deny if lighting will materially and permanently injure other property users in the vicinity. I'm here to tell you that I am one of many where material and permanent injury to our properties will occur every night, all night, due to the light and noise pollution of the substation. Please deny this special exception. Thank you.
Thank you. Next, please.
My name's Ty Muller, and I live at 5935 Hoover Road, neighbors with Bob here. I'm speaking on ballot factors 2 and 4C. Specifically, I'll explain how the noise of the project violates our ordinance and damages the quality of our surrounding properties. 7 years ago, I bought my first home. I chose that location because of the distance from Lafayette and West Lafayette. It's a short drive, but it's still removed from the busy city life. My neighbors and I take pride in the rural charm, the peace and quiet, and the sight of open fields, and we rely on the ordinances to protect the enjoyment of our property. The UZO has noise standards. In sections 4-10-6-B-1, Category A, states that the maximum permitted sound level to be heard in any residential zone shall not exceed 45 decibels between 9 p.m. and 7 a.m. Rainbow Trout submitted a noise study with their applications at page 454 through 490. The study is sloppy and shows how closely we need to scrutinize Rainbow Trout's entire application. The study states at page 457 that it relies on the Shelby Township charter noise regulations, But our Shelby Township here in Indiana does not have a charter or specific noise limitations. The document also states the project is subject to a 65 decibel noise limit. But this is not correct. The limit section in 4-10-6-B-1 is 55 decibels during the day and 45 decibels at night for residential zones. The study expressively admits in the data table on page 485 that nighttime noise will be above 45 decibels at 7 homes. All 7 of these homes are in an R1 residential zone. My home is one of these 7s where noise will exceed the limit set by the ordinance. Unfortunately, the location has lost some charm already since buying my house, thanks to the American Electric Power increasing the size of the already existing substation to the north of me. They've made it louder, brighter, and more invasive. There's now a double prison-like fence with harsh lights and cameras pointing straight at my house. I hear the noise and feel the vibrations from this current substation 24 hours a day, 7 days a week. If Rainbow Trout is allowed to build a second substation, I will be trapped in an inescapable bubble of constant humming. The noise will be damaging to my health and my ability to enjoy my home. I'm a mason by trade, and this is way out of my area of expertise, but when I realized the impact I had to get involved. Noise is just one cracked brick in a wall that should never be built for many reasons that you've heard tonight. You must mark on your ballot items 2 as will not, because Rainbow Trout's own noise study shows that this project will violate the county's noise ordinance. You should also mark ballot factor 4C and 4D as will, because the project will be damaging to neighboring properties based on the excessive noise generated 24/7. Thank you.
Thank you. Next, please.
Catherine Soborowski, 938 Chepstow Lane. So I've got some really good news for you. I'm the last person in this slideshow presentation. Hey! And they're way overconfident in me because I'm a lawyer by training. So they think, oh, she's going to get up there and wrap up the 10 people we just cut out of the list perfectly, and she's going to say everything they wanted to say. I'm not. I can't. It's not possible. I have 5 minutes, right? But let me give you the highlights. We've cut 10 people. We understand it's late. We know you're tired. It's the biggest project the county's ever seen. That's why we've got so many folks here, why they've done so much research and thought so much about it. Some of the things that we're cutting out tonight, we're not going to talk to you about what we think of the econ impact study. But what I do want to say about that is we've had some folks down here to talk to the county assessor to just understand, do those numbers seem even remotely right? And the answer there was, well, we're not really sure. There's a lot of complicating factors. But you don't even really need to go that far in what the county assessor says about it. Just hear what Gen X said about it a couple weeks ago in Decatur. They said after SB1, there's basically no certainty whatsoever that you'll get any level of long-term tax revenue from this. So to make up the difference in that county, they offered an economic development agreement with big bucks. Nothing like that on the table here. So I think we'll say just skip past the economic benefits for the community. They're not what they are stated in the application. Another thing folks wanted to talk about, and you've heard a bit of tonight, is the battery situation. And I know you're thinking, well, they said it's not there. But listen, there's a technical document in your application packet that shows you it's there. It's in the generation interconnection agreement, and the reason it's a problem is because they've been given authority to put 88 megawatts of energy to the grid. And they're building for 120, so you've got to make up the difference somewhere, right? And in that GIA contract, they say, okay, we're doing the 88 of the solar, and then you can have 356 megawatts of battery. There's also financial penalties with not building out the specs promised in the contract to the grid. So you can start to see why we're kind of obsessing over the batteries. Not only are they dangerous, but there is a binding document in the application that says they might be there. So if they don't come next week or next year, the year after is not speculative, it's almost certain. So don't ignore the risk of the batteries. That's plainly in the application. There's also a diagram of the property where they would be next to homes, right next to Ty's home, in a tiny little triangle on top of my neighbor Jim's house. This isn't something we're just imagining. This is real. In addition to the economic issues, we also wanted to talk to you about construction noise, 60,000 posts being driven into the ground. I think you can imagine it would be like this all day while I work at my desk, right? Sunrise to sundown, so pretty easy to understand that one. So those are the basic speakers that we cut out, and now I'll conclude for you. Dear members of the board, this is not a time for leniency. This is not a time to ignore the rules. Tracy Brown was already up here tonight to express to you we have serious concerns about if these rules are good enough to protect us. And our attorney, Jason, has already explained to you at great length how the rules have not been satisfied by this application. 5 of the items required under the ordinance are completely missing: drainage, driveways, power purchase agreement, federal and state approvals, and one more that I can't remember at 1 a.m. But 5 are missing, and then 5 are speculative. Not really all the way there, not completely missing. So you have an application before you tonight that actually doesn't meet any one of the 9 factors in entirety, which means beyond a doubt, there is no way, just under the law on the books in this county, that you can possibly approve this thing. So on ballot factor 2, you are mandated by the law under the Unified Zoning Ordinance to say no. On ballot factor 3, when we're thinking about public health, safety, and welfare, you've heard our property values might go down the drain, dangerous from the fire department, other things like that. And on ballot factor 4, you've heard about the noise, the traffic, 24/7 operations, and how bright it'll be. So I think we've pretty much demonstrated that the entire ballot shows you this thing is a loser. And that's all you need to know.
Thank you. Anyone else wanting to speak in opposition?
My name is Sally Moeller. I reside at 4033 Willowwood Drive, Lafayette, 47905. I've been a resident of Tippecanoe County for over 67 years, and I was born here. I'm here to express my opposition. I believe it should be denied for the following reasons. Number one, the recent termination of federal subsidies for solar projects, as well as the denial of solar projects on productive farmland. The second is national security. Recently, multiple departments in the federal government, Ag, EPA, and Treasury, have totally stripped any federal subsidies or tax credits for solar and or wind power projects. This just happened in the last few weeks, even like 8 or 9 days ago. These subsidies have been instrumental in providing seed monies for construction of these renewable energy facilities. Without these subsidies, many proposed projects will fall by the wayside. What impact will this have on the proposed solar project? New rules outlined by the Treasury Department on August 16th narrows down the definition of projects considered to have begun construction, replacing the previous rule that allowed developers to qualify after incurring 5% of the project costs. This 5% safe harbor rule is no longer available to determine whether a wind or solar facility has met the beginning of the construction deadline. Developers now need to prove they started, quote, physical work of a significant nature, unquote, to establish that they have begun construction, and those projects must be continuous. Preliminary activities such as mapping, clearing a site, test drilling, and excavating to change the contour of the land are not considered the beginning of construction. This project does not qualify for these federal subsidies. We don't need a project that in all likelihood will be discontinued for a lack of funds. Termination of solar and wind projects being placed on productive farmland. You've already heard about how Ag Secretary Brooke Rollins has stopped all of its programs that funded solar or wind power projects on productive farmland. She talks about from 2012 to 2020, more than 70% of solar farms in rural areas were installed on agricultural land. As of 2020, wind and solar projects took up a total of 400,000 plus acres of farmland. Halting renewable projects on U.S. farmland marks the end of panels being made by foreign adversaries like China. And you've already heard the presence of toxic materials in these solar panels. There's also a threat to national security. Surveillance bugs kill switches, and cellular radios have been installed in many of the solar panels manufactured in China. Since approximately 90% of the world's solar panels are produced in China, this poses a potential national security threat to our country. These surveillance bugs can collect intelligence information, and the kill switches can be activated from a distance to shut down our electrical grid. Purdue has a number of national defense research labs. The Chinese are keenly interested in the intellectual property of these and other research labs. In late May, the U.S. State Department cited Purdue as being one of 6 universities in the country where high-value STEM research has been targets by the Chinese to send back to China. These bugs can collect data from remote locations. In other words, they can spy on us. And these have been found here in the United States already. While inverters are built to allow remote access for updates and maintenance, the utility companies that use them typically install firewalls to prevent direct communication back to China. However, rogue inverters provide additional undocumented communication channels that allow firewalls to be circumvented remotely. These rogue inverters could change their settings, destabilize power grids, damage energy infrastructure, and trigger widespread blackouts. I respectfully request that the Area Board of Zoning Appeals deny this special exemption. Thank you.
Thank you. Please sign in. Anyone else wishing to speak in opposition? Hearing none. Ryan, you have a rebuttal?
4 hours ago, I asked that we focus on the facts and not unfounded fears, and a lot of what we've just heard about are other counties and other projects, and despite my opening comments that there are no batteries in this project, we still heard an awful lot about batteries. To be clear, we removed the batteries from our site plan. Now our team will help us to refocus on the facts. Unfortunately, we have limited time to provide rebuttal for over 3.5 hours of comments, so we have organized our comments into a few categories, and I'd remind you that we have multiple experts here to answer questions that you have this evening, or I guess this morning. I'll start with the perceived procedural issues with our submission. We attended the pre-submission meetings with area plan staff with written consents from property owners, which is standard practice in zoning matters in Tippecanoe County. Mr. Clevenger, earlier you said that BZA doesn't control the ordinance, and likewise we don't either as the petitioner. We have to work with what we've got. There's an or in our ordinance that's very important and can't be overlooked. Even the opposition mentioned multiple times that depending on the circumstances, some things may be required and other times not. And of the 9 items listed in the ordinance, not all of them are required for both improvement location permit applications or special exception applications. In fact, there are some of those 9 items that aren't even items to really submit. They're simply order to, for example, not to plant invasive species. That's not something we can actually submit. That's something we have to comply with. I'd like to reiterate also that Stu Klein and Zach Beasley confirmed that driveway permits and drainage plans would never be approved prior to a special exception application. That's coming from our county surveyor and highway department. With respect to the Mammoth Solar case that Mr. Kuchme mentioned earlier, the petitioner in that case acknowledged that they didn't comply with the ordinance. That ordinance had very specific requirements for special exception applications specific to that application. Unlike our ordinance that includes the or, that ordinance didn't have language like that. Completely different ordinance than what we have here. And we are certainly not acknowledging that we have an incomplete submission. We have made clear that our position is that we have strictly complied with the submission requirements of the ordinance. It's also worth noting that Mammoth Solar ultimately did get approved and it's currently under construction. The real reason anyone would challenge the sufficiency of our application is to try to kill the project with the county's moratorium. Opposition is desperate for you to not decide this project on the merits because deep down they know that there's really no legitimate reason that this project should be denied. With that, I will hand it off to Paul Wyman, who will address property values.
Good evening, ladies and gentlemen, the BZA. Thank you for your time this evening and for your efforts in this entire project. My name is Paul Wyman. I'm from Kokomo, Indiana. I'm the president of the Wyman Group real estate firm. We'll be celebrating our 25th anniversary this coming January. Also spent 16 years in county government, retired just a couple years ago as Howard County Commissioner, and the bulk of that 16 years I spent as the president of the Board of Commissioners. Much experience in things that you're all dealing with tonight. I helped craft the ordinance for our solar ordinance in Howard County. Been involved in economic development agreements, road use agreements, decommissioning agreements, and the whole bit. And also, other thing I would share with you is that Governor Holcomb appointed me last year to the Indiana Land Use Task Force Committee to study land use in the state of Indiana, not only currently, but also for the future. And my background and my experience in government and in real estate led me to be appointed to that position. So before I share with you my thoughts on property values, what I would like to say to you all tonight is I have zero financial interest in any solar farm. I have zero financial interest in any solar company. How I end up in these situations where I'm asked to speak around the state is because during my time in my tenure as a county commissioner, in meetings just as this, when information about property values and other things were brought up, I was much as you guys is interested in what were the real facts. And me having access to the MLS, the multiple listing service, the actual data of sales in our communities is what became really important. And as I shared that in public meetings, people around the state caught on to that, not just BZAs, but plan commissions, county commissioners, many other folks, which is why I've been invited to speak at many places. And so what I'm here tonight to share with you is what you're hearing from all these folks about property values is not what we're experiencing 45 minutes down the road. In fact, what we're experiencing 45 minutes down the road in multiple alternative energy projects is quite different. And so the handout that I just provided to you all this evening, I'm going to step you through this real quick to help you understand what we're experiencing just down the road. The first one is the 125 turbine wind farm in Windfall, Indiana. This literally is between my office in Kokomo, Indiana and Tipton, Indiana. And when I was county commissioner, we were doing all this property value study. This is the first alternative energy project that was at the table that I was able to sink my teeth into and say, I'm going to track every single sale within this 125 wind turbine area and all the sales around it in Windfall and Elwood, just outside the wind farm area, and track those differences. So if you'll flip to the next page, you'll see I've broken it down into 3 different real estate trends, 3 defined real estate trends. From 2018 to 2020, pre-COVID, the sales in the wind farm area, the designated wind farm area, had a list to sale price ratio of between 5 and 6%. 4% in the entirety of the area. A 1 to 2% difference literally in the middle of the wind farm area. During the COVID time of March 2020 to 2021, there was a 3% difference in list to sale price ratio. No impact on property values during that time. And then when the real estate market really heated up in 21 to 2025, there was a 1% difference in list to sale price ratio in the designated wind farm area and all of the homes outside of the wind farm area, surely highlighting no impact on property values. The best way I could provide it to you is the next page is to give you this visual. Here is a property that sold during that exact time frame. $400,000 listing surrounded by 7 wind turbines. The red circles are the wind turbines, the black square is the home. Listed at $400,000, sold within 2 days for $400,000, and closed several weeks later. We have studied that home immensely, and I have 8 or 9 comps to show that it was treated as fairly as any other property in that area. Now I'll move to the 2 solar projects that are happening in Howard County, one by NG Solar, one by Ranger Power in Greentown, Indiana. This project, the announcement period was the beginning of 2022. And what we did at the beginning of 22 was started to track every single sale in Greentown, Indiana, and every sale in the designated proposed solar farm projects. You'll see on the next page, I'll sum it up for you. In Greentown proper, any property with a Greentown address, $58,890,000 worth of properties listed since 2022, 57,968 sold, a 1.5% difference. In those two designated solar farm areas that I showed to you, Ranger Power and Engie, Ranger Power had a 1.5% difference in list to sale price ratio, and Engie Solar had a 0% difference in the designated areas. If you'll flip to the next page, I'm going to show you, to sum up my comments, 2 sales that closed last month, literally across the street from the designated Ranger Power Solar. Both of them sold at full price. Both of them closed last month. My whole point to share with you this evening, ladies and gentlemen, is you've heard everything from 8% to 40%, and here's what I'm going to share with you. There are studies from Lawrence Berkeley. It was talked about, Loyola University, University of Rhode Island. We have all these universities conflicting. People say to me all the time, Paul, what's happening in Indiana? What's happening right here? Put all these studies aside. What I'm bringing to you is real life data from the MLS on property sales. I would invite anybody in this room to come to my office. We'll sit in the conference room. We'll pull up any one of these sales, any time period, any property you want to look at in my study, and I'll show you the exact data. That's how much we believe in this data, and that's how factual this data is. 45 minutes down the road, anybody's welcome to come and join us. I'm not a 25-year real estate broker.
Good evening. Try and make this quick. My name is Eric Olson. My address is 7806 North 200 West in McCordsville, Indiana. I'm a senior PM with the Project Execution Department with RWE, responsible for seeing these projects through construction as we take them on. So I will say that much of my career, I'm a civil engineer by trade as well, so I have some experience in the site world. To address quickly some of these grading concerns people are talking about, I just want to stress with this site, in particular on all of our sites, generally moving forward, we minimize site grading. We don't mow hills over. We don't do any of that kind of stuff. We have new technology and tracking systems that follow the terrain, so our impacts to the earth are very minimal at that point, which is a great benefit to the existing subsurface. They talked about topsoil being stockpiled. When we do that on a site, we just do that temporarily. A lot of times it's stockpiled to make us some lay down yards, do some other things. That's restored, respread at the end of construction. That's a temporary measure, and those soils are protected during construction. As far as the compaction concerns, I just want to say that as mentioned, we'll have minimized mass grading when we're using large equipment. And I also argue that our short-term use of this mid-size construction equipment for the type of work we're doing, in the short term, has far less effects than a lot of the larger farming equipment year after year after year that treads on that land. So I think we have a very minimal effect in terms of equipment. As far as the drainage concerns, they showed some previous slides that showed like ponding water around modules and stuff. I just want to stress that those kind of photos shown are during construction. That's before final gradings occurred. That's before any vegetation is established. So yes, that occurs on occasion, but that's remediated fairly quickly. And those are just after rain events before things soak in. So we're aware of that, and we mitigate that to every degree possible. In terms of drain tile, I could say that they said that we don't do anything until 40 years down the road or whenever it's decommissioned. That's not correct. We address those things and have budgets to replace those drain tiles and fix them as those are damaged and found during construction. So, and in terms of the runoff concerns, like I said, during construction, we use extensive erosion control measures. There's lots of new technologies and designs out there that help us attenuate water. We're also using, we're going to be following the stormwater ordinance that's in place. A lot of temporary, permanent sediment basins, traps, attenuated flows through structures and such. So we take that very seriously as well. Let's see. And then as far as the ditch concerns, I heard some concerns about ditches. also carry a budget during construction related to ditches and culverts that might be damaged. And admittedly, sometimes those things get damaged, but we're there, or we have a construction team on site that's there all week. I'm available by phone as well. I may not be there all the time as a project manager, but have our phone numbers. We deal with residents when we build these sites continually, address their concerns, have budgets to replace these things, and help the residents as they see fit, and we work closely with them. So I just want to point that out. And then I guess take some time for some other people. I'll just say we have Colleen, who's also an expert here, some of these drainage concerns, so she'll be able to answer some of those during the Q&A. Thank you.
Thank you.
Hello, my name is Jason Winnick. I'm from 353 North Clark Street, Chicago, Illinois. So we heard a lot today about the loss of ag land in production and the impact that has on the community. And we're aware that solar is, a big change for some people. The rainbow trout team and I empathize with that, sure. Solar is proven by the APC staff to comply with the UZO, and landowners chose to sign on with rainbow trout. Landowners are the backbone of every project with at RWE, and their interest is what brought us here today, nothing else. That is backed up by how we treat the communities during construction operations, and I encourage you to speak, our operations team here today. This land is used for 35, 40 years, and then it's returned to whatever the landowners chose to do with it. Some of them may not have been farming it anyway or choose not to in the future, but that option is there for them instead of having them sell the property. Some other benefits outside of just for our landowners, this clean power generation meets Indiana's growing industrial demand for electricity. Indiana is a net importer of electricity, and this helps Indiana and the U.S. gain energy independence, which I heard is a big topic here today. Renewables are the cheapest, come online the fastest. We've talked about that a bunch. There's native plants, pollinator species that attract, the wildlife that we saw pictures up here today. And the native vegetation acts as a buffer to prevent some of the concerns that people here had. We saw a few points on transmission. The project uses existing infrastructure and prevents utility upgrades, which is a huge savings to taxpayers. And so the utility switchyard's already there. And so that's where our substation will be built. There's not going to be a new one built outside of that. Ag is a large part of Tippecanoe County and Indiana as a whole. And as our landowners and supporters here today will tell you, as you all think about, alternative uses of this land if landowners didn't sign on to this project and permanently took the land out for agriculture. So this project keeps agricultural land in families, which I'm sure resonates with a lot of people in the crowd here today.
4 minutes remaining.
Good morning. My name is Mark Quarles. I'm the Environmental and Permitting Manager for RWE. My address is 353 North Clark Street in Chicago. I'm here to speak to you about the unfounded claims that I think the terms contamination and poison our water supply and toxic chemicals that would be associated with an industrial solar farm. That's just without facts. That's given you statements based on fear without facts. When you do the research, like I have on the facts, you will find that academic institution, University of Michigan, Michigan State, North Carolina State, the state of Michigan have all determined and concluded with their studies on solar panels, and I'll quote their conclusions, where the risks were negligible, insignificant, in orders of magnitude below EPA standard for air, soil, and groundwater, and that's based on factual scientific data. And why are the risks insignificant? It's because of the way the panels are manufactured. There are multiple layers of combinations of plastic, glass, tempered glass, and the cells are in the middle, sandwiched between. They're meant to withstand extreme weather events. They don't break in small pieces. When they're broken, they're promptly removed from the site. So the facts don't support any fears about contamination of aquifer and contamination of soil. I will say, too, on the weather damage claim, warranty returns are 0.04% of all panels that are used in the U.S., which is including transportation, which is the majority of the breakage. And our panels are warrantied up to 1 inch in diameter hail. So that would have been included in the 0.04%. So these things are meant to last, and they're meant to be very durable. Thank you.
Chad Martin, Stantec Consulting Services, 1455 Meadowbridge Drive, Greenwood, Arkansas. 2 minutes, so I'm going to talk as quick as I can. On the topic of wetlands, we completed wetland delineations. No wetlands will be impacted by the project infrastructure. As far as streams go, there are no access road crossing existing streams. There's only one area where we think we might have a temporary impact for an MV cabling. We're looking at possibly horizontally, directionally drilling that, therefore avoiding any impacts and avoiding any permitting. Any permits that might be required will be completed using nationwide permits. They're out there, they're ready for us to use. We can use them tomorrow. Listed species federally. We had 4 species on the list, 2 bats, 2 mussels. We will have no impact to streams, therefore no impact to mussels. Bats for solar, for the most part, we're looking at foraging in the forests or daily hibernating in the trees in the summer. We will have no impact to the forest or trees, therefore no impact to those species. Eagles are protected, their nests protected under federal regulations.
30 seconds.
We did not find any nests while we were doing our surveys on site. As far as monarch butterflies go that are proposed, the addition of grasses and pollinators will actually help that species. It may be a benefit. Glare study was completed using Forge Solar glare analysis software. We found no glare along project roads to
Your
neighboring.
time is up, sir.
Thank you.
Thank you. Now it's time for questions, comments from the board.
Yeah, I have a few questions.
Sure, Tim.
For REW and their affiliation, I have a few questions. The first question will be in 3 parts. Now, since the power and economic exchange is still being negotiated, we don't have some of those details for the local site-specific location, but from a comparable property standpoint of places in your network, how far does the energy usually travel through the grid to your customers?
Yeah, Jason Winnick. The power will, disperse throughout the grid. We can't exactly point to exactly where it's going to go, but the power will be used where it's needed. So it could be used locally, travel. Yeah.
So is it in your opinion that you'll be using possibly local, maybe Duke, Tipmont, REMCs locally, or is it going to be shipped out elsewhere?
It could be used locally and shipped out elsewhere. Depends on where the power demand is.
Any plans for negotiations with local utility companies?
For the power
proceeds
purchase
here? Yeah.
Yeah, I think we're currently discussing all the offtake options. We haven't secured anything yet, so we're exploring our options.
Does the lack of battery technology limit you from even considering that local? Because the demand might not be.
Not at all. So oftentimes too, if we even had a battery, which we don't here, it functions as a standalone. And so it's not directly connected to the solar. It doesn't have direct benefits to that project.
So again, let's say answer a question about transmission. How much loss do you usually see from proceeds localized being transmitted over your infrastructure and even to a grid that you don't control?
Yeah, that's a good question. I would have to get back to you on that.
Hi, Mark Schuler again. Our energy is measured at our point of interconnection, and we'll have a meter there which calculates how much energy, and it goes into, when we ramp it up to a higher voltage, for the higher voltage lines, the losses could become much more minimal.
So it's like an investment of a property you have vacancy, maybe 5-10%. So would you say you could have the proceeds of energy being done here with solar, could it be 10, 20, like just in your opinion, you guys are the experts, how much energy is lost?
Based on
Your produce of energy, how much could be lost?
The losses, it depends on, it's pretty low based on our point of interconnection. Our biggest losses will be in our collector lines from the south array to the north array. And I don't know, Baton, are you still here? You're still awake? Good. Say your name and address.
Good morning, Vatan Kumar, electrical engineer, 405 North Wabash, Chicago. So the electrical losses go down as you go up in the voltage. So 0.8 is from the inverter to the substation. From the substation, it's like 0.1 or even less than that. So it's very, very low. And this substation is just next to the switchyard, so it's even low. I'm an electrical engineer by my master's from NC State, and that's what I teach as an assistant professor. So this is something I read every day. So it's very, very minimal.
Thank you. Next question would be, since the technology has got better, that's a good thing. Subsidies might be going away. I'm not going to cover that. But the cost to remove such a solar farm in the U.S., probably not much of a comparable since it's newer technology here. Would you have, could you kind of give an idea of what it would cost currently to tear out a farm this size? And if you don't have something here in the U.S. to compare to overseas, have you had experience dismantling these properties?
I'll start with the last part of that question.
Okay.
I don't have experience with dismantling
Name, please, for the record.
Chad Martin with Stantec. We did do the decommissioning plan. It was roughly $8 million with 2025 money. That's calculated looking at labor, equipment, materials, using RS Means, which is a public paid for service. They have 90,000 points of data across 950 locations across the U.S. So you can get real, what we believe is the best data available in the state for that type of work.
Okay, last question. I won't hog the other members. So for this project, since we don't have leases to review, nor that I'm an expert at reading leases, if a property owner said, hey, a lot of developers, when they develop land, sometimes they like to scrape soil for a profit. Sometimes it's a nice byproduct. Is there any stipulations in the lease or agreements? Because the landowners own the land. If they want to sell proceeds and make money off topsoil, could they do that?
Hi, Miranda Norfleet. I live at 1911 Heather Street, Austin, Texas, and I'm an attorney with RWE. Our leases don't specifically restrict or contemplate that dynamic with landowners pertaining preserving the right to retain the topsoil. It certainly would have been something that they could have negotiated if they preferred to, although that would have been confidential. But as a default, that isn't in the lease. In practice, we desire to maintain a really strong relationship with our landowners and accommodate their requests where we can.
So these negotiations could be still ongoing with the landowner for this topsoil?
So, I mean, yes, our leases are executed with all of our project landowners. But if they came to the table with a new interest in a different use for topsoil, it would certainly be something that we would entertain, to the extent feasible.
Thank you.
Anybody have questions?
Yes, I've got a question.
Sure, go
I've
ahead.
got a couple questions, actually. One would be about decibel ratings and noise, because I know that's been a concern. So whoever could answer that.
Chad Martin with Stantec.
Thanks, Chad. So I understand that the inverters and the cooling fans are the main contributors to the decibel ratings and the noise. If you're within 1 meter of one of these inverters or a cooling fan, what's the decibel rating?
Within 1 meter,
Yeah.
3 feet, I think we had them in the noise study at 89 decibels.
Okay, and how much does that decrease the further you get away?
Well, there's a lot into that, but let's just say at the fence line, we had nothing over, I want to say on average 45 decibels at the fence line. There were only 7 receptors that were over 40 decibels, period.
Okay, and then the nearest home is maybe 50 feet away from the fence line, is that correct?
I'm not positive on the setback on them, but I know that we did have one that was modeled at 49 decibels.
Okay, and I think is the EPA recommendation like
55?
55, and is there an evening recommendation also, or
50.
a standard 50? Okay, so at least you're.
And then I think the
below
township, I believe, is 65. Is that correct?
I'm not certain on that, but yeah.
Oh, okay.
Okay. That's- And then what about the substations? So that was another concern that came.
Modeled at 100,
Okay.
101 to be exact.
Okay, and then what's the furthest property away from the substations? Do you have?
I don't have that on the top of my head. It's in the report, Table A.
Sure, okay, I'll take a look. And then my other follow-up was to Tim's question. So you haven't torn down, you haven't been involved in a decommissioning.
I have not.
But elsewhere in the world, there probably has been, whether it's in the United States or somewhere else. Are you familiar with what those costs might be for decommissioning elsewhere, maybe with another company?
Yeah, so the folks that put together these plans are engineers, civil engineers, so they are the experts in those plans, and the information they're pulling together takes a look at all of the most current data available.
Okay. But that's not a number you have offhand. That wouldn't be a dollar figure you have at the top of, like on.
For this project,
Yeah.
it was estimated at a little over 8 million.
Or for any other project. You wouldn't actually know that number. That's not something.
I don't know the number. I've seen many of these plans, and I can tell you they range from 8 to 12 million, depending on the megawatt size. And
Okay. My last question, at least for now, would be, so say REW was taken over by someone else. Say someone else took over this lease in 20 years and was managing the property. Would they be required to do the same decommissioning plan? Would they have to hold the same bonds? Would they have to?
Miranda Norfleet, again, yes, they would be bound by the same decommissioning obligations, and the decommissioning plan would bind any successor.
Thank you.
And Brad, to that end, one of the commitments was that rainbow trout or responsible party, if transferred, shall recalculate and file that new estimate every 5 years.
I do have a question about the substation. I know that triangle where there's a substation that is not under your control, that is to the north of a number of residences. It seems awfully bright, according to at least the pictures we saw. How is the lighting on the substation that you're putting up that is to the south of those? I'm concerned about that triangle of where there's a number of residences.
I have a question again, so I can follow it better.
There's-
Smith, Operations, RWE.
There's a substation that is to the north of that kind of that triangle there where there's houses that's not under your control. There's a picture that was brought up that showed that was extremely lit up. You do have a smaller substation that is to the south. I believe that's in pink there. How will the lighting on that be compared to the lighting to the one to the north?
So that one is definitely lit up, for sure.
Yeah.
On ours, we typically do 4 lights, one at each corner of the project, and they're going to be pointed inwards. So if we were to think of this as the substation, each one's going to be pointed inwards and down, and then maybe 1 or 2 lights at the actual operations building or the SCADA house, control house for the substation.
Okay, so it will not be nearly as lit up.
No, they
As
got
the
a deal
other
on lights, for sure.
Yeah. The other question I have have you considered another species besides red cedar for the buffering? I know red cedar. I've got red cedars that I'm actually taking out because they're dying underneath.
All right. I was at the Soil and Water Conservation District this morning.
Okay.
And we spoke to those guys, and they said, we want to critique everything you've got, and we're going to put in non-invasive species, and we're going to put in trees that are going to grow in our soil. They're like, can we put in little trees so they are more resilient? And I said, well, the neighbors kind of don't want to see it, so they got to be a little taller. So we are working with those guys. We're going to work with Niches, work with Purdue Ag. We talked to those folks already. They gave us some recommendations. And obviously, Stantec has done a great job in getting us started. So we're going to put in the right stuff that's going to last, and it won't look like that. And if it does, my buddy Davin, who just spoke, will tear it out and get the contractor to fix it.
And are there plans to monitor the trees that you do put in so that if one dies, they are replaced?
Yes, Devin Smith Operations. Yes, so we do a turnover plan with the vegetation contractor that's doing the installation. And then we also work with our vegetation contractor that's going to be providing the annual service for the actual inspections that we would perform and then any type of remediation that would occur afterwards.
I guess a question for staff. Is there anything in the application that says what species they have to use other than that it's evergreen?
Going back to the required buffer yard from the ordinance, there is no guidance as to what that buffer yard needs to be, but buffer yards in general do have evergreen requirements.
One of the things that I could add to that is we're actually working with a buffer right now, the project in Kentucky. And prior to the turnover phase, we actually experienced a lot of basically dying trees. And before we were able to take that over, we did warranty claims pre-turnover and then worked with the actual vendor to provide the turnover plan, which included them doing the proper watering to establish the roots. So definitely one of the things that we're looking into is making sure that the warranty is intact and to their compliance before we actually accept it and then continue it.
Thank you. Another question, dealing with the roads and the conditions of the roads. Is there any agreement with the county in order to make sure that the roads are kept in decent shape for those traveling, whether they be gravel or paved roads? Or has anybody talked to the county? Or is that something that is planned?
Hi, Wayne DeLong with GNX Solar, 525 South Meridian Street. Certainly, it's very common to enter into contractual agreements with the county commissioners related to road maintenance and moving things like that forward. Certainly, if there's agreements and structure that we can provide, we're happy to do that. We can certainly commit to that on the record.
Okay, thank you. Anyone have questions? Robert.
I have a question regarding wildlife and this project. I'm not so concerned about the endangered species. You guys are putting up a lot of fence if you're approved. Around here, we're really getting into problems with deer. You know, they're going everywhere. You're cutting off a lot of, travel space where these deer are going to go, where they typically run, their food sources. They're going to be confused along with fox and every other thing that goes around there. What are your experiences from other projects to where are we going to start having a lot more deer automobile collisions, or how does this go? Because you guys are fencing off a large amount of land.
Chad Martin. Can we go back to the full site where it shows the north? There we go. So we have two separate, very large areas, definitely. And that riparian forested area that's off to the southeast, for the most part, will not be impacted. And that's going to be a lot of your travel corridor. for a lot of your larger mammals or your mammals or animals that are going to move at night. 6-foot fence will not hold a deer, right? Deer can jump over a 6-foot fence. Using the game style type fencing, I think I even put in one of the reports that most mammals are going to be able to get through that, under that, except for maybe a coyote. Birds, raptors are going to be able to utilize that area as much or more. Diversity may even go up with birds, taking it away from a monoculture to a more natural savanna type prairie grassland.
Thank you. I think that deer could possibly get over a 6-foot fence. I'm not seeing that happen very often. I do think that that would be an obstacle for most deer. And like I said, I'm not saying that they couldn't jump over, but they're not going to go over that like it's nothing. That will end up being an obstacle for them.
Okay.
Anyone else have any questions? I know we received a lot of information, and a lot of it is not necessarily under our purview, as well, but we do have a decision to make. So we have a ballot.
All right, there were 7 ballots cast. There are 3 yes and 4 no.
A special exception has been denied. And we have any administrative matters?
Thank you, everybody, for being here tonight.
Yeah, I would like to thank everybody for listening and for the audience's civility. Unless any member has an objection, the chair will order the findings of each member casting a vote for the majority decision of the board to be the collective findings of the board in support of the decision of the board. Hearing none, it is so ordered. I'll take the last motion.
I move to adjourn.
We are adjourned.
So if any of you guys took handwritten notes for the solar pens, can you put your name at the top? We're going to keep it with your mouth.
My name's Emery. I'm with the Expo, and I was wondering if you had a second, just like a couple of quick questions. I don't want to hold you much
We
longer.
really can't comment on the case
Okay. No, that's okay.
now, so
Yeah.
yeah, if you want to talk to staff, you can. Yeah, thank you. Ah.